run over real quick, but before we do, I want to call your attention to right back here in front of this stand. I put a map up of the reservation. And the reason I put that up is to show everybody what in terms of ownership of land on the reservation today, how much land the tribe, individual Indians, and then white folks actually own within the reservation. So if you get a chance to look at this map, we're going to take a little break about halfway through. We're going to try to end about 8 or 8:15. The yellow on this map represents non-Indian fee land, land owned by white people. The white on the map is individual Indian land that each of us might own or own an ownership interest in. And then the green part is tribally owned land. So if you look at that map, the tribe only owns probably less than 20% of the land on the reservation as a tribe. Us as individual Indian people together, we own maybe 40 to 45%. And then white folks, that yellow, they own maybe 35 to 40% of the reservation. And that goes to that issue we talk about, jurisdiction and sovereignty. That goes to what we have really control over. So I wanted to bring that in for the folks that were here last week. We talked about that a bit, and I wanted to put that up so everybody would have a chance to see it. And as I said, we'll be taking a break about halfway through, and you can come up and take a closer look. Before we Okay, well, we're maybe by way of a little review, a couple of preliminary things first for those of you that didn't come last week, and just to remind ourselves what we're about, that we're here talking about constitutional reform. And when we talk about that, we want to be real clear up front that we're not talking about changing enrollment. We're just talking about how we change our government to make a better government. Second, we kind of agreed last week that we would follow a simple kind of approach that it's better to educate everybody first before we start trying to write a document or write what we think the changes will be. So what we're trying to do is just start by educating ourselves and each other so that when we're done, everybody here will be able to go out and have their own sessions and educate other people in the communities. And we actually had more folks here last night, and I want to recognize that we lost a member from the south side, the husband of one of our council members, Mr. Pat Calf Bossribs. So on his behalf and in his honor, I'm going to stop for just a moment, and we'll just have a short moment of silence in memory and honor of Pat and his family. And with that, I recognize that the funeral was today. We might have lost some people due to that. There were many folks out there last night for the rosaries. I didn't make it out, but I'm sure there were many there this afternoon. And so we're going to do this every Wednesday night starting at 6 o'clock. Got probably more than enough food tonight, so after tonight maybe we'll call around each other and decide who's going to bring anything so we don't end up with too much. But the next time you come, well, let's try to bring something else, another warm body to help educate people. And so that's what we'll start with that. Now, actually tonight we're going to start just a little bit differently. I want to thank Virgil Edwards for putting this together, and his son donated this projector to us to be able to use, and Virgil put together a PowerPoint. Now, before we go back to last week's PowerPoint, this week he put on the original 1935 Constitution. And I thought it would be interesting to look at that real quick. We're not going to go through it thoroughly, but just in comparison to some of the things we talked about last week. And for those of you who are computer people and understand all of that lingo, let's turn this off for just a second so we can show that. Our current, you can barely see those numbers up there. The 1935 Constitution is 31 kilobytes long. The current Constitution is 105 kilobytes. So we've almost tripled the length of our Constitution in that time, in 75 years or so that we've had it. It's gotten much longer. We've added to it. As we talked last time, most of the additions we've made to it have had to do with elections. Now, right here, he's got something that's real interesting because it's to me, a demonstration of how much the people before us, how much attention they paid compared to how much attention we, as a group of people, pay today, us modern Blackfeet. So right here in this little box, it has, back then there were 1,785 eligible voters. 1,785 people were eligible to vote on the Constitution. And of that amount, 994 voted in the election. So more than half of the tribal membership at that time voted in that election. And as we'll see when we get back to our own document, in our changes over the years, we've had a lot less than that. I think today in a current modern tribal election, we have in the last election about 3,200 voted in the tribal council election, and about in the primary, and about 3,100 voted in the general election. And today I think there's about 8,000 eligible voters. So just barely over a third of us even vote today and participate. So real quickly we'll go through that. The first article hasn't changed at all, and we talked about that last week, about how that's defined, that the jurisdiction of the tribe shall extend to the territory within the confines of the reservation boundaries as defined by the agreement of 1895. If we look at the agreement of 1895, that's the agreement that we had on the ceded strip, Glacier Park and the Badger 2 Medicine. And I went over that today with one of the young lawyers when we put this map up. If we look at that agreement, the only boundary that agreement defines is the western boundary. So if some smart lawyer from out there wanted to challenge us and ever got to looking at all of this stuff, they could go into court and say, gee, the Blackfeet in their own constitution didn't even reserve jurisdiction over their whole reservation. They just reserved it over their western boundary. You know, that place up there on the park line, it's about this wide. So they could make an argument that that's all we have jurisdiction over. So that's just one of the many reasons we need to move forward with change. Article 2 on membership, we talked last week that we've amended that twice. And the first, way back when, in the first one, it said all persons of Indian blood whose names appear on the official census of the roll of the tribe on January 31st, January 1st, 1935, and any children born to any blood member of the tribe maintaining illegal residence within the reservation. So as we know, we've amended that to include the blood quantum requirement. The next interesting one, going back to the original Constitution. Now today, as I said last week, anybody that runs for council knows that you got to win Browning. You better campaign hard in Browning. And if you win Browning, even if you're from Hart Butte or you're running from Seville or Old Agency, chances are you're going to get on the council. And the reason for that is that we have today what we call at-large voting, meaning that we in Browning, we get to vote for the Hart Butte representative, we get to vote for the Old Agency representative, and we get to vote for the Seville representative. And that's why the people in Browning, the greater Browning area, really control the outcome of any election. We got away from what we call representative government. We're going to have an election here in the state next week, and we got Indian people running to represent our district in the state. Only people in this district, it stretches all the way down to Flathead, but only people in this district get to vote for those representatives. So I think for the Senate we have Leanne Johnson and Leah Whitford. But only the people in that Senate district get to vote for them. All the people in Montana don't get to vote for them. And then we have a representative race. And the same is true there. Only the people in this district for representative get to vote. Everybody doesn't get to vote. But way back when we first adopted this Constitution, two things. It says the council shall consist of 13 members. So when we started this, we had 13 council people. And in fact, as we talked last week, the old people used to refer to the council as 13, as the 13. They didn't call them the tribal council, they called it the 13. And more importantly, it identifies the districts, Old Agency, Seville, Hart Butte, and Browning. Actually, they called it, if you notice that, they don't even call it the Browning district, they call it what? The Agency district. Etun UP, that was where our father lived. That was the agency here in Browning. And so then it goes on to say the voters of Old Agency shall elect 3 councilmen. The voters of Hart Butte shall elect 3 councilmen. The voters of Seville shall elect 3 councilmen. And the voters of the agency district shall elect 4 councilmen. So in other words, we had true representative government back there. The people from Hart Butte picked their own representatives. The people from Old Agency picked their own representatives. People from Seville picked their own representatives. And the people from Browning, they picked their representatives. Again, as we'll see going forward here in a minute, today Browning picks, we all vote for everybody. Hart Butte votes for Browning, Browning votes for Hart Butte, and so on. The next section is just on Article 3 is elections. And we're going to talk about our own Constitution here in a few minutes. But as we can see, there's only 7 sections. Looks like it might be no more than a page long. As we talked last week, of the 11 amendments we've made to our Constitution, the majority have been on elections and nominations. And so that today, our election rules are about 4 pages long. We've more than tripled that. We've made more amendments about election than any other thing that we deal with. So we've been more concerned about election than we have been about the power of the council and how our government actually functions. So the next section is Article 5, vacancies and removals, something we had a big fight over these past few years. So if we look there, that's only 2 sections long, just 3 sentences. If a council member shall die or resign, etc., the council shall elect to fill the unexpired term. And a council member may be expelled by 9 members or more. So remember, we had 13. So 9 members or more voting for expulsion. Before that vote is taken, a person shall be given an opportunity to answer the charges against him. Council's decision shall be final. Now notice what we're going to see here in a few minutes. There's no criteria. There's the thing that we're going to see today about engaging in conduct that reflects on the dignity of the tribe, or being drunk or missing meetings. None of that's included in this original document. The next one is really one of the most important section of the council of the Constitution, and that's the powers of the council. We have changed that slightly over the last few years, and one of the changes has been to section G right there, to select subordinate boards, etc. We've changed that to adopt the plan of operations. And section H, to regulate and license all businesses, exclude people from land owned by the tribe, community labor, and section 9, to promulgate ordinances for the safety and peace of the reservation residents, and to establish courts, etc. That's why we don't have what we call separation of powers. Separation of powers, again, like we talked and Fish explained last week, if we look to the state or the federal government, there's 3 branches of government. There's the executive branch, that's the president or the governor, and they administer the laws, administer the budget, but they don't get to make laws, they don't set the budget, and they don't have control over the courts. Then we have the legislature. Now the executive branch, they serve full time. Then we have the legislature. Now let's be honest, I think we'd all say that Congress has gotten kind of out of hand. They meet year round, we pay them about $120,000 a year, and gee, I think they've passed less laws in the past 8 or 9 years than ever before. They don't really, legislating is passing laws. The state, however, let's look at them as an example. We're going to elect the new state legislature. In January, they're going to meet. They serve for 90 days, and then they're done. During that time, I just looked it up, between their daily pay and their per diem, they get about $200 a day. But that's only for 90 days, and then they're done. We're not paying them to sit year-round. And so there's money saved in terms of the government, because you don't have a permanent legislature like we do with the U.S. Senate. And lastly, in the state, we have a separate judicial branch. And so across the state, there are people running for district court judge, justice of the peace, and the Montana Supreme Court. And that's a separate branch of the government. We elect those people. There's 2 Supreme Court races going on, and there's a number of districts. Now, we in our area, 4 years ago, we elected, or 2 years ago, we elected a district court judge. In 4 more years, he'll be up for election again. But they're not appointed by the council, they're not appointed by the legislature or the governor, unless there's a resignation. Then the governor gets to appoint somebody just to fill out that term. But the next time around, there's a new election. So that's how we have separation of powers. When we get to go through this whole thing about powers of the council, we'll see that there's no separation there. Either the council runs everything. Now we're going to come back to this when we talk, but under that section 2 it says manner of review. And written into our old constitutions that we still have today is the notion that the agent, the federal government, the Great White Father, still has the authority to approve or disapprove things that the council does. Not everything, but lots of things, as we'll see when we go through that. There is an important part there that I've talked about before to councils, and that's future power and reserve power. Future power. It says the Council of the Reservation may exercise such future power or further powers in the future may be delegated by the members of the tribe, the Secretary of Interior, or any duly authorized agency of the state or federal government. So to me, that's a concept that means the tribal council don't have all the power. If there's something that's not listed there, then the council don't really have the power to do it. But what we do today is we say, oh, we got all the power. We'll do anything we want. Then there's this next section that says reserve power. That's the only place that the people really are mentioned, but we ignore them. Any right or powers heretofore vested in the tribe, but not expressly referred to in this Constitution, shall not be abridged by this article, but may be exercised by the people of the reservation through the adoption of appropriate bylaws and constitutional amendments. In other words, the people are supposed to be able to give that power to the council. But I bet there's nobody in this room that can ever remember when the council said, oh wait, we don't think we got that power. We better go to the people and ask them if we can have it. We never have done that in my lifetime, and I bet up the lifetime of anybody in this room, have we? So the next article is land. Now that article really hasn't changed too much, and if you look at it, even back then it was the longest article of the Constitution, that we were most concerned with land. There was allotted land, tribal land, leasing of land, and then something that we don't have anymore, and that's called standard assignments. You know, in 1935 we just came out of the allotment era, and the Indian Reorganization Act was supposed to end allotment. Allotment was when we became individual owners of land. And so the idea was that, in my own opinion, was that the people wanted to be sure that those that didn't get allotments would still have access to individual pieces of land that they could use to make an income from. So we had this thing called standard assignments. Tenure of standard assignments, exchange, leasing, and inheritance of those assignments. Purchase of land by the tribe, and use of unassigned tribal land.
Joe, how did the standard assignment stop?
It was just stopped by declaration of the council. Back in about the 60s, the council just said, we're going to stop doing it. And then I think in the 70s, by Charlie Conley, lead of Charlie Conley, we even said that we're going to review every standard assignment. And one of the conditions of getting a standard assignment was you couldn't own any land of your own. By that time, most people had inherited land, even if it was just little tiny chunks. And so Charlie went through a process, and he reviewed every standard assignment. And if you had a standard assignment but you owned land, they gave you a notice of cancellation of that assignment. So today, there are no existing standard assignments. Those have all been converted. The other thing they allowed them to do was convert them to a lease. You could lease it, but it's not an outright standard assignment anymore. So even though it's in there, we've never abolished it, the council no longer honors it. And again, you'd have to come in and say, I have no land of my own, not even an heirship interest. And then you have to find available tribal land. So that's the other issue. As those of you that have been around know, every piece of that tribal ground, even on the mountain front, is leased up for some reason or another. The majority on the mountain front is in grazing leases. And so there might not be a timber lease or commercial lease, but the majority of the mountain front, the tribal land, are in grazing units, and it's leased for grazing purposes. So let's go on. We'll come back to a lot of that stuff down the road. The next thing is our Bill of Rights. And we talked about now, important change there that's a more modern change is back then, and it increased the pool of eligible voters. You had to be 21 to vote. Today the voting age is 18. And so that was a change that allowed more people to vote and recognized it was related to you only got to be 18 to go to the army and to fight for your country. And so a lot of people felt that it was appropriate, I guess, to lower that age limit to 18. We had economic rights, civil liberties, and the rights of the accused. That's something that comes up a lot, even today, just today. I had a person come in about that. And so we've changed that. So right at the bottom it says, excessive bail shall not be required and cruel punishment not imposed. So what is excessive bail? If you've got no money and you've committed a minor offense, but the court says, oh no, I'm going to require a bail of $2,000 in cash. Anybody here be able to put up $2,000 in cash right now? So that's probably excessive bail under the Constitution. And it probably should, the court should look at that and be able to follow it. So the next things were referendum and amendment. We haven't changed those over the years. Now an important thing that related to what we're doing today is we've talked about that while it may not be the mandate for trying to change the Constitution right now, it was certainly an important thing that we voted on. And that was the referendum of 2008. So the last part of that sentence says that the outcome of the referendum shall be conclusive and binding on the tribal council. Council didn't allow it to be conclusive and binding, did it? At some point, the council said, we're going to vote to end your effort. We're going to rescind the resolution. Constitutional Reform Committee, you don't exist anymore. But so we've started this saying, we don't need their sanction. We'll go forward, and when we get a document, we'll come in and we'll present it to them. And if they don't vote to put it to a vote, then when election time comes, we'll start voting those people out and put people in who will allow us to vote on that document. So the last thing is what we're doing here is the actual vote that will be on a constitutional amendment or a new constitution. And that says the Constitution and bylaws may be amended by a majority vote of the qualified voters of the tribe, voting at an election called for that purpose by the Secretary of Interior, provided that at least 30% of those entitled to vote shall vote in the election. So first, when we have this amendment, our new Constitution, 30% of the eligible voters of the tribe have to vote. So if 3,000 voters is not more than 30%, we got to turn out more people than that. And if we don't turn out more than that, even if we vote in favor of it, it won't pass. So 30% of us got to turn out to vote. And of that 30%, no amendment shall become effective until approved by the Secretary of Interior. It will be the duty of the Secretary of Interior to call an election upon a proposed amendment at the request of 2/3 of the council or a petition signed by 1/3. Now, let's recognize that 1/3 is 33 1/3%, not 30%. So 1/3 is actually more than 30%, or 2/3 of the council. So the council, there's 9 of us. If 6 council members voted to have a referendum and amendment election, that's all it takes for it to happen. We don't have to have unanimous consent of the council. We just have to have 6 people on the council who are willing to put whatever we come up with to a vote. And then once we do that, at least 30% of the people have to vote in that election. Now I'm going to end there, and I guess we'll just look real quickly. The bylaws haven't changed, except to the best of my knowledge, except for polling places. Judges and clerks have remained the same. Meetings have remained the same. except that we changed that. It's no longer Community Hall in Browning. It's at the reservation headquarters in Browning. The duties of the officers, that's an interesting thing we'll talk about as we go on, because that's what helped create this conflict, this mess that we just went through. And again, this is the original Constitution. So that was the original Constitution. It's about a third, about as third as long as the Constitution that we have today. Oh yeah. Oh, we still got to close that somehow. Remember, we looked at 900 and some of our people voted in that election, 908, 90 some. Of that amount, 884 voted for and 157 voted against. So the vote for the Constitution was overwhelming back then. And remember, we did that under something called the Indian Reorganization Act. Those of you who have elders that you've spoken to, they used to refer to that act as the Wheeler-Howard Act, the Wheeler-Howard Act. Those were the two senators who introduced it in the United States Constitution. And as we talked last week, there were some promises made to Indians to get them to do that. But as I told the group, in my own research, I found that really there was competing promises. Mr. Wheeler, in introducing the act, his goal was really to bring about an end to Indian governments, to do what I called make us like them, that policy called assimilation. Let's make those Indians like us, and then they'll be good people, and we can eventually absorb them into the mainstream of our government and our society. The Indian people, they didn't understand that. The promise to them was right here. Here was the promises made to Indian people. First, self-rule. The tribal council is going to be in control of all affairs of the tribe, among other things. So, gee, we're giving you folks the right to do anything you want to yourselves, to control your territory. Second, there was the old revolving credit fund. And those of you old enough to remember know that back when we had tribal credit, when the Bureau first had it, and up until 1996, we had the revolving credit fund. That was a fund that the government put up. We borrowed money from that fund, and then we paid that money back, and we could borrow more. We used that money primarily for ranching and farming, but you could borrow loans for other purposes. So the promise there, and again the goal there of the white people, was, oh, we'll make them Indians into good farmers and ranchers and business people, and again they'll be like us then. They'll look like us. So the last carrot there was no more loss of land. Now, it said many allotments were lost to outside interests starting in 1907. So we actually had two allotment acts, the Blackfeet. We had the 1906 Allotment Act, and the main feature of that one was if you got land under that, you got the minerals too. That's why some of us still get mineral leases and mineral money from those leases. But the second Allotment Act that we had was in 1919. And if you got allotted under that act, you didn't get the minerals. The minerals were reserved to the tribe. That's why, for those of you who don't know, some of us get those mineral leases and we get income from that. And other people who got allotments, maybe were handed down just in their family, they don't get anything because their allotment came under the 1919 Allotment Act. Now, allotment was when the government said, that's how we ended up with this map back here that looks the way it does. The government said, we're going to take the reservation, and you, Darryl, you can come in and all your family, and you can pick out 400 acres. You can pick out 360 here and 40 someplace else. And that got divided up. People allotted in 10-acre tracts and 40-acre tracts. Some families got allotments together. Other families, they were spread plumb out. I owned inherited part of an allotment way up in the northeast corner of the reservation that still had the minerals with it. But today there's about 190 of us on that allotment, that one little 40-acre tract up there through inheritance. But then the other part of allotment was the right. Now, allotment was we got that land, but it wasn't ours outright. It still said in trust for Joe McKay, or in trust for Darrell, or in trust for Mary, or whoever, in the name of the federal government. But we got the use rights. What they allowed us to do from 1906 until 1934 or 35 was to get fee patents on it, or to mortgage our allotments. And so that's how people lost their allotments, lost their land. That's why we have all that yellow land on that map back there, is that we were allowed to mortgage them, sell them outright, and a lot of people did that, needing the money and not realizing what was going to happen. Other people mortgaged it to the business people, not understanding what was going to happen. And when they didn't pay their grocery bill, the grocery man went to the government and said, "Oh, Joe owes me $500 on his grocery bill, and he signed his land over to me for it. I want to foreclose on that land. I want it given to me in fee status." So those were called forced fee patents. And so that's how, during that time, that we lost that land. Now there's a reference up there to something called the Dawes Act. It's really the Act of 1887, not 97. And the reason that's important to us today is that that act was the legal basis for all allotments all across America. And one of the key provisions of that act said that when you got a patent and fee on your allotment, it becomes subject to state taxes. And so today, that's why people that own fee land, even us Indians that own fee land, it's subject to state taxes. And that's why you can periodically look in the Glacier Reporter or the Cutbank Pioneer Press, and you see in that legal section, tax deed sale. And they list all of these lands on the reservation. Those are Indian fee lands, land that we as Indians, somebody owns outright in fee, but they didn't pay the taxes on. They might not understand they owe the taxes, or they might not have the money to pay it. And so the state, the county sells that land. There are white people from all over. There's one guy I remember from California who just watches papers like that. And when he sees those tax deed sales, he puts a bid on them. And he buys that land, and it becomes his land outright. And so Indians continue to lose their land in that way. So that's why that act is important, because it's the basis to allow the state to tax our Indian fee land. Now, as long as our land is still held in trust, the state doesn't have any right to tax it or do anything to it. So that's kind of what brings us up to where we are today. So our present Constitution still provides for oversight by the Secretary of Interior. It says the approval of the Secretary is required in many actions of the Tribal Council. The Secretary of Interior appears 26 times in our current Constitution. So once again, that notion that the Great White Father has to watch over his children is still there, even though this is 2014, almost 100 years after we adopted that. Gee, we have computers, we can flash them up on the screen, we have satellites and all kinds of things, but we as Indians are still viewed as needing the supervision of the Great White Father to look over us, make sure we don't do nothing wrong. Since the early Blackfeet Tribal Business Council was unable to obtain funds for economic opportunities without BIA consent. That's still true today. if the tribe wants to borrow money, of course a bank, anybody that's borrowed money, even a car, when you borrow that money for that car, the bank says two things. How are you going to repay me? What's your income? And I want a collateral. I want something to secure my loan. So they take a security interest in your car. Well, when the tribe goes to borrow money, they say, well, how are you going to secure that? We want an interest in your trust income. We want you to pledge your trust income. And so in order to do that, the BIA has to consent to that action. Or let's say, like when they buy the Smith Ranch, it's in trust already. The lender, they say, well, we want a security interest in that land. Because it's trust land, the BIA has to approve that. So we still have to do that today. Well into the 1940s, allotments were continued to be lost by forced fee patent. And most importantly, the present Constitution does not provide for a separation of powers. All the power is centralized in a council, leaving the people with no recourse other than election. So in other words, if the council does whatever they want, the only time we can change that is when we have a council election. Then we can elect different people. But something happens when people get on the council. And I don't mean to criticize them, but in my own opinion, that's why we don't see 7 or 8 other council members here tonight. Some, let's be honest, not on this particular night. We've had tragedies and some people are ill. But generally speaking, once you get there, you get on that council, you sit at that table, and you realize how much power you got, you don't want to give it up. What? Have a referendum, change the Constitution, end my term? I don't want to do that. Gee, wait till my term's up. Then you can do that. And so that's why it's been so hard for us to make those kinds of changes. The council is reluctant to give up its own power once they realize the power that they have. And because we have no separation of powers, in other words, no checks and balances, no one can, you can't go to court today and say, the council is abusing this part of its power. I want an order against them saying that they can't do that. A few years back in a case involving Pat Schelt, when Pat Schelt was removed from the council, he went to court. And our Court of Appeals said, oh gee, if it's within the council's power under the Constitution, we got no jurisdiction over it. We can't review that. And in other words, the council can do anything it wants as long as they can point to something under the Constitution. Court's not going to review that. They say they have no jurisdiction. So there's no checks and balances. There's no way to hold the council itself accountable for what it does or doesn't do. So that's a quick review of where we were up until this point last time. Then we talked already about our territory and what it's limited to. And it says it's defined by the Agreement of 1895. As I said, that's the ceded strip. The ceded strip is the whole thing from Glacier Park down to Lewis and Clark National Forest, the Badger 2 Medicine. That whole strip is the ceded strip. The next thing was membership. And as we saw from the original document, we amended that to include a quarter degree of Indian blood. Now the other thing we did talk about is that Section 2. It says the council shall have the power to promulgate ordinances subject to review by the Secretary of Interior governing future membership and the adoption of new members. And as I pointed out last time, you can read that to mean that if the council met tomorrow and it wanted to, it could pass a resolution saying we're changing the membership. We don't have to have a referendum vote. We're going to do it right now. And so you just need to be aware that that's among the reasons that we need to change this document, to put in some checks and balances, to make sure that the council can't exercise power without the people's, some form of control, whether it be by our legislature or not. Now the governing body, we looked at the old Constitution. The main changes that we see there are the council is now 9 members, and as I pointed out, notice that we changed the agency district to the Browning district, but we still have the other one. Now here's the other big change. The election of all council members shall be submitted to the entire electorate of the reservation. That's what took away that community representation. That's why we have at-large voting. It goes on to say it sets up the residency requirement, right? That now you have to be a resident of the reservation for a year, and you have to reside in your district for at least 6 months prior to the time that you become a candidate. So those are the changes, the amendments that we made to the first 2 sections. Now the other thing that was in the last one that's still here is it says that in lieu of districts, the council shall have the power to establish communities and the basis of representation on the tribal council from such communities subject to popular vote. So again, the council could pass a resolution tomorrow. So we want to go back to representative districts. Only people from Heart Butte vote for them. Only people from Old Agency, only people from Seville vote for each other. And if they did, the people would still have to vote on that change. Go ahead.
I'm talking about see, when you guys get elected to get in the council, you have no right saying, we have the power to do this and we have the power to do that. You must remember who got you in there. And each and every one of you are in there for the people, not for yourself and not for this group or this group. Because they want open enrollment or they want something done about what they want.
Well,
this is for the people. Blood, full blood.
So
I got all the money in here. Yeah.
So,
if it hadn't been for them, you guys would have nothing. Yeah.
Again, what she's saying and what we've decided to do, because we're recording this, is that her concern is that the council people, when they get here, just do what they want to do. And my response to that is, that's why we need to change this. As you're going to see when we get the powers of the council has the power to do all of those things. And yes, I agree with you. Council people as representatives should be concerned about what they vote, what they campaigned on, and who elected them. But like I told you, the truth is, when council people, I don't care who they are, when they get there, they realize we got the power. And so we're going to come to that here in a minute about what the council does when we talk about removal here in the next section. But so right now, you're talking about, we're saying the council could pass it, because it says right there, the council has the power to do this. That's not me saying that. That's the Constitution that we all live under. It says right here, the council shall have the power to establish communities and the basis of representation from the council.
Listen to what you're saying, and that you guys can just go do what you feel like wanting to do. Now that's not what you're supposed to be doing. You guys gotta look out for the people, not for yourself.
Well, that's why we had this.
Up there, if you had any sense, or any one of you, you guys would be doing something with other tribes and fighting the government on abuse, everything what they done to our ancestors. Right today, we won't have to pay nothing.
Well, again, that's why we need to change this document, because that's what it allows the council to do. So let's talk about what the powers of the council are, because that's one of the reasons we had the conflict. It says the tribal council shall elect from its membership a chairman and vice chairman. So the chairman that we elect, they're not the chairman of the tribe, they're the chairman of the council. Then it says the council shall elect from within or outside its own membership a secretary and a sergeant at arms and other officers and committees as deemed necessary. So once again, in response to your point, that's why we have to do this. because this is the document that we run under. And in response to what you said, about 3 months ago, everybody there, except the ones that were already there, they swore an oath to uphold this document. So this is the document that gives them the power to do just what you're talking about. So if you don't want them to have that power, that's why you need to change this document. We can't change it ourselves. So there's a way to change it.
Can say that they can do these things and they can make them the way they want them to be. The government can do what they want, and this is what they're doing, and they're making you guys think differently. Now you guys got to be smart.
Well, no, you know, I'm a person who's known for thinking for themselves. So the government doesn't tell me how to think. That's why we're going through this document, and we're looking at what's wrong with it so that we can change it to make sure that those things don't happen. So this is our section on elections and nominations. We all know how we elect people. We amended that this last time to go to 4-year staggered terms. Now, the council didn't do that. The people did that. But as we talked about last time, the government, because it runs amendment elections, they made everybody register to vote. And of the people that registered to vote this last time, just a little over 900 actually voted on going to 4-year staggered terms. And of those 900, about little under 600 voted in favor of it. And of those 600, 300 came from off the reservation. So if you don't like what's going on here, then you have to get involved, and when the time comes, you have to register and vote. And that's why we have these staggered terms that we have today, because the off-reservation people gave them to us. The people on the reservation didn't vote for 4-year staggered terms, and compared to the people that voted against it, we would have killed it. And if the people on the reservation, the off-reservation people is who registered to make that election legal. So that's how we do that. And this just tells us that we're going to serve our 4-year staggered terms, and we're going to have an election every 2 years. The 2 candidates with the largest number of votes advance, and we have a general election. It tells us when we start doing that. The other thing that we came to that we had dispute with the Bureau about says all elections shall be by secret ballot. Any member of the tribe 18 years of age or older eligible to vote when they presents themselves can do that. Goes on to say Section 7, all elections shall be held in accordance with rules and regulations laid down by the council or by an election board appointed by the council. Now, is there anything after that language that says, provided, however, that the Bureau of Indian Affairs has to approve the selection of the election board? There isn't, is there? So in this last election, when our agency superintendent took the position that the election board had to be approved by them, she was wrong. That's not in our Constitution. It's not one of the things that is subject to BIA approval anymore. But they took the position that it was. So then the next section that we have is vacancies and removal. Now remember when we looked at our first Constitution, it just had that Section 1. If a council member shall die, etc., then the council will elect a person to fill the unexpired term. That person has to be a resident of that district. Then we added these 2 sections. Well, actually, there's 3 sections. And then we're going to talk about why we need to change the Constitution. Section 2, the tribal council can expel a member for cause by 2/3 or more of the members of the council voting for expulsion. Before any vote is taken on such matters, the members shall be given an opportunity to answer any charges at a designated council meeting, and a decision of the council shall be final. Any member of the council convicted of a felony in court or for which they haven't received a pardon or restoration of their civil rights shall be ineligible to hold council office, and any tribal member officer found guilty of the council of gross neglect of duty, misconduct reflecting on the dignity of the tribe or the tribal council, habitual drunkenness, or repeated absences from functions shall be expelled and shall be barred from holding office. Now let's be real honest. The last 2 years, that all started right after in September of 2012. And in September of 2012, 4 members of the council voted to expel 5 members of the council. And that's when this all started. So if that's the law, then how could 4 members of the council vote to expel any other member of the council? They couldn't. And then once again, but they couldn't go to court because the court had said, oh, that's in the power of the council, so we can't review it. And so there was no checks and balances left to do that. So the other 5 members, or 4 of them, retaliated by suspending the 4 members who had done that. Now let's stop right there. Does anybody see the word suspension in there anywhere? It doesn't say that. But once again, the court said, oh, those are in the power of the council, so we got no authority to act on it. So there was no checks and balances. There was no place to go to say, that group is not doing right. You tell them what to do right, and you uphold the law. Because the court said, we got no power over the council. So one of the things in the 2008 referendum, and I just looked at that before I came over here, was separation of powers. And that's what that means.
They fired Dawn from the being chief judge because she wouldn't do what they wanted them to do. So they just fired her and put in a yes person.
Well, that goes back to there's no separation of powers. That's just what I said.
The court says they can't do nothing.
So
Dawn was trying to do
it said right here, as we looked at, and we'll jump ahead to it, but we're going to come back to that later. Says the council has the power to promulgate ordinances for the purposes of safeguarding the peace and safety of the residents of the reservation, and to establish courts for the adjudication of claims amongst members, and for offenses and trial and punishment of members charged with offenses. Doesn't say anything there about a separate court. That's why the council can do that. And let's be real honest, she wasn't the first judge to have that happen to her. Many judges over the years have been subject to that because the council said, we don't like what you're doing. You're voting, you're acting against us. You won't release my cousin from jail. And so I'm gonna bring that to the council and we're gonna remove you. So how do you stop that? You stop it by having a separation of powers. Now here's another thing, going back to a council about, actually it was the council that Pat Schelt sat on before they removed him. The people in when they adopted this in 1998, that amendment, they put in this provision. Upon a petition of the tribal council to the tribal council by at least 20% of the total eligible voters of the tribe, a recall election shall be held within 30 days of submitting petition to the council to determine whether the council shall be recalled and removed from office. The vote of majority of the qualified voters in a recall election shall be conclusive and binding. If the majority of the voters in a vote to recall a member, the member shall be recalled and removed from office, and upon certification of the vote by the election board, The certification of the recall shall occur within 72 hours. If a majority of the voters voting in that recall election vote not to recall, the council members shall continue to remain in office and perform the duties and responsibilities of a member of the council. Well, I recall in 2006, a group of people came in and presented a petition to the council members that were in office at that time. And they asserted that that petition represented 20% or more of the eligible voters of the tribe. And they said, we want to recall the whole council, period. And so let's stop right there. Now, does that provision say when that petition is presented that the election board shall review it and determine whether it's accurate, and if it is, then they'll call a vote? Doesn't say that, does it? It says the tribal council shall do that. Doesn't say the BIA shall review that, and if they determine that 20% of the voters signed, they'll make the council have an election, or they'll call an election. It says the council shall do that. So if you're worried about the power of the council, then change the Constitution. Because here's what the council did with that petition. They took it and they went over to a trash can and they threw it in the trash. And that's as far as it went. There was never a vote on that petition. Now there was a lady just this past time, Anna Bulsha, spent a lot of time. Remember, you saw her parked down there on the street gathering signatures to try to get to 20% of the eligible voters to have a recall election of the whole last council, every one of them. Did that happen? It didn't. Why didn't it happen? Because the council is responsible for doing that. It doesn't say that that petition shall be presented to the election board, and the election board shall have the power to call it. It doesn't say that it'll be presented to the court, and if the court finds that 20% are met, the court can call an election. It does not say that it can be presented to the BIA, and if the BIA says, yep, there's 20%, they can call an election. It says the council should do those things. And if the council don't want to do those things, it won't. And the bottom line is, because there's no separation of powers, then the people can't do anything either. So that's our election process and the removal from office. Now, we agreed last time that everybody needs to take a break and go to the bathroom periodically. So before we start on the next section, the most important section of our Constitution, called Power of the Council, before we start on that, we're going to take a short break. If you need to go to the bathroom or get a drink or any of those things, time to do it. Until almost after 9. That we try to be done by 8 o'clock because everybody has things to do and get on with their evening.
But I was out partying.
So before I start, I want to again remind you all that, to the best of my knowledge, none of us in this room wrote this Constitution. This isn't something that Joe came up with, or George came up with, or Cheryl came up with. This was something that these people on this wall behind you, this is what they came up with. And this is the document that they gave us. And so while it might have worked 40 years or 50 years or 60 years ago, it doesn't work today. And that's the whole reason that we're doing all of this. And so Article 6 of the Constitution, that's really where the most trouble comes from. And because it starts with power of the council. Doesn't say powers of the people.
Last time too, you said that the Bureau or whoever it was picked out the first council.
So yeah, let's back up just a little bit. Prior to the time that we had our current Constitution in 1935, when the government first came here and established the agency, we had our own system. We had clans and we had societies and we had different kinds of leaders. We had war leaders and political leaders and spiritual leaders, and that was how we regulated ourselves as a people prior to the time that we had civilization. That's why the first Browning district wasn't called Browning, it was called Agency, because this is where the agency was. And the old people still in a way had their own system. But the government, their goal was always to control us as people. And through many different policies, the main one being assimilation. Now they called it assimilation, acculturation, even termination. But the ultimate goal of the government was for us as Indians to become like them, to become brown-skinned white people and act like them. And so they did these things to us. One of the things they did was way back when the agent, the Indian agent, he'd want the tribe to do something. And if he couldn't get the regular leaders to agree to be Indian country forever. But as more and more white people, the population grew, they wanted more of our land. They wanted to take from what the Indians had. So the Indian agent of the Cherokee, he went to them and said, well, we want to buy some more of your land. And the regular Cherokee leaders, they had their own traditional government. They did elect people, and they did have a government. The government, the Cherokee government, said, no, we don't want to sell any land. So the agent secretly handpicked a new council of the Cherokees. And through that new council, without any knowledge of the rest of the people, they signed a treaty giving up a big chunk of their land. And that's how and why the Indian agents in the federal government, that was their policy of how to control us, was to handpick who the leaders were going to be, so that them leaders would do what they wanted to do. And that's the best example I can think of, but there are many like it. Going back to that Allotment Act, between 1887 and 1935, millions, literally millions of acres of Indian land all over America were lost to the federal government. When I was waiting for people to come tonight, there's a map out there in the hall right next to the documents office, or right next to the enrollment office. And it shows Indian country over the years. Big dark spots, smaller dark spots, and then finally today, just these little tiny blotches around America that are today's Indian reservations. That's how they took our land, by hand-picking councils. So why do we have, even today, instead of saying the tribal legislature or the governor or whatever, why doesn't our Constitution say that? That's because in 1935, when they passed the Indian Reorganization Act, and they said, all right, we're going to give those tribes, as though we didn't already have our own, we're going to give them a government. We're going to let them pick their own form of government. Oh, but it has to be a constitution government. So there were some really bright young lawyers, all white guys. One of them became known as the father of federal Indian law, strong advocate for Indian people. And if we still followed what he preached back then, we wouldn't have a lot of the issues we have today in terms of jurisdiction and control. That man's name was Felix Cohen. And in the late 40s and early 50s, he actually became a lawyer for the Blackfeet people. However, back in 1935, he was just a young lawyer, young, brilliant guy, but a young lawyer. And the Congress got ready to adopt the Indian Reorganization Act. And the Commissioner of Indian Affairs, his name was John Collier. And he was a person who believed this was going to be good for Indians. So he went to his young lawyers and he said, well, we need some kinds of forms of government to put out to the Indian people. And so them bright young lawyers looked around themselves and looked around America at Indian country, and what did they see? They didn't see the traditional government that existed in the 1870s or even 1880s. What they saw was the tribal council system of government that the BIA had created. And they looked around, they didn't think beyond that. And they said, oh gee, I know, let's have tribal councils, because that's how they govern themselves. Well, that wasn't our historic way of governing ourselves. That was the way they had given us over that period of time. And so when they drafted these constitutions, now, again, for those of you that don't know, that first constitution that we looked at, our people only made minor changes to that before they adopted it. It was otherwise what we call a boilerplate document, meaning that it was something those young lawyers just circulated through Indian country. Here's some things to look at. Do this. And only the tribes either adopted one of those, or there was about maybe 100 tribes who did what we call opt out. They didn't adopt anything. And they chose not to have constitutional governments. The Crow was one of them. The Crow didn't adopt their constitution till about 15 years ago. Until then, they had a traditional government. And gee, as a young boy, I forgot about this. My family moved to Billings for about 4 months in 1964. 63, fall of 63. My dad worked for the BIA in housing, and he had to go to a council meeting down at Crow. And he said, we're going down to Crow Agency tonight. They're having a council meeting. And I didn't say nothing, but I thought to myself, gee, a council meeting at night? So we get down there and we go to this gym, big gymnasium. All the Crows were there, the whole reservation. Everybody that wanted to show up, they were there. And the leadership got up on this platform, and they would present resolutions. And after they got done presenting it, they would call for a vote. And they had these little voting booths set up right there on the gym floor. And because the whole tribe was the council, they came forward and voted. And that's how they voted on things. The whole reservation had a chance to show up and vote. We were there till about 11 o'clock at night. They only voted on about 3 issues. But it took that long for them all to go through those little voting booths and say yay or nay to whatever the issue was. That was the Crows' original form, or a version of their original form of government. So today, even the Crows have adopted a constitution, but one they wrote themselves, not one that they copied like this. They wrote their own, and now they act under their own form of government. So, having said that, let's go on and cover just a few. We'll try to get down to the charter, anyway, of council power. So it says the council of the reservation shall exercise the following power, subject to any limitation embodied in the statutes of or Constitution of the United States, and subject to further to all express restrictions upon those powers contained in this Constitution and bylaw. In other words, the council's power is not supposed to be absolute. It's supposed to be limited by 3 things: statutes of the United States, the Constitution of the United States, and our own Constitution right here. George asked me at the break, he said, now, it says in here that none of these can supersede the power of the council. Actions of the council can't supersede these things. And he was mentioning that standard assignment provision in section 7. So he's right. As I said, Our Constitution still has something called standard assignments. And in theory, you should still be able to come in and say, there's a piece of tribal ground. Soon as that lease is up, I want an assignment of that ground to me. No lease money, no nothing like that. Just my right to use it for my life, period. But the council don't allow that. And again, as I've been saying, that's why we need to change this, to make sure that if we're going to have things, the council has to follow them. Now here's one that creates a lot of concern right now in the context of water rights, right? And actually I was just watching tonight, before I came over on PBS, a hearing in the state on the Flathead Water Compact, and the white people were attacking it. But it says right here that the council shall have the power to negotiate with federal, state, and local government on behalf of the tribe and advise and consult with representatives of the Department of Interior on all activities of the department that may affect the tribe. That's why the council has the power to negotiate a water rights settlement. Now, under our current bill, though, let's be real clear. The bill that's being presented to Congress says that while the council can negotiate this settlement, the people have to vote on it to make it final. That's not in this document. That's going to be in the law if Congress approves it. So the Congress is going to give the people the right to approve that, but if we just looked at our own document, the council has the right to negotiate that, has the power to do that. Now, things we do just kind of every day. We negotiate 638 contracts. We negotiate with them about leasing agreements and those things. So there are things we do kind of on a daily basis that fall under that are not so threatening to everybody, but we do them every day. Section B, the council has the power to employ legal counsel for protection and advancement of the rights of the tribe and its members. The choice of the council and fixing of fees to be approved by the Secretary of Interior. In other words, they gave us the power to hire our own lawyers, but they said we got to approve them. See, if we don't like Joe being your lawyer, we're not going to approve him. You might get someone that's too aggressive or something, and we're not going to approve him. And we can even decide what their fees are that you're going to pay them. That's in our current document right now. So again, going back to that thing at the heading of this, do we really have self-rule? If they can do all that, if they can tell us, no, you can't hire Joe, or you can't hire Puggy, or you can't hire whoever as your lawyer. We don't like them. We don't even have to give a reason. Just we're not going to approve that. Number C, the council has the power to prevent the sale, disposition, lease, or encumbrance of tribal land or interest in land or other assets without the consent of the tribe. So in other words, the Bureau can't go out and put our land up for lease. Only the council can do that. The Bureau can't say, oh, well, you guys aren't using these things. We're just going to sell them for you. They can't do that. The tribe can stop them from doing that.
On that one there, what about the last 5 words there?
Without the consent of the tribe. So that's interesting, Puggy. What exactly does that mean? Does that mean that the council consent has to be given? Or does that mean that referendum vote has to be taken?
I think it means, when you're speaking of tribe, we're talking about the people. The council is the council. I think a lot of people confuse that. They say the tribe. This is not the tribe sitting up here, these 9 people. That's the council. We are the tribe. So I think that means that was intended to mean without the consent of the people. You can't sell land, or you can't lease or encumber tribal funds. Our councils continually over the years have encumbered tribal funds without the consent of the people.
So I was just going to say, if you were to put that question to the council today, and you say, does that mean the tribe or the council, what do you think their answer is going to be?
themselves.
That's right. So once again, going back to the folks that were asking the questions, that's why we're here, because we need to change our document to make that clear. And I absolutely agree. If it says without the permission of the council, that's pretty clear, right? But it says without the consent of the tribe. So arguably that means that the tribe is supposed to have a right to vote on those things under a referendum kind of approach. And really, we take that a step further, because that's not under referendum, arguably there doesn't have to be a 30% requirement. It's just you set up a poll, you have a vote, the outcome wins, whether there's 10 people or 1,000 people or 10,000 people. If they're all registered members and they vote, whoever outcome of the vote, they win. But again, over the years, like I've said, and it's not just this group, it's not just the last group, it's over the years, that has become, well, the tribe, that's us, we're the council, we speak for the tribe. And so that's why, ultimately, the tribal council takes that on themselves.
No, Joe, I've always been concerned and it has diminished over the last 20 years, I'll say, the legal branch of our government, our legal department. It seems like they would be advising the council. When you do this, here is the provision in the Constitution that you must follow. Or look at this before you do that. I think we had that at one time. And as we were talking earlier, prior to the self-determination policy that we have now, there was actually a representative from the Bureau that was sitting in council meetings called the, advocate, or whatever it was, for the
Liaison, the tribal operations officer was what he was called.
And they kind of sat there, kind of watched out for the people's interest in this manner. We've exited that type of oversight. And now we have a legal department that I would assume should be talking about this. So I was really dismayed over this last years of seeing our legal people watch these actions happen that in violation of our Constitution, our bylaws.
Well, did y'all hear him? He's saying that over the years, our legal department over here, that in the past, in years past, would sit in every meeting. And if the council was doing something that appeared to be unconstitutional, they'd say, well, wait now, you might not have the power to do that. And then the Bureau of Indian Affairs, the last one whose name comes to mind, and I'm sure there were many others, was old Dick Helfenstein. Remember Dick Helfenstein, those of you old enough to remember? He was the tribal operations officer back under Mike Fairbanks. And if it wasn't Dick himself, Mike Fairbanks would sit in a meeting. And if the council was doing something that they didn't think was consistent with the Constitution, they'd get up and say, well, wait now, Mr. Chairman, this is what your Constitution says, and we might have to review that or approve it, so you better think about that. And so Puggy was saying that he was concerned, dismayed, that in these last 2 years, when it seemed like the Constitution, and it was, being violated, that the legal department seemed to take a walk. So what I would tell you, Puggy, and I guess maybe I have a little more information than you, is that there were some members of the legal department who really were telling the council, wait now, you can't do that. However, there were others who were saying, oh yeah, you can do that. And that goes back to the Pat Schelt time, when they removed Pat Schelt. Remember that it takes 6 people to vote to expel somebody. When they voted to expel Pat Schelt, the vote was 5-3. They didn't allow Pat to vote. 5 is not 2/3 of 9. However, one of the lawyers went back and said, well, gee, wait now. 5 is 2/3 of 8. It's at least a working 2/3. And the council, the executive committee, 3 of them, said, you're right, but let's just stop for a second and do the math. 5 is not even 2/3 of 8. And so that was even wrong. But going back to the abuse of power, 3 members of the executive committee said, oh yeah, you're right, we agree with that, it's at least a working 2/3, and so, yeah, Schultz, you're done, we vote to expel you, you're done. And so here's the other part about that. Now let's take a comparison. The state government and the federal government, they have official lawyers that are called the attorneys general. And those lawyers are charged with the responsibility of telling government, the president, the governor, this is illegal, you can't do it. And they have the authority to bring an independent action in a separate court to stop that. So again, we could build that into a new constitution. We can say whether by election, now the state attorney general, they're elected, but the federal attorney general, they're appointed by the president, but they still have the same authority. Why do you think Bill Clinton almost got removed from office? Why did Richard Nixon get pushed out of office? Because at some point, someone the Attorney General appointed, even though Bill Clinton's Attorney General was appointed by him, he went to Congress and said, I think we need a special prosecutor appointed to investigate because I've been potentially in conflict. And so Congress appointed a special prosecutor, and they investigated Bill and Hillary Clinton and brought charges against a bunch of people, and eventually provided the basis for Congress for a bill of impeachment against Clinton. Now that lost, but that's how it worked. Back in Tricky Dick Nixon's era, they pursued that, and when it was clear the votes were there to impeach him, he resigned. But so changing that so that the legal department is not just some arm of the tribal council, it's actually an arm of the government with the independent authority to not just represent the council, but represent the tribe. When that thing with Pat Schultz was going on, the council brought in an attorney, not a non-tribal member. I won't say who it is, but it's a good example of what you're talking about. And Pat, he filed a complaint against that attorney with something called the Montana Commission on Practice for Lawyers, the group that regulates lawyers in Montana. And Pat came and showed me the letter. That's why I knew what it said. The Commission on Practice wrote that attorney a letter, and they asked that attorney one simple question. They said, here's our question to you. Is your client the tribal council, or is your client the tribe? That goes to exactly what you're talking about, isn't it? If your client's the tribal council, then you basically do whatever the council wants. But if your client's the tribe, then you have a duty, an independent duty as a lawyer to say, wait now, the council wants to do this, but it's against their constitution, might even violate some federal law, and therefore it doesn't seem to be in the best interest of the tribe. And if it's not, it's my duty to take a stand against it, my legal and ethical duty to take a stand against it. But we don't spell that out here, do we? We just say the council can hire an attorney. We've gone beyond that already, but it says they have the right to employ legal counsel for the advancement of the rights of the tribe and its members. Again, I don't think you'd find a lawyer that's worked for the council in the past 20 years that could tell you that that's what the Constitution says, and would therefore be able to answer that question that was posed to that lawyer. Who's your client? The tribe or the tribal council? So, going on, because we're getting close to a time we said we were going to quit, it says the council has the authority to advise the Secretary of Interior with regard to all appropriation estimates or federal projects for the benefit of the Blackfeet tribe prior to submission of such estimates to the Bureau of the Budget and Congress. and to manage economic affairs and enterprises of the reservation, including all oil leases on tribal lands and the disposition of oil royalties from tribal lands in accordance with the terms of a charter to be issued to the Blackfeet tribe by the Secretary of Interior. So it's under Article 6, Section 1E, that the charter comes into play. Now, once again, I served on 2 terms. I represented councils for about 10 years. Not many people I ever worked with on the council could even tell you what this was in this charter, let alone follow it. And I've actually served with people who said, well, I don't even know what's in that charter, so we're probably going to violate it all the time. But yet we take an oath that we're going to uphold the Constitution and laws of the tribe. And this is one of those laws.
Hey Joe, just a quick point there on that charter. In 1950, those oil leases started coming, and they were more significant than what was in the charter, more than the $5,000 limit that's in there. And so a council back then took that $5,000, in excess of $5,000 from that money, oil leases, and put it in an account. And the Secretary of Interior called them on it. So they violated their charter as early as in 1950, that I can see. And the 10,000 thing you always hear about, you can't make an expenditure more than 10,000 is in the charter.
Let's talk real quick about 2 provisions in the charter. And again, these come up, and one is another reason why we have to change all of this. Under the charter, and the charter says that the board of the tribe is going to be the council. And so under the charter it has something called corporate powers, Section 5. And it says, subject to the restrictions contained in the Constitution and laws of the United States or the Constitution and bylaws of the tribe, shall have the following corporate powers in addition to powers already conferred. And here's one that always comes up that I personally brought up. But yet, if we think about it today, it's so outdated that to follow it every day would just bog tribal government down. It says that the council has the power to purchase, take by gift, bequest, or otherwise hold, own, manage, operate, and dispose of property of every description, real and personable, subject to the following limitations. Here's the first limitation. No sale or mortgage may be made by the tribe of any land or interest in land, including water power sites, water rights, oil, gas, or other mineral rights now or hereinafter held by the tribe within the boundaries of the reservation. No sale of any other capital asset of the tribe exceeding the value of $10,000 may be made unless approved by a majority vote at a referendum called by the tribal council as provided in Article 9 of the Constitution. Now let's take that last sentence there. For those of you that don't know, in accounting terms, a capital asset is any asset that has a life of more than a year, in which under accounting rules we do what we call depreciate. We reduce its value over time. So, what's the value of a brand new truck today? A lot more than $10,000, right? So let's say we use that truck for a couple of years and we decide we're going to trade it in. That's essentially a sale. Now, if we've only used it for a couple of years, chances are, because if you look in the paper at used trucks, those of us that are truck people, hell, you can't buy a truck that's less than 10 years old for less than $10,000, can you? Even a good used truck, you're looking at anywhere from $15,000 to $25,000. So if we're going to trade our 2-year-old truck in, and it's got a value of more than $10,000, according to this, we have to have a referendum vote. So every time you were going to do something like that, you'd have to have a referendum vote. And that's kind of like why Crows eventually changed their constitution, because they realized that having a vote on everything bogged down their government. They weren't going nowhere. And you can all probably remember that we all used to joke privately about, oh, I'm going to end up like them crows. Look at them crows. And that's why, because they were voting on everything. Now let me jump way ahead. This is one of my favorite provisions of the Charter. And you all remember something called Tire Tech, huh? And that's when the council put up $750,000 to buy a patent on used tires that supposedly were going to be made into road building material. And I just heard about it. And there was all these rumors, and I thought there's got to be a way to prove it. So Article 9 of the Charter says, and I'm going to skip parts of it down to, basically says the officers of the tribe shall maintain accurate and complete accounts of the financial affairs of the tribe, etc. Tribal council shall elect from within or without their number a treasurer, who shall under the control and direction of the tribe be the custodian of all money under the jurisdiction of the tribe, shall pay out money in accordance with the orders and resolutions of the council. No disbursement shall be made without the signature or approval of the treasurer. He shall keep accurate accounts of all receipts and disbursements, and shall make written reports of the same to the council at each regular and special meeting. Shall be bonded in such amount as the council shall by resolution provide. And here's the big one. The books of the treasurer shall be open or shall be audited at the direction of the council or the commissioner of Indian Affairs, and shall be open to inspection by members of the tribe or duly authorized representatives of the government at all reasonable times. In other words, tomorrow morning at 8:30, we ought to be able to go next door over here, go into Miss Birdrattler's office and say, Tainsi, we want to see all of the books of the tribe. I want to start with, and I did this several times, I want to start with the council's travel. I want to see all the council's travel for the last year. And in theory, she has to give me that. But if we were to go over there and do that tomorrow, what do you think the answer is going to be? Tainsi's going to say, you got to go ask the council. The council is going to say, no, that's confidential information. Well, according to this, it's public information, isn't it? That's one of the ways we go back to that word, checks and balances, are those words, but they give us what? Accountability. That's how you hold people accountable, is by information and knowledge, and spreading that knowledge out to the people. And so our only method of holding the council accountable is information. And we're supposed to be able to get that information. But if we're denied that information, how can you hold the council accountable? You can't. And so we'll stop there for tonight, and we'll continue to go on. And again, we're less than we were last week, and our new guest left. But let's see if the next week we can bring somebody with us. And before I let that go, after I posted, after last week, I went home and made a little short post on the internet and said, gee, we had our first meeting, it was a good one, and I'm enthused, and got a bunch of messages from people saying, oh, when's the meeting? When's the next meeting? And each one of them, I said, the next meeting's next Wednesday at 6 o'clock. Am I going to see you there? And every one of them said, yeah. But not one of them are here tonight. So let's see if we can drag some more people in and educate more of each other.
Everybody away by saying we're doing something different. Let's remind ourselves that what we're not about here is changing enrollment. What we're about is changing our government. And the reason we're about it is because of the situation that occurred over the past couple of years, and basically the meltdown of tribal government, and it came to a halt, all to the detriment of the people at the end of the day. The system didn't function. And as a part of that, we've been talking about a separation of powers. And the first thing people think about is the tribal court, separating out the judicial system. But we also have talked about a a separate legislative branch that makes law, and a separate executive that actually enforces the law, and the different powers that they would have, including the cost of doing all of that. And we just had an election here in the United States and in Montana, and as we talked last time, here beginning the 1st of January, the state legislature is going to meet. Those people are going to get paid a total between their per diem and their meeting pay about $200 a day for 90 days, and then they're done. And so the cost of doing that is a heck of a lot less than having a permanently seated tribal council who legislates and does executive things at the same time. And also as opposed to Congress, who get paid about $130,000 a year. And I was just watching the news before I come over here. I think this last Congress has passed the least bills of any Congress in about 20 years. So we've been basically paying them just to sit around and fight, kind of like the tribal council. So, and again, the reason we're doing this is because we agreed the system didn't work. So what we've been doing to understand that more than anything is just going through our own Constitution as it exists. And we talked about the Indian Reorganization Act and the purposes of it, what it offered to the tribe, and what it didn't offer to the tribe. That at the end of the day, there was really no complete self-rule, that there are still many provisions in the Constitution that require approval of the Bureau of Indian Affairs in one way or another. And so at the end of the day, the tribe doesn't have absolute control. We talked about our territory, how if we just went by that limited definition, there's an argument to be made that, gee, our territory, the only thing we got jurisdiction over is that western line up there, because it defines it according to the agreement of 1895. You read that agreement, it doesn't really define the reservation, it just defines the line over there on Cedar Street. As I just said, we talked about enrollment, that while that's not what we're about, I pointed out that the last section there actually says the tribal council as a group could have the power to change enrollment without even the people's vote. So those that don't want enrollment to change, this is a reason for them to be interested in changing the Constitution, to ensure that if we go forward, that can only be done in a certain way, that the people have a right to participate. We talked about the tribal council. We compared that to our original tribal constitution, where we started out with 13 members and now we're down to 9. And we talked about the districts, and going way back to 1935, we got the Browning district, Park Butte, Seville, and Old Agency. But in 1935, Browning was actually called the Agency district, because that's where the agency was. And we also talked about that the election today is submitted to the people at large, as opposed to the original Constitution. Each district elected its own representatives. You ran from Seville, only the Seville people voted for you. Hart Butte, only the Hart Butte people voted for you. Old Agency, only they voted. And only Browning voted for themselves. And today, as most of us know, any politician knows, if you want to win, you want to be on the council, you got to win in Browning. That's where all the votes are. And so Browning actually controls Hart Butte, Old Agency, and Seville. They don't really get to pick their own representatives anymore. The other thing we talked about is that the council actually has the power to change that, but the people have to vote on it. And then going back into the reason for our conflict, one of the first provisions that we looked at is that under the Constitution as it exists today, it says the tribal council shall elect from within its own membership the chairman and the vice chairman. And then it goes on to say the council can elect from within or outside its own membership the secretary, the sergeant at arms, and such other officers and committees as deemed necessary. And I asked asked at the first meeting, I think, what are the two positions that people get on the council that they want, that they think have power? And number one was the chairman, but number two was the secretary, right? And actually, it comes down to it, the secretary doesn't even have to be a member of the council. Anybody in here can be the tribal secretary. If the council picks them and says, we want you to be the secretary, then they are. They don't even have to be an elected official. Same with the sergeant at arms and committees and officers, other officers, it says. So in theory, the council could create other positions and just pick people. We want you to serve in this job. Then we talked about elections, and of course, as we discussed, that's the most amended provision of our Constitution. We haven't focused on the powers of the council or separation of powers. We haven't even got to that. We've been spend all of our time talking about how we're going to elect each other, amendments, so amendment after amendment on how we elect the council. And of course, the last one was when we went to 4-year staggered terms, and as I told you, in that election, what changed from the beginning was that we didn't used to have to register to vote. Last time they sent out these registration forms. You had to fill it out and send it back in order to even get a ballot. And so of about 6,000 or 8,000 eligible members, only about, I think the number was about 1,600 or 1,800 actually sent back registration forms and got their ballots. And of that number, only about 900 or so actually voted in the election. Of that number, about 500 and some, or a little over 600, voted to go to 4-year staggered terms. And then I told you that of that number, about 300 of those votes came from off-reservation people. So in other words, the people that live within the reservation, we didn't actually, as a majority, vote for 4-year staggered terms. That was given to us basically by the people from off the reservation, because we didn't take an interest. We were too complacent. We didn't talk to each other. We didn't discuss the consequences, and therefore we didn't vote pro or con one way or another. And so if we threw out the off-reservation ballots, two things. We wouldn't have met the 1/3 eligible voter requirement, and the election wouldn't have probably passed. We wouldn't have 4-year staggered terms today. At our first meeting, our elder, Gertie Heavy Runner, asked about that. And she said, when are we ever going to do that? I don't like that. And I told her, don't you remember that right after that election, a lot of people said that. And the council said, oh, well, we're going to give you a chance to vote. We're going to revisit that. But we never have. And that comes back to why we had, in my own opinion, the conflict that we did. And that was about power. Once people get to the council and realize how much authority they have, or they think they have, they don't want to give that up right away. Even in terms of changing the Constitution, a lot of them said, yeah, let's do that. In the past, yeah, let's do that. But the minute it looked like it was going to affect them in their term, they went, oh gee, I don't know. Maybe let's wait till next time. Let's wait for a while. We don't do that to us. I want to serve out my term. And so power has become part of the problem. Then we looked real quickly at, and that's what I wanted to come back to now, because it's really what started this fight that brought us to where we were. So I thought it might be worth a little bit of discussion this evening to talk about that. So let's go back, take a ride back in time to 2012. We had an election, and we had a group of people get elected. I believe it was 4 back then. 4 members got elected. And then they picked an executive committee. And by the middle of August, they swore their oath in July, middle of July, first Thursday in July. We swear to uphold the Constitution and bylaws and charter and laws of the Blackfeet tribe. By the first part of August, they were already in conflict with each other, and things weren't going well. And they went to a meeting in Billings. The group came home early, and 4 of that group held a meeting right here in this room. And those 4, along with, they appointed some others just on their own. They voted to expel the other 5 members, right? So let's talk about that just for a second. Vacancies and removal from office. A council member or official shall die, resign, permanently leave the reservation, or be removed for cause the council shall declare the position vacant and shall elect to fill the unexpired term, provided the person elected to fill the unexpired term be a resident of the district in which the vacancy occurred. So if we just stop there, the only time the council has a right to elect someone on their own is when they've legally removed someone or someone has died or resigned. So when that group of 4 people said, oh, we're going to appoint you and we're going to appoint you, and now we're going to have a vote, was that legal? Not according to that, right? So then in section 2 it says, the tribal council may expel a member for cause by 2/3 or more members of the entire tribal council voting for expulsion. Before any vote for expulsion is taken on the matter, such members shall be given an opportunity to answer any and all charges at a designated council meeting, and the decision of the tribal council shall be final. So let's kind of break that down a little bit, because that's something that's been argued about before in the context of what it takes to rescind the resolution. It takes another provision. Let's see if we can jump way ahead here. Right here, this is in the bylaws of the Constitution, under meetings, right there in section 2. It says 2/3 of the entire members of the council shall be present to constitute a quorum to legally transact the business of the council. Section 3, all decisions shall be by majority vote of the council members at a meeting in which a quorum is present, with the exceptions that a 2/3 vote of the entire council shall be necessary to rescind any former action of the tribal council. So there's been an argument from time to time about what those sections mean. And the argument has been, do they mean that when that happens that the entire council must be present? Or when you read those, the quorum requirement and the 2/3 requirement together, does that just mean that 6 of the council have to be present, and then that all 6 of them have to vote to do something one way or another? So it's been interpreted both ways from time to time. But if we return back to vacancies and removal, it says the council may expel a member for cause by 2/3 or more of the members of the entire council voting for expulsion. Now, does that say that all 9 members have to be present when that vote is taken? Or does it just say that the 2/3 is based on the entire membership of the council? So if we stop there, there's 9 members of the council. What's 2/3 of 9? Easy junior high, grade school math. 6 people, right? 6 is 2/3 of 9. So at the very minimum, 6 people must vote for expulsion. Then it goes on to say, before that's taken, the council member shall be notified at a duly set meeting and be told of the charges against them. So if we go back to that time when a group of 4 supposedly expelled the other 5, if we apply that standard, was that a legal vote? It wasn't, was it? First, there wasn't 6 members present to constitute a quorum. Second, 6 members didn't vote to expel anybody. And third, the people they were trying to expel, they weren't given an opportunity to answer the charges at a meeting designated for expulsion. In other words, they weren't given a notice that said, Joe, come to the meeting on November 10th. This is the charges against you. You were drunk on the street raising hell, and we're gonna vote to expel you. And that person didn't have a chance to show up and say, well, no, I wasn't drunk. I was upset at my family, and this was what I was doing, and you have no proof that I was drunk. And besides that, I went to the hospital right after I heard you saying that, and I got a blood test, and here's the results. I had no alcohol in my system. So the bottom line was there was no hearing to do that. So if we apply those 3 standards, that attempt to expel the other 5, that wasn't legal. So that's what happened. Other 5 come home, they were upset, and they got together, and 4 of them, 1 of them didn't take part. So then 4 of them said, we're suspending you other 4 for what you did to us. You're suspended, period. There was no hearing on that either. So, and as we talk, does anybody see the words suspension up there? It's not, is it? So that goes back, remember I told you about that. I thought he might be here tonight. He actually called about the meeting. That goes back to that so-called Schilt precedent, when in 2006, the council first suspended and then expelled Pat Schilt from the tribal council. So I represented Pat Schilt in that. We went to tribal court and we challenged first the suspension. And we said just that. There's nothing in the Constitution that even speaks of suspension. How can you do that? And the tribal judge, a non-member who they brought in to hear the case, he looked at the Constitution and he magically found the right to suspend a member in this provision right here. Now this is in Article 6, Powers of the Council, Section 1R. Section 1Q says the council has the power to adopt resolutions regulating the procedure of the council itself and of other tribal agencies and tribal officials.
Where's it at now?
1Q, Article 6, Section 1Q. If you don't have your Constitution, you want to look at it directly, here's some extra ones up here. So that's what it says right here. This is what he relied on. The council has the power to adopt resolutions regulating the procedure of the council itself and other tribal agencies and tribal officials. Now, does that say anything about discipline or suspension or punishment? It says procedure, right? And procedure generally means how we do something, the process by which we do something. So Pat Schilt said, I'm going to appeal that. So we went to the Blackfeet Tribal Court of Appeals, and that's when the real bad precedent that brought us to that ultimate fight came up or started. The Court of Appeals said, well, we have no jurisdiction over this. If it's in the Constitution that the council can do something, then the tribal court doesn't have any right to review it. Even if it's wrong, we don't have any right to review it. And they said, so the decision stands, you're expelled. You're suspended. So a few weeks later, the council sent Pat the notice and said, all right, we're gonna have a meeting on expulsion, and this is the charges against you. And so Pat came to the meeting, and they presented the charges, he denied them all. There was 8 of them at that point. They were all here, him. They said to him, you can't vote, because you're the target here. So that left 8 members, and they voted. And it was 5-3 to expel him. Let's stop right there. Is 5 2/3 of 9? No, it's not, is it? We just said simple math. Is it 6 is 2/3 of 9? Let's take it a little harder. Junior high math now. Is 5 2/3 of 8? Come on, somebody. No, it's not. 5 is not 2/3 of 8. 2/3 of 8 is more than 5. It's 5 1/3. So 5 is not 2/3 of 8 either. And actually the attorney at the time told them, you lost, you didn't have the vote. And they even went in the back room and they called up the BIA. And they said, this is what we did. Did we expel him? And the Bureau said, interpret your own constitution. And so they waited, and the next day the executive committee, just 3 members, held a meeting. And they said, well, we interpret the Constitution based on advice of another attorney, that 5, while it's not arithmetically, it's not mathematically 2/3 of 8, it's a working 2/3 of 8. And so you're expelled, Pat Shell, you're gone. And so Pat challenged that in court. They brought in a different non-Indian, different white guy to hear the case. And that guy told him, well, gee, I'm really sorry, but the math don't work. 5 is not 2/3 of 8. But then he said, but my hands are tied, because he was trying to follow judicial practice, which was there was a precedent by the Court of Appeals that said they had authority to do this because it was in the Constitution. And he said, so I disagree with them, and I don't believe they legally expelled him, but my hands are tied by their precedent. And he said, I encourage them to revisit their precedent and overturn it. So we went back to the Court of Appeals, and once again the Court of Appeals said, we're sorry, but we already decided this. We told you the first time you came here, if it's within the power of the council to do it, we got no jurisdiction over it, you're done. And that became known as the Shelt precedent. So now let's fast forward again to 2012. And the 4 have just suspended the other 4 and told them, you're on suspension. What is, just in a common sense, what would everybody, when we say something is suspended, we generally think about that as kind of a short-term action, right? That's not permanent. There's something else gonna happen. You're suspended, kind of. Just we're holding up for a while. But as time went on, it seemed to be pretty clear that the group of 4 wasn't going to bring back the other 4. And therefore they were expelled. That was really their intent. And so, were they legally expelled if only 4 of them did it? We end up in the same boat as the first bunch did, right? They had no meeting to do it, they didn't have a quorum, and they didn't have a 6-person vote to get it done. So, let's be honest with each other. Why did all of that occur? What was the fundamental reason that whole thing occurred?
Power.
It was over power. It was a fight over power. They no longer saw themselves as 9 equal working members of the council, as our elders did, and that they had a duty to resolve their differences. They saw themselves as having power. I want the power. You can't have the power. I got the power. It's like school kids fighting over the ball, right? It's my basketball. If you don't play with me, I'm going to take it and go home. Well, I'm going to take the power and you're out. You know, when I was a real young boy, and the elders used to come to our house and talk, I would remember hearing them from time to time say something like this about being on the council or having that authority. They would tell my dad and tell others, as you're a leader now, you have no more family of your own. We're all your children, all of us. And your responsibility is to take care of all your children. So your duty is to work with the others and put aside your differences to work for the betterment of all your children. So it was that philosophy that allowed all of these old men on these pit walls behind us, that allowed them to try to move our tribe together way back when life was a little less complicated than it is today, because they approached it in that manner. Even if I disagree with you, I've got a duty to work with you at the end of the day. It's not about how much power I got or how much power you got. It's about working together for the betterment of the people. Well, at that point in time, first with Pat Schultz, and then that kind of trend continued, because really in between then what happened? We went through about 5 different chairmen, didn't we? Where the council itself appointed a chairman. No, we're mad at you, we're going to take you out, we're going to put another one in as a chairman. That too was about power, until we got to where we were. And so then things happened, and one of the members of the council was removed in a vote because of a felony conviction. It goes on to say that if you were convicted of a felony, you have not received a pardon, you shall be ineligible to serve on the council. So the council said, well, that guy was convicted of a felony, we don't even have to remove him, he's gone. We're going to appoint somebody else. And at that point, the 5 became 6. Now, from September of 2012 until about March of 2013, the council continued to act, didn't it? Did a whole bunch of things. And they did it under what they called executive resolutions. And if you look, as we'll see when we jump forward to the powers of the council again, there's no such thing as executive resolutions in the Constitution. So the Bureau was even playing its own brand of politics. It said to the group of 5, based on the Shelt precedent, we're going to let you act by executive resolution, but as soon as you get 6, you got to ratify all these decisions that you did in the past. So when the 6th came on, they took action to fix a bunch of those, but they didn't fix all of them. So arguably, those ones they didn't fix, they're not even legal. They were never legal. They're not legal as we sit here today. Got a question?
Yeah, there's something about the state of emergency or something like that.
So we're going to see here in a minute, but let's fast forward to that one, Tim. The state of emergency came from this thing called the Plan of Operations. And as we talked in, when we started on the powers of the council the last time, we got down to number E, where we adopted the charter, that required the adoption or allowed for the adoption of the charter. Now, if we go farther down, and we'll come to that here in a few minutes, Article 6, Section 1G says the council has the power to manage the tribal affairs in an acceptable and businesslike manner in accordance with an administrative plan called the Plan of Operations, and by amendments as necessary, subject to the approval of the Secretary of Interior. And so In 1964, a plan of operations was adopted. And in that plan, under the definitions section, chapter 1, M, it says, an emergency is a situation in which administrative action is required to alleviate an immediate danger to life and limb. The need must be of such a nature as to alleviate unnecessary suffering and hardship. Does a fight over power sound like an emergency that fits that definition? So
For natural disaster.
that's it. And then if the rest of the plan doesn't even have a section then that says, in the case of an emergency as defined by chapter 1, this is what you can do. These are all the things you can do. So what happened was that when the group of 4 suspended the group of the other 4, and there was now only 5 of them left, because one member has never voted to suspend or expel anybody. He refused to take part in those votes. But he did come back and work with the other 4. So now there was 5. That's not a working quorum. They were told that. You don't have a quorum. So they said, oh, okay, we're going to declare an emergency. And that allows us to take administrative action. And so that's what they did. So they operated under a theoretical state of emergency until March of 2013. So then now we had 6. And the 6 worked more or less together, leaving the other 3 out in the cold. Again, no expulsion hearing, no notice, no nothing. You're suspended, I guess, until our term's up, and then you'll just go away. Until October of last year. And then power got in the way again. The 4 of the 5 of the 6 started having a conflict over who was in control. So 2 of them broke from the 6 and said, oh, well, we're going to bring back the other 3 on our own. We're going to declare the illegal suspensions lifted, and we're going to bring back the 3. So now you had 5 and 4. And then the 5 said, well, we're going to throw a couple of you guys off, and then we're going to replace you with these other guys, and so now we got 6, we can legally do business. Well, but once again, they didn't have a meeting to do that. They didn't even have a quorum to do that, and so we ended up. The consequence was that the Bureau said, at least with respect to business with us, you don't have a working quorum of 6 duly elected members of the council, so we're not going to recognize any of your actions. That's what brought us all here. And so when we talk about why are we doing this, why are we talking about changing our constitution and changing our government and separating out powers, that's why. And I was at a meeting the day before you all remember last spring, I think it was in March, when they had the standoff out at Earl Olperson's cabin out there, and the police surrounded the place and whatnot. Well, the night before that, a couple of you in this room, just a couple, were at a meeting. I was asked to come to a meeting out there to talk about constitutional reform. And I went out there. We visited, and I said, I want to caution folks about one thing. Here, we're all talking about reform. Gee, you can get on the internet and on the Blackfeets who want change. There's a couple of thousand people talking about reform. Here's one of the things that happens. Everybody's all fired up. Council gets elected, and gee, they start working together, or at least appear to be working together. And what happens? Everybody goes, oh, gee, well, They're working, look at, it's working. We don't have to do nothing, it's gonna work. But all it takes is then for a couple of people to say, oh, no, we ain't gonna play that game. We're gonna do what they did with the Schultz thing. We're gonna go off on our own. And in a blink of an eye, we can be back to that same place again. And if you remember right, at our last meeting, when Carrie and Bill came in about constitutional reform, Carrie and Darrell, one of the council members spoke real strongly at first, kind of questioning our motives and whatnot. And he said, I was a victim of that. And I told him, the reason you were a victim of that is because we had no separate independent court system where you could go to bring your grievance, who could say to the rest of the council, yeah, you did this person wrong. We order you to reinstate him. Because our court had taken a walk. Because under our Constitution, we have no separation of powers. Because the court is a creation of the council. Under Article 6, Section 1K, the council has the power to create courts. The council has always taken a position, and you guys answered to us. Remember I told you at one time we even created something called, because the council didn't like the outcome of a particular case, they said, well, Court of Appeals didn't get it right, so we're gonna create a Blackfeet Supreme Court. So for about 8-10 months, we actually had something called the Blackfeet Supreme Court. We had the regular court, the Court of Appeals, and then the Blackfeet Supreme Court. That just kind of died out on its own because there was really no, once the council got whatever it needed in that case, there was no reason to continue. So, going back to that whole thing about removal from office, that's where what brought us to today. That the removal clause was used in a power struggle over who's got the power. We got the power, you don't got the power. And as somebody said to me, council lost track of the notion that it's not about power, it's about responsibility. And it's about exercising that responsibility in a way for the best interests of all the people. So whenever we get caught up in that power, this could always happen. It just happened here. You know, some of the council even refuse to talk about it. They want to think that it can't happen again, but it can. It just takes a couple of personalities to come into conflict. We can go back to that same setting. I'm going to take this group and go with me, well, I'm going to take this group and go over here. And we're going to get nothing done. And not only are we going to get nothing done, we're going to throw you guys out and pick our own people. And again, who's suffered because of that? The people suffered. Program people suffered, the regular people suffered. Everybody suffered because of that. And so that's why we're here trying to talk about changing our Constitution. So as you all go out there and talk to people over the coming months, remind them of why we got here, why we need to do this. And it only takes a couple people to go off the deep end and end up back here again. So, like last time we got into the powers of the council, and there's three. The powers of the council is divided into three sections. Section 1 is called the enumerated powers. That's the powers that are just spelled out specifically. We give this power to the council. We'll come back, but we're just going to jump forward real quick. Section 2 had to do with manner of review. And that goes to that point that not even under the Constitution, we don't have, the council don't have, the tribe don't have complete power. Even when the council's doing right, a lot of its things are still subject to review by the Secretary of Interior. Now let's be honest about that. That played out in this last election. One of our elders, Charlie DeRouche, is with us tonight. I'm sure he remembers the time when he served. When the council would pass an action, depending on the nature of it, That would go right down to the superintendent. Superintendent would have to review that action, and he would tell us, I either approve it or I disapprove it, and this provision would come into play. And Earl Operson reminded us all last week that back in that day and farther back, the superintendent or his representative used to actually be at every council meeting. And if they thought the council was about to do something wrong, they would say, well, wait now, guys, let's talk about this. And the Bureau would exercise that authority. When we had the meltdown, the Bureau took a walk, and they did it under this modern notion of self-government. That's an internal matter to the tribe. Well, we aren't going to get involved. That's an internal matter of the tribe. But yet, in our Constitution that they gave us, in a number of places, it says they have some kind of responsibility. But today, they don't really exercise that responsibility at all. They just do it in a limited way. When it suits their purpose, they come to the table and say, oh, you can't do that, or you have to do this. Otherwise, oh, that's an internal matter. We're not going to get involved. Section 3 of the Constitution is future power. The Council of the Reservation shall exercise such future powers as may be delegated to the Council by members of the tribe or the Secretary of Interior or by state or federal government. So to me, the notion of that was the Council don't have all the power. There's still some things that we, the people, would have to give them, or that the government took from us that it has to give us back. And a good example of that, and an easy one, is liquor. As we all know, alcohol has devastated Indian people across America. And alcohol played a role in the early history of our tribe. So the government took the position that Indian people couldn't regulate, tribes couldn't regulate the sale of alcohol on our reservations. And alcohol was banned from Indian country. And then Congress passed a law in the early 50s that said, if you want to sell alcohol on the reservation, you have to have permission from both the state and the tribal government. And in that way, they gave us back a limited right to sell alcohol. So today, we have our own alcohol ordinance. And if you want to have a liquor license, you have to have it from both the tribe and the state, because that's what federal law says. So that's an example of a delegation of authority back. Finally, it says reserved powers. Any right and powers heretofore vested in the tribe, but not expressly referred to in this Constitution, shall not be abridged by this article, but may be exercised by the people of the reservation through the adoption of appropriate bylaws and constitutional amendments. And we talked earlier last time about the referendum and amendment thing that also helped bring us here, that we all hope at the appropriate time the people will step forward again and say, yes, we support that. When the people voted on a constitutional referendum issue that said we want to have an amendment to the Constitution. And as Fish has pointed out numerous times, the referendum and amendment language is pretty clear. But that goes back to that power thing. And if the council is the one that's got all the power, and the court doesn't think it's got any authority, then we don't get anywhere. So referendum, upon a petition of 1/3 of the members of the eligible voters of the tribe, or upon a request of the majority of the members of the council, any enacted or proposed resolution shall be submitted to popular referendum, and the referendum shall be conclusive and binding on the council. So Fish had a referendum put up about, do you want to have a constitutional amendment? And the people voted on it. And 2,300 or more people voted in favor of it. Only about about 440 voted against it. So according to that language there, that last clause, such referendum shall be conclusive and binding on the tribal council. Did the tribal council adhere to that? They didn't. In fact, some of that group, when that was going on, we got to the election of 2010, and the Constitutional Reform Committee, in an effort to promote reform, held a rally, as we call it, where all the candidates were allowed to come in and speak. And several of the candidates, I think 2 of them at least, who made it onto the council in 2010, went to that rally. And they stood up and said, I support constitutional reform. I support the referendum. And they got elected. And by August, I think, right?
August 5th.
In August, they came into this meeting and they said, oh, well, all jokes. We're going to vote by resolution to abolish you guys. You're done. There's no more referendum, no more amendment committee. You're done. We take that back. We didn't really mean what we said. So at that point, the referendum language became meaningless. It wasn't binding and conclusive on the council. And going all the way back to our election ordinance, our election rule rather, when they changed the Constitution to go to 4-year staggered terms, they added this section right here of Article 5. Article 5, Section 4. It says, upon a petition of the tribal to the tribal council of at least 20% of the total eligible voters, a recall shall be held within 30 days of submitting a petition to the tribal council to determine whether a member shall be recalled and removed from office. I believe it was between 2004 and 2006, after he was, no, it was before he was removed because he was still on the council. A group of people came up with a petition. Now, nobody even knows if they met the 20% requirement. They believe they did, but they came in and they presented their petition to remove some of the council members. Remember what I told you happened to that petition? They took it and walked over to the trash can in their office, dropped it in there, and that's where it stayed. The council didn't honor it. They basically said, oh, we got the power, we'll decide that. We ain't even going to review your petition. We aren't going to decide if the names are adequate. We aren't going to decide if you followed the right procedure. We aren't going to decide if you got enough signatures. We aren't going to do that, period, end of story. So once again, the people's effort to have a say was wiped out, was overridden by that single word, power. And that's why we have to separate the powers of the council. So we started talking about the specific powers of the council. One of them was, and that's going on right now, people are angry about that, but there it is. So again, if they don't like that, that's why they need to take part. The first one is the council has the power to negotiate with federal, state, and local governments on behalf of the tribe. Doesn't say what about, just says they have the power to do that. So when people get angry at the councils over the years, or gee, it's been going on for about 20 years, for negotiating with the state of Montana and the federal government over our water rights, it says right there, basically, that the council has the power to do that, doesn't it? That's one of the powers of the council. Now, as I make the point, and I want to do it again for anybody that may watch later, under the water rights agreement as it is, the people will have the power to vote on the final approval of that. But under this article right here, just by itself, the council could do that, do other things on its own. It goes on to say negotiate, advise and consult with representatives of the Department of Interior on negotiate over 638 grants. We negotiate our indicate cost rate. We talk to them about various laws that we think we want or that we're opposed to or whatever. So that continues to go on. It says we have the power of the council to employ legal counsel, attorneys, for the protection and advancement of the rights of the tribe and its members. But the choice of the council and the fixing of fees have to be approved by the Secretary of Interior. And as we talked last time, arguably the Secretary could say, oh, we don't like Joe McKay, we don't want you to hire him, we're not going to approve that. Or we don't like how much you're paying that person, we're not going to approve that. And in theory, restrict who the tribe actually hired as an attorney. Now, Mr. Edwards at the last meeting raised that point about that. He said, well, during the meltdown, it appeared that the attorneys, or at least some of them, were actually advising the group of the council that it was okay to break the law, that it was okay not to follow the Constitution. And so I told him, well, that raises that simple question of who is the client of the tribal attorney? Is the client the tribal council, or is it the tribe itself as a tribe? And if it's the tribe itself, doesn't the attorney have a duty to tell the council when necessary? Wait now. You're exceeding the scope of your authority under your own constitution. You can't do that. You're violating your constitution. Or just that particular action you want to take may not be in the best interest of the tribe. And it's our duty to let you know that, and at least speak up and say that to you. And so that's a legitimate issue. Who does the tribal attorney represent? Because in a lot of circumstances, the council looks to their attorneys to give them approval, right? And if the attorney passes their blessing on something, no matter how bad or how illegal it might be, the council uses that as a means to justify it, don't they? Oh, the attorney said it was all right. The attorney approved it, so it must be okay. Legal said it was okay. Ask legal. They said it was okay. So doesn't the attorney then have a duty to say, no, I don't represent you as the council. I represent the best interests of the tribe and its members. And if you look at it that way, the council's not all the members. At some point, the attorney has to elevate themselves, not in a power sense, but above the politics and say, wait now, I'm an advisor here. I have a duty to offer appropriate advice. Whether you agree with me or not, is that you're right, but it's my duty to say, let's think about that. That might not be the best thing. That might not be an appropriate thing. That might even be illegal. And so it's my duty to tell you that. The next power of the council was the power to prevent the sale, disposition, lease, or encumbrance of tribal land or interest in tribal land or other assets without the consent of the tribe. That seems now, if we just took that first part, prevent the sale, disposition, lease, or encumbrance of tribal land or interest in land or other assets, that would be okay. But it goes on to have that other language again, doesn't it? Without the consent of the tribe. Now, what does that mean? And that really is, in my own opinion, one of those gray things that you could argue about. So the council would say, well, it doesn't say without the consent of the people, and we're the elected representatives of the tribe. So it's really just saying without our consent that this can't happen. Other folks look at that and say, no, the tribe means the people, so you can't do that without the consent of the people. Let's talk about that just for a second. I brought this up at the end last time. The Crow were one of the few, about 87 tribes, 300 and something, after between 1935 and 1940. About 300 tribes adopted some kind of government under the Indian Reorganization Act, some kind of constitution. The Crows were one that didn't. And so when the Crows met, a council meeting consisted of every member of the tribe. Remember I told you I was fortunate enough as a child to go to a Crow Tribal Council meeting at Crow Agency, this big gymnasium. The council, the kind of governing, or the council itself, they really didn't govern. They got ready to pass a resolution, and then somebody said put it to a vote, and everything stopped. They had 2 little voting booths. Everybody in the room, the gymnasium, would line up at those booths and vote on every issue. And we all used to, as I got older and got into politics myself, we used to joke about the Crow, didn't we? Oh, let's do it Crow style. Everybody in the world gets to vote. And the reason we joked about it was the Crows didn't seem to progress very far. They didn't seem to get far because that's the way they did things. More recently, they wrote and adopted their own constitution. You know, to the degree they're successful, I guess we just have to study that. But they seem to be doing better than they were when everybody voted on everything. So there's 2 ways to look at that. One is that means the council speaks for the tribe because it doesn't say without the consent of the people. Another way would be to say, no, it means all of the people. And if you read it that way, then a bunch of things the council does would have to be subjected to referendum vote. We talked about the council has the power to advise the Interior about appropriations and budgets. And Article 6, Section 1E, to manage the economic affairs of the tribe, including oil and gas leases and dispositions of oil royalties from tribal lands in accordance with the terms of a charter to be issued by the Secretary of the Interior. And we talked about that charter. I'm going to pause here, just pull it up for a second, in case you haven't got it. There's some laying on the table here. So then in 1936, I believe, we voted, oh, that's right, this is not on here, I gotta do it. We voted on this charter, and the people, let's see, what was the date of that? December 27th, 1936, we adopted a charter. And that charter basically makes the tribal council the corporate board of the tribe. And as we talk, there's a provision in this charter which is based on 1930s mental or amounts and whatnot. 1936, $10,000 was a lot of money. And so the charter says in this section, let's see, under corporate powers, section 5B, that the council has the power to purchase by gift, bequest, or otherwise own, hold, manage, operate, dispose of property of every description, real and personal, subject to the following limitation. No sale or mortgage may be made by the tribe of any land or interest in land, including water, power sites, water rights, oil and gas, or other mineral rights now or hereinafter held by the tribe within the reservation boundaries. No sale of any other capital asset of the tribe exceeding in sum the value of $10,000 may be made unless approved by a vote that the majority of the tribal council, a majority vote at a referendum called by the tribal council as provided in Article 9 of the Constitution. So in other words, they were saying if the tribe's going to sell anything that's worth more than $10,000, got to have a referendum vote. Back in 1936, that was a lot of money. I remember we moved forward to today, and you driving a brand new truck, one of those $40,000 trucks. You drive it for a couple of years, still got a trade-in value of maybe $20,000. So what that means is every time the tribe went to trade in a vehicle, we'd have to have a referendum vote. So there are some things even in our charter that by virtue of time moving forward would be restrictive on the ability of the tribe, the council to do business. But rather than just ignore them, wouldn't it be better to amend those things and change them, to make them reflect the times, to operate under the document rather than just violate it all the time? So in that sense, the charter has kind of become meaningless, even though it's an important document of the tribe. Remember I pointed out to you, and actually George made a point here in terms of the charter itself. Now, section 6 of the charter says that by referendum vote, we could remove the supervisory power of the Secretary of Interior. So we could take out secretary approval, but if for some reason we wanted to completely rescind the charter, that would take an act of Congress. What section was that, George? You had that right here, section 10. Yeah. This charter shall not be revoked or surrendered except by act of Congress. So in other words, if we wanted to just completely abolish the charter, we'd have to get somebody to write a bill, present it to Congress, and Congress would have to, this great body who can't even get together among itself, would have to get together and vote on the Blackfeet giving up its charter. So,
Hey, Joy, and I was reading in 1952, the council made a whale deal that violated the, that same section you're talking about, section 5.
right.
F, and in excess of 10,000, and the Bureau would not approve that. Although that money was gonna be allocated for per capita and given to people, the Bureau, because they exceeded that corporate amount,
Yeah.
the Bureau didn't approve.
But today, do they do that? No. Today, they just kind of ignore us and again, turn their back. They too have walked away from their supervisory authority, again, unless maybe it becomes convenient for them to do it. But like I told you, remember, there's one important part of this charter that is supposed to be that other thing we talk about. Checks and balances and accountability. Accountability. How do you hold people accountable? A lot of times you hold public officials accountable by exposing what they're doing to the rest of the world, right? By information. And what's the biggest thing we do? It's our money. And as we talked, because that's what she's been told, if we tomorrow went over to the treasurer and said, Tainsi, Ms. Birdrabbit, we want a listing of all the tribal council travel for the last 10 years. She'd look at us and smile and say, you go get an approval from the council first. And the council would say, no, that's confidential information. But here's section 9 of the charter. Let's just talk about the last sentence there. It says, the books of the treasurer shall be audited at the direction of the council or commission of Indian affairs and shall be open to inspection by members of the tribe at all reasonable times. In other words, we as members are supposed to, that's our accountability, to go tell them, I want to see how the money's been spent. I want to see who got what. I want to see this. But the councils over the years have said, no, you don't have, you can only see what we give you to see. Isn't that a controlling information? Isn't that a way you control people? You only give them as much as you want them to know. You don't give them the big picture. You just give them little tiny pieces of that picture so that they can't make the picture themselves. So, again, the charter came about council the power to manage the business affairs of the tribe, or to manage economic affairs and enterprises of the tribe in accordance with the charter. So that's kind of where we ended last time. Let's go on to Article 6, 1F. Council has the power to make assignments of tribal land to members of the tribe in conformity with Article 7 of the Constitution. So Article 7 of the Constitution, which we'll see probably next time, a big part of it has to do with that thing called standard assignments. Now, as we talked, remember in 1935, one of the things the Constitution and Indian Reorganization Act did was it ended allotments. Individual people could no longer get allotted tribal land. The tribal members or leaders, the old people, must have been concerned that people got left out. And so they adopted this provision presented to them called standard assignments, where they said if you don't own any land yourself, you can come in and apply, and we'll basically give you like a permanent home site for your life, and you can even transfer it to your kids if they don't have land, of tribal land. You're not gonna own it outright, you can't sell it, you can't do these other things with it, but it's kind of like yours. You can farm it, you can ranch it, you can take the profit off of it, all those things, standard assignments. And then remember I told you in early 80s, Charlie Conley made a move to abolish standard assignments. And then today there are no more standard assignments, even though, as George points out, that's still in the Constitution. We never rescinded that, or we never threw that out by amendment. It's still there. It was just, again, the power of the council that said, we're not gonna do that. You can't do that no more. Even if you own no land, even if you can find some tribal land that you want, no, we're not doing that no more. But it's still in our Constitution. It says that they can. Now this is, the next section is where this plan of operations comes from. It says the council has the power to manage tribal affairs in an acceptable and business-like manner in accordance with the administrative plan called the plan of operations by amendments as necessary, subject to the Secretary of approval or by his duly authorized representative. Now here's another sentence that gives us as people some kind of right, or a couple sentences. But again, when this has happened, there's been a big outcry. Oh, you violated my rights. So it goes on to say, all salaries or remuneration shall be paid as set forth in the plan of operation. The tribe shall pay only for services officially authorized in the administrative plan and actually received. The amount shall be a matter of public record. Doesn't that seem to say that everybody's salary is public record? That everybody can see what everybody else makes? One other thing about it, then we'll take a short break and finish up the powers for tonight. That the second to the last sentence says the tribe shall only pay for services officially authorized and actually received. Now to me that seems to say that if you haven't earned that money, you don't get to get it. Now, remember these past few years, these things that also came up called payroll advances? Gee, some people, there's still a list out there. Some people, including council people, got $30,000-$40,000 in payroll advances. Now, if that advance wasn't actually earned, according to this, were they entitled to it? Doesn't look like it. And have we all ever seen a list of all the people that got those payroll advances and how much they got? You got the list, but it's never been published, has it?
Did they pay back?
Pardon?
They never had to pay it
Some of them have still not paid the full amounts back, that's right.
And some have been wiped off.
Some of them,
Council passed a deal too where you couldn't run for council.
so that was part of the referendum, where you weren't supposed to be able to run for council if you owed the council money. And one of the council people at that time left office owing about $40,000 that has never been paid back.
60.
Lots of money. So, again, this is another thing in our Constitution that we've just ignored. And where would we go to get justice there? Go to the court? Well, the court has said, we've got no power over the council. So, once again, folks, that's why we need to change our Constitution.
And you never hear the word unconstitutional. See, I could argue the standard side thing, that's unconstitutional, by who?
By the council,
By the council, so that's not any vernacular, it's basically, constitution in the eyes of the beholder.
So George's comment was that in our system, you never hear the word unconstitutional. Now, if you watch the news, CNN, for a couple hours any night, you'll hear that term 3 or 4 times. It's unconstitutional. And he was saying, so gee, in our system, and he used the standard assignments as an example, that they were abolished by the council, not by the people. He said it's come down to, it's the Constitution is in whatever is in the eyes of the beholder. Whoever's reading it wants it to mean. That's what it means. Because we have no separation of powers. We have no place to go to resolve that.
I just want to say that on my capstone, I did Blackfeet, and we looked at a couple other tribes, and I mentioned it to a few of you. And, having gone through it, studying what the other tribes are doing on a national level in Canada, we've got 630 indigenous tribes over there who are also moving ahead and restructuring. And so there's a lot of tribes to look at. But the one thing, when we talk about amendments and we talk about constitutional reform, that is paramount to me, that is more important in terms of moving things ahead, is to do an amendment on removal of council. I believe that, and so depending on the tribe, some tribes can get away with doing the entire constitution and it'll be voted on. And some tribes have even included enrollment, but that's not the case at Blackfeet. So you have to look at each tribe individually. But I think after talking to the Bush Foundation, who's really active right now with the Dakotas and funding Native Nation building people, the Harvard people and so forth, the trend seems to be doing amendments. And so you ask the question, what is a priority for amending? And I think the one thing, having witnessed, having been on council, having seen it from a member of the tribe, I think one of the first moves should be removal of council. First amendment that comes up when we talk about reform. One of the language in there, failure to honor the referendum, to honor the Constitution should be removed, grounds for removal of that, or failure for abuse of office. And so I think with that, I think it'll come together a lot quicker. So as we're talking about this, there's other amendments that are really key, I guess, to get the council in order and begin to hit those. But what you need, obviously the petition process doesn't work. They've had the numbers, they've presented it, and Joe pointed out, went in the trash. And so it's gotta be within the council, in my opinion. So I would say you just need 2 councilmen, one to make a motion and one to make a second, and the timing is absolutely critical. Right before election, when I pushed for the restructuring of our government, I could write a book, literally, what I had to go through, trading votes, support the rodeo, support this and that. I think that's the politics of it, and to gain trust of the other 2 councilmen. And we had a unanimous vote on it at that time, and all 9 members voted to support. And so I think as we look ahead, and I know Joe pointed out, within the 4 years, obviously we're looking at a long-term process, but I think we need to look at the next election as a key opportunity to try to implement some amendments, maybe not the whole Constitution. And so I think we need to start, when we write, to start rewriting those critical areas, removal and so forth. And
Jarvis has a real light voice. People have asked me to repeat that so that it goes into the record. And he was making a comment that it might be useful to make amendments as we go along, including an amendment related to removal of the council for not following the Constitution. So let's take a quick break here, though. And we started a little late, and we all got things to do every evening. We'll try to finish up by about 8:15 or 8:20 for a half hour, and so we'll go for a little while. Longer, and then we'll call it a night. We're talking about the powers of the council. And you know, just generally speaking, what's the one thing that every government does to raise money to fund its government? Taxes. Federal taxes, state taxes. It's the one thing everybody does. It's the principal source of revenue. We, the tribe, today have some taxes, but still a lot of our money from our leases and whatnot, that doesn't go to like general distribution. It goes to run the government. We've used all of our income to run the government because we haven't been into that thing called taxes. So Article 6, Section 1H says the council has the power to regulate and license all business and professional activities conducted on the reservation. Once again, subject to the approval of the Secretary of Interior, and to levy assessments for public purposes, provided that any assessment upon non-members trading or residing within the jurisdiction of the tribe shall be subject to the approval of the Secretary of Interior. In other words, the tribe has the right to tax. Now, what do you think that everybody would do if the tribe start taxing its own members? What do you think the reaction would be? My own sense is not very good, huh? But what's one tax that a lot of other people pay, white people on the reservation pay, that we don't pay?
Property tax.
Property and a state income tax, right? White people on the reservation that work at the school, they pay federal income tax and they pay state income tax. We don't. So what do you think would happen if one day the council said, well, we think we're gonna have a tribal income tax, and you guys are gonna start paying the tribe and we're gonna levy a tax on you? See, my own opinion is that simply because the tribe hasn't been very responsible with its money, most people would go, what? You're not gonna take my money, what are you gonna do with it? You're just gonna waste it. And there would be a rebellion over that. Same thing if the tribe says, all right, well, we're gonna tax your property. And people's reaction would be the same thing, wouldn't it? And so that goes back to why we have to have accountability. If the tribe were being accountable and doing the right thing all the time, there's always a natural resistance to tax. That's how the United States was formed, right? The United States government was formed on that heading of taxation without representation, because the British were taxing the colonies and they rebelled because they didn't want that. And so there's a general resistance to taxes. So if the tribe started doing that to its own people, my sense is we would resist, and that would become an issue. But that's why, to me, then we have to have accountability, checks and balances, and ultimately separation of powers. Now it says there that we got the right to levy assessments upon non-members, subject to the approval of the Secretary of Interior. However, as I told you in the very first session, the United States Supreme Court has significantly limited the tribe's sovereignty in that respect. And they have basically said, no, you don't, even if the government says you can, you can't, because we say as a matter of tribal jurisdiction, you lost the right to tax non-Indians on non-Indian fee land within the reservation. And so remember a few years back, the tribe passed something called a possessory interest tax. And it was trying to tax like the Burlington Northern right-of-way, the Glacier Electric right-of-way, those kinds of things. And they all challenged, that was a fad across Indian country. And those were all challenged in the federal courts. And the federal courts struck down every one of those taxes. And so today we have a limited right. We have a hotel tax, a bed tax that the big hotel pays and some of the others pay, but some don't. And if they really all challenged us, we might not be able to make it stick. We have tax sharing agreements with the state where we get a share of the gasoline tax, the liquor tax, and the cigarette tax that's collected on the reservation. But that's tied to tribal membership. And we don't get the tax that's levied on the white people in theory. And so the tribes, even though it says that, over the years, because of the court cases, our ability to do that, and therefore our ability to raise revenue, has been severely restricted. But let's talk about that just for a second longer. Let's say the tribe's possessory interest tax was still in effect, but the tribe wasn't taxing none of us. Wouldn't the non-Indians then have an argument that we're being treated unequally? That thing called equal protection? You're taxing us, but not your own people. Well, why don't you do that to your own people too, and we won't feel so bad about it. But the bottom line is we can't do it under the law. So let's go on. The tribe has the right to exclude from land owned by members, by the tribe or its members, persons not legally entitled to reside thereon, under ordinances subject to review by the Secretary of Interior. That's that famous word. You ever heard that word, float? Let's float Joe off the reservation. He's not a good guy. Let's get rid of him. That's where that comes from. The right to exclude people from the reservation. The next one is that the council has the power to requisition community labor for public purposes of the tribe, purchase land from members of the tribe under condemnation proceedings in courts of competent jurisdiction, subject to review by the Secretary of Interior. In other words, the council could in theory pass a law tomorrow saying, we don't like what them constitutional review people are doing, we think we'll punish them. We're gonna requisition their labor. We're gonna force them all to go up there and rebuild the Indian Days campground. That's what it says. It says they can requisition community labor. In other words, they can force labor upon us if it's supposedly for community purposes. And that the tribe has the power to condemn land of its members in courts of competent jurisdiction. In other words, just like the state and the federal government, when they're going to expand the highway, at the end of the day, you don't have a right to stop them. Your only right is to bargain with them for more money, because they can condemn your land and you can't stop that. And so remember, there was a case, some of you might have been approached by Pat Shelf to sign up for it, where the Conoco pipeline was running across the reservation and they tried to stop it. And those people went to court, federal court, and they had that pipeline condemned under a federal statute. And so people were basically forced to allow the pipeline to cross and get whatever money the court ordered that they were entitled to get. That's what condemnation means. That the tribe could, in theory, say, well, George, geez, you got a nice piece of land out there. We'd like to have that land and build, I don't know, a new church on it. We're going to condemn your land and take it from you because we see that as a community purpose. And they could do that according to this article right here. 1K, that the council has the power to promulgate ordinances for the purposes of safeguarding peace and safety of the residents of the tribe, establish minor courts for adjudication of claims or disputes arising amongst members of the tribe, and for trial and punishment of members of the tribe charged with commission of offenses set forth in those ordinances. In other words, we have the right to law and order and to enforce those laws in tribal court. Once again, it doesn't go on to say, and those courts shall not be subject to interference or review or whatever by the tribe, or the tribal council does it. That's why we don't have separation of judicial power. That's the judicial power of the tribe, right there. And we don't say that the council can't interfere in that. There's another important thing about that doesn't relate to our separation of power, but really about our sovereignty. And as a lawyer, I've had that brought up to me numerous times in cases where we're trying to say the tribe's got the authority to hear this case involving these non-Indians in tribal court. And some lawyer will come in and say, wait now, you don't. According to your constitution, that article says that you only have the right to establish minor courts for the adjudication of claims or disputes arising amongst members of the tribe. You don't, by your own language, you don't have jurisdiction over us. We're not members of the tribe. So in a case that I had in front of the Court of Appeals many years ago involving the old East Glacier Water and Sewer District, the Court of Appeals at that time said, well, wait now. There's two ways to interpret a constitution. One is according to this, the strict language of the Constitution. Another acceptable way is according to the way that the adopters of that Constitution understood it. And in that case, the court said, the Blackfeet didn't really write all of that. That was more or less given to them. And the people that adopted it didn't understand all those written words. So we're going to interpret it the way they believed it, not the way it was written. Court said, we believe that they would have said, no, that means if that involves a member of the tribe, then we get to have jurisdiction. So if it's just two non-members, the tribal court itself has said, no, we don't have jurisdiction in that instance. There was a fight between Archambault and the Weeder family over the sale of the old Archambault place out here. The contract for deed, they got into a fight over it. Now, although Chuck lived here for many years, he's not a Blackfeet. He's from Fort Belknap. And so, but they tried to bring that fight to tribal court. And the Weeder family, they opposed it. Said, no, none of us are members. You don't got jurisdiction. And the tribal court said, you're right, we agree. Because there's no member involved, and no member interest, no tribal interest, you go someplace else. You either go to Fort Belknap or you go to state court, but you're not going to fight it out here. So that's a provision that really restricts tribal sovereignty. And another reason why those of us that want to do this need to change things like that, to have the tribe have the broadest expansion of jurisdiction that the law allows us today. Because bright white lawyers have come in and said, no, according to that, you got no authority over us. So the next one, Article 6, Section 1I, or 1L rather, says we have the right to regulate inheritance of real and personal property other than allotted lands within the Blackfeet Indian Reservation, subject to review by the Secretary of Interior. So the council can pass like an inheritance law, probate law we call it. Now, even though it says there, we can't do that with respect to allotted land. In 2006, the Congress passed something called the Indian Probate Reform Act. And in that act, they essentially made one of those delegations of authority that we talked about earlier, where they said, well, Up until now, the BIA has had sole jurisdiction over probating Indian trust land. But if the tribe adopts a probate ordinance and we approve it, you, the tribe, can supersede these rules and you can probate these lands in tribal court. Only a few tribes across the country have done that. Now, one of the things that people don't like about that law is that it continues that old, remember that thing called escheat, where they said we're gonna, if you own less than 5% of your land, interest in it, and it's earned less than $100 in the last year, when you die, that land goes to the tribe automatically. People fought that 2 different times and went to the Supreme Court of the United States and they struck it down. Well, this last one, they come up with one that appears like it's gonna stick. And it's called the single heir rule. So if you pass away, only if you have no heirs does that land go to the tribe. But if you got any heirs, in order to prevent that land from being further divided up, say there's 10 of us, and grandma only owned less than 5% of that tract, probably everybody in here gets a lease check, like $7 or $20 or something, because you only own a little share of land. So under that act, instead of allowing that to be further divided up by the 10 of us again, it says, if you've got a piece of land that falls into this category, it goes to the oldest living heir. So in other words, big brother or big sister, they get that land outright. It doesn't get divided up anymore. And if there's no direct heir, and when I say heir, I mean direct heir, son or daughter, or mom or dad, not cousins or aunts and uncles or anything like that. So the tribe, because of that, because people here don't like that, and the tribe has agreed with them, we just did one about 2 weeks ago. The tribe routinely passes resolutions relinquishing its claim to that land, so that that land can stay in that family and go to whoever in that family. So instead of doing that, an easier way that would be more consistent with sovereignty would be to pass our own inheritance law and enforce that in tribal court. So if we go on, section 1M, article 6, council has the power to encourage and foster Indian arts and crafts, culture, and tradition. So it just basically charges the council with maintaining cultural things and promoting the culture and tradition of the tribe. Nobody's ever questioned that as a good thing. Article 6, section 1N, to enact ordinances not inconsistent with Article 2, the membership, governing adoption and abandonment of membership, and to keep at all times a correct roll of the Blackfeet Reservation. To me, that's kind of a meaningless provision when you already got a full article on membership itself. It's just kind of a reaffirmation that the council has the power to do this, subject to that article. Section 1O, to provide for the appointment of guardians for minors and mental incompetence by ordinance or resolution, subject to the approval of the Secretary of Interior. You know, unfortunately, and I'm one of them, lots of people today have family members who suffer from a mental illness or otherwise incompetent. The first thing we want to do in an effort to help them is we want to put them someplace, put them in treatment or something like that. But the fact of the matter is those people have rights. And if you were to do that in the state, they would say, no, you got to have a hearing. You got to serve that person. That person's entitled to be represented by an attorney. You have to have medical evidence. You have to have all of these things before you can do that. You can't just go do that. But we still want to just do that. A few years back, we had a council member, older member, an elder, who was in a car accident, suffered a serious head injury. He was never quite the same after that. And he his family wanted to help him, but instead of recognizing that he had rights, and our court was culpable in this, they helped in the violation of his rights. They just went to court and said, oh yeah, he's not doing good. Send him to Pathways in Whitefish, put him in there. And the court just issued an order and said, yeah, he's not doing good. Go pick him up and put him in Pathways. They didn't want to give him a hearing. They didn't want to make him come forward with the medical evidence. They didn't want to give him his rights. And so that's something we all need to remember, is that people have rights. And if it was one of us, and somebody just said, gee, Joe's acting crazy on the street, go get him and pick him up, put him and send him to Warm Springs, you'd want to have your rights protected. And so, you know, basically this says the tribe can do that, but it's got to do it by ordinance. And those ordinances, once again, have to be approved by our father, the secretary. Says the council in number P has the right to promulgate rules and regulations governing fishing, hunting, and trapping of the Blackfeet Reservation. So Chops was just asking me. The council just took an action at the request of the Fish and Game people to bar non-Indians from using tribal or Indian land along the southern end over here, along the Badger 2 Medicine, to access the Badger 2 Medicine for hunting purposes. And the reason the tribe did that is because the tribe has been active in trying to manage and promote game on the reservation. So working with Fish and Wildlife, U.S. Fish and Wildlife, and I forget the other place they got out, Yellowstone, I think, the tribe has planted elk down there in that area on the reservation, twice that I'm aware of. And of course the elk, they know no boundaries, they just go back and forth. And so the elk don't just stay on the reservation, they go into the Badger 2 Medicine too. And up until this year, if you were a hunter, you would know that the elk season in the Badger 2 Medicine, the seated strip, the state side, was you could hunt either sex, a cow or a bull, for the first 2 weeks. But after the first 2 weeks, you could only kill a bull. And the reason was to save as many cows because they would be reproducing, right? And that was an idea that was to build the herd. And that was the way it's been since I started hunting in there about 30 years ago. This year, the state came and said, we want to change that. We want to open it to either sex all season long. In other words, kill cows all the way up to the end of the season. And the tribe said, well, gee, wait now. We've been planting elk there. You guys aren't doing anything. So why don't you respect that? Let's let the herd build for a while longer and leave it the way you had it. That's good with us. Leave it the way you had it. And the state said, no, we're just going to open it up. Either sex all season long. So the Fish and Game people come in and said, well, if they're going to do that, let's restrict non-Indians from using the reservation to go in there and kill those cow elk. And so they asked for that rule and the council agreed to it. They're not saying you can't go in there, they're just saying you can't use the reservation to go in there. And the truth is, some of you know this, there's really only a couple of places on the reservation that you can access that. Up there behind what they used to call Palookaville, right up above Ramsey's along in that area, way down on the end along Badger Creek, there's a big strip there. But that's non-Indian fee land. So in essence, the tribe's regulation is more a matter of a message rather than it is a real restriction. Because at the end of the day, there was only a couple of real places that you could do it anyway. But it's under this heading right here that the council has the right to do that. We move on to Article 6, Section 1Q. That's that one where that judge in the Shell case said, oh gee, this gives the council the right to suspend its members. They have the power to adopt resolutions regulating the procedure of the council and of other tribal agencies and tribal officials on the reservation. again, the judge said, gee, that means you can suspend your own members. I disagree with that today as I did back then, but there's still a case out there that says, no, that's what it meant. Then the last
Hey, Joe,
specific,
before you go on to that one, so did the council adopt a resolution that gives the executive committee this sole authority that they exercise at times?
no. Council has never adopted a resolution giving the executive committee sole authority to do anything, period.
Why do they do it?
Power, because we're the executive committee and we got the power. And we're gonna finish this last one and then we'll talk about that next week. You think about those questions, because that's when we're gonna get a little more into this thing called the plan of operations before we go on to Article 7 on land. Because again, that's an article that we don't even really look too much anymore, Article 7 on land. It's one of the longest articles of the Constitution, but as George says, we've kind of just abandoned it by council action. We've amended it, or we've changed it. It's become meaningless because the council don't pay any attention to it. So Article 6, Section 1R says the council has the power to delegate to subordinate boards of cooperative association, which are open to all members of the tribe, any of the foregoing powers, reserving the right to review any actions taken by virtue of such delegated powers. So again, under that, the council can create the Fish and Game Committee, delegate to them their right to make regulations, etc. But then they come in once a year and say, here's the rules for this year. Council adopts a resolution accepting them. That's how that works together with the other section up there about regulating fish and wildlife activity. So those are the specific enumerated powers of the tribal council. And if I can close by just going back to what I was saying earlier about why we ended up where we were in the last 2 years, going off of Mr. Edwards' question. Has the council ever delegated to the executive committee the sole power to do anything? And the answer is no. The executive committee over the years has just assumed that power and said, oh, we're the executive committee, we can do this. And they have said, oh, we'll go get it ratified by the council later. Let's think about that for a second. They approve something, they tell somebody, oh yeah, we approved it, go do it. 3 weeks later, they bring it to the council and say, oh, we did this, we want you to ratify it. The action's already done, it's already implemented. What sense does it make to bring it to the council to ratify it? You've already done it, it's already been carried out. That becomes a meaningless act that kind of, I guess, makes the executive committee feel like, oh, we did the right thing here. Even though we didn't have the power to do it in the first place, we came back to you to get it ratified. Now, next week I'm going to have some specific examples. One of them is going to be related to our hotel up here. The whole way that's set up raises serious questions about whether there's a legal entity, whether there's a legal management contract, and whether we even have a legal agreement with Holiday Inn Express to run our hotel. So I'm going to close with this last little tidbit to get you interested. Under our franchise agreement with Holiday Inn Express, we pay them 9% of the gross profits of the hotel. Right? Gross means right off the top. No, not after expenses, right off the top. We pay them 9% plus the numerous miscellaneous fees right off the top. We pay the management firm 5%, right, of the gross, right off the top. In addition to paying a separate local manager out of the operation. And then, because of the loan that they took out, they're required to set aside a 3% reserve fund of the gross right off the top. So if you add that up, that's 17% of the gross profits of the hotel that comes right off the top that doesn't go to the tribe. And 14% of it that just goes to other people and never shows up. The reserve fund, in theory, if they've made their loan payment out of their own income every month, in theory, at some point, that might come back. But let's be honest, here in another month or two, the motel is going to have very few customers. It's going to be losing money on a month-to-month basis. It has to pay a $46,000 a month mortgage. That's what that reserve account is for. So the bank can guarantee that it's getting its loan payment. So the chances of us getting all of that reserve fund back at some time are not good. We might get some of it back if the hotel gets profitable, but we're never going to get it all back. And so if those agreements aren't legal, what does all of that mean? So I'm going to leave you with that for tonight. You all think about that, and we'll talk next time.
'14th, 1934 at the old Browning Community Hall. And the subject of the meeting was the Indian Reorganization Act. Now, because he made me honor my promise to go home and cook stew and fry bread, I didn't get to read through them real good. But in glancing through them and relying on his comments about them, it looks like the primary issue that they talked about before they adopted the Indian Reorganization Act, the Constitution at that time, was stopping the loss of land as a result of the allotments. And that was the principal discussion of the day. And during that time, the council, then there was some minutes of a meeting later on in the year on September 11th, 1934. Now we adopted the Constitution on October 19th, 1935. So this is the year before that, after the IRA was initially adopted by Congress, and they were out promoting it to Indians across America, and they were trying to get the tribes to adopt it. And then one of the things that our council did back then was that they also passed a resolution in that same, probably at the result of this meeting, asking for the Commissioner of Indian Affairs to come out to Montana and to meet with all the tribes and talk about or clear up some of the things that were in the Indian Reorganization Act. So some of the people on the council at that time were, and some of you were still old enough to remember some of those people: Joe Brown, Leo Kennerly, William Buffalo Hyde, Wright Haggerty, Medora LaBrush, Rides at the Door, James Fisher, William Kipp, Oscar Boy, James Grant, Richard Grant, Little Blaze, and Richard Sanderville. Those were some of the people that made up the council at that time, even before we had the Indian Reorganization Act Constitutional Council. So once again, when we started, we talked about the so-called carrots, the reasons they put out there for Indian people to want to adopt the Indian Reorganization Act. And it looks like, in looking at our history, the main thing that we focused on was this notion of stopping the loss of Indian land. I think there was something like 135 million acres of Indian land prior to the adoption of the Dawes Allotment Act. And even by 1935, that was down to like 80 million or 84 million. So we had already lost like 50 million acres of Indian land across America as a result of allotments, and then people both selling and being cheated out of their land and their allotted land. So with that, George had an idea. He wanted a few minutes, so I'm going to turn it over to George, and I'm going to make
Kind of been bothering me, I guess, is Joe's been, faithfully doing, I think part of one of his elected duties, and I guess not, I wouldn't say lamenting, but, has said several times that he's talked to his fellow colleagues and has invited them to come to the meeting and participate, and it probably hasn't been happening. And then he made a pitch for Welland a couple of weeks ago or more about Welland needing more resources to have more CDs to pass around, and I was thinking, my goodness, here we are probably addressing one of the more pivotal things in our history, and we're going to be wrestling up CDs for SNORC to pass out to our people. And this particular thing I'm going to share with you comes from the election laws, part of our election laws, and on the first part of that, it speaks to the issue of there are 4 types of elections that we have in our tribal election laws, and now you'll see the 4 that I mentioned: the secretarial election, the council member elections, the referendum elections, and the recall elections. And there's this other little, I guess, caveat in our election laws called the opinion survey, and it says, in addition to the above elections, the council may call for an opinion survey in order to poll the membership as provided in section 5 of this chapter. Now, as you go on to page, where I would say I'd start on page number, I had the thing on 69, it starts to talk about a process in terms of what is this opinion survey? Is it just doing an opinion? But actually, in the election laws, it's election in itself. It's done by a request of the majority of the members of the tribal council on any matter or issue. It's not a referendum. It's not an ordinance. The vote on the issue may be designed with more than 2 choices offered to the voter on an issue. The vote must be advisory to the council and must not be conclusive or binding. Fine, An opinion survey may be held in conjunction with other elections or not. But it also moves on to treat this particular type of a survey not as a survey. We're not going to hand out a survey. It actually gets into how we hold our elections. It'll allow you to create an election board. That's on page 70. You can appoint the election board, and for this opinion poll, that's on 71, section 11. It speaks to the election board to educate, and it was just kind of similar with the issue, Dale, you remember that with the museum, where you had the process where the election board's duty was to warn the voters regarding the ballot issue, if you will, the election board and the staff. At all times, of course, to be careful about neutrality, but the election board may appoint spokespersons to represent a particular side or viewpoint, in this case, whether we should move on and reform the Constitution or not. And the election board may publish materials, publish sample ballots, sponsor forms, or perform other necessary functions to fulfill its duty. There's language there that you have to state that it's non-binding. So this whole election process goes through, and at the very end on page 73, the election board must certify the results of the referendum or this opinion survey to the Blackfeet Business Council within 72 hours or the closing of the polls. Now, to my knowledge, this has never been done before, but I found it when I was an election judge and going through all the election laws and saying, what a way for for number one, to elected officials. After all, they're elected to not only uphold the laws and everything, but also to make sure that if we want to improve government, and part of it is Constitution, to get behind that and utilize proper resources to do so. And so there's the buy-in at that particular level. I think if we were to move in this process, formalize it more, start having the discussions out there, and have the resources. Number one, to have the resources. Don't have to run around for a place to have the meeting, or we'll all do crayons and do our ballots, but do it in a professional way, and perhaps if get to the point, and whether the election would be for one day for people to go to Heart Butte or what have you, for 2 days, get volunteers, and you simply go in, your membership is validated there, and you vote. In my opinion, the question would be, well, whether to reform tribal government or not. It's an opinion. They could oppose it or no. There's your no and yes, huh? And so that could happen. Maybe 2 days, 1 day, what have you. And I'm thinking in terms of time frame, maybe February perhaps, or maybe even later, to propose it to the council, start looking at the time frame. And I'm thinking near the end of June to perhaps have this survey done, and then present, if you can, the results during, just before that Thursday, during our North American Indian Days. It's a pretty good day. A lot of people come in from all different areas, and the result hopefully will say, yes, we as a people have bought in, and we believe, in our opinion, to the council, that it's a good idea to reform our tribal constitution. I believe you get to the point, you get the buy-in, and then the leadership is compelled, because they're the ones that initiate the survey, to say, let's put some resources and let's move to the next step of the nuts and bolts, and how do we do that and get it done. Whether the time frame is by 2/16 or beyond. So I just offer this as perhaps a proposal. We're moving forward to take advantage of the language and the process that's already in place. I think it's non-binding. It's called an opinion survey, but it allows us to follow the mechanics of an election process. Now, I haven't done the numbers of what it would cost, but I'm sure that can be done. I talked with Becky a little bit about it today, but I think we can get it done, and I think the important part would be, before you have the election, would be having these community forums. Perhaps there would be people who say, this is not a good idea, I'm against touching the Constitution, and then we can have the pros and cons. Let the people get the ownership of this and start having those discussions out there, and then when we're done, let's vote on it. And again, it's non-binding, but I think it gives cover, if you will, to the political side of our leaders to say, this is what the people have said to this process, and I think as a governing body for the people, we need to move forward then. Maybe we can, and of course, we may not please everybody, but this is an idea I just wanted to share with you. It's been there, and to my knowledge, this particular election process has never been utilized, so kind of think about it, but I think in terms of moving forward, we formalize it, there's a buy-in at two particular levels, and if our people, for the majority, say we think it's time to reform the Constitution, it allows more than just Jim McKay's idea, or George Heavyrunner. Hopefully it's bringing the community together. You know, it's almost like February 26th to the 28th. We're all going to be wrestling up, and we've got one common mind. Let's go into the divisionals down in Great Falls. We got that organized. You know we're going. We know we're going to be run, and we have a goal. And hopefully our goal is that our team representing us is going to go to the next level, and we'll plan and move on there. So that's where I'm at. I just wanted to share with you that, something for Joe to think about. If there needs to be a point to bring this to the legislative body to consider, I'd be more than glad to do the groundwork in terms of the cost. But why not for our tribal government to take responsibility to provide the resources to get this done? After all, it's their constitution too, and it just bothered me when Joe's here, then Roland has to go rustle up CDs. My goodness, such an important issue, and we shouldn't have to be there. I mean, this is an important thing, not for us here, but for our future generations. And why not put some treasure into it and get this moving and try to get our people on board. So I guess I'll just leave it at that. Joe, was just an idea that I wanted to throw out on the table.
Well, I'll offer my own comment, and then I'll ask all of you what you think. And first, let me say that I believe museum vote really was the first opinion vote under that, after the late Vicky Santana wrote our original election code. And it was an opinion vote. I was actually the one that initiated that as a member of the council to put it in front of the people. And of course the people voted against that, and so the council refused to take over the museum at that time because the result of the opinion was don't do it. I like George's idea. I personally think it's a good idea for several reasons. First is that going back to when we had Kerry come in and talk to the council, I don't know if any of you saw that on the TV station about 3 months ago, was it? Back in October, I believe. Was that when you came in, Darrell? And Darrell actually went first, and he kind of got some heat over it, but I think Darrell had an excellent response, and that response was, I'll bet if we put this to a referendum vote again today, the vote would be just as overwhelming, if not more so. And during that time, the majority of the council indicated their support. Now, one of the things I've kind of heard indirectly, because we don't really talk about it, is that some of the council were saying, well, but we have all these other problems to work on first. So if we put this in a time frame similar to what George has talked about, you know, you should be able to say, well, you've had almost a year to work on those problems, haven't you? And so isn't it time to maybe focus on this other thing and give it a chance to get started and show your support? And my own sense, though, is that, you know, we do, just as a matter of information, have several members leaving on the 26th to go back to Washington, D.C. to try to get our water rights off of dead center. So the February might not be the best month. I would say we'd probably give ourselves at least another month, in part so all of you and whoever the other people that have been here can politic the council, and you know how that goes. Many years ago, the first time as a young man when I was 17, and we got invited to the first Kiayo Indian Club youth conference, and I went to my dad, and he wasn't on the council, and I said, well, do you think the tribe would help us? And he said, I'll tell you what, one word disappears from every council person's vocabulary when you're sitting right in front of them. I said, what's that word? He said, no. He said, so you get your group together and those high school kids, and you go down to the office and you meet with every council person you can, and I'm willing to bet that they'll all tell you yes while you're sitting right in front of them. And he was right. So that'll give us an opportunity, you all an opportunity to go in and talk to the council about, you know, we're not asking you to make a commitment for a referendum, just give the people a chance to express their opinion. It's been 6 years, so if, in case there's any doubt, give them a chance to express their opinion on whether they want to go forward with reform. And I guess I would tend to agree with Darrell's comment of October. My sense is if we got that to a vote, the vote would be overwhelming again, that people want to go forward with reform. And so I think that's a good idea. Now the only thing is, let's be real honest, several of them are pretty tight with their purses, and so whether they would get off of any tribal resources afterwards might be another issue. But at least we'd have maybe the sanction of the people to go back out and start looking for other funds instead of just being a group. And so I think that's a good idea. Anybody else got any thoughts about that? Darrell?
So where does that place the referendum? It's already been passed for the people who did say that they wanted to referendum.
Well, as we've talked before, Darrell, my own take on the referendum was that it can be argued, as the BIA did in a letter to the council back in that I think in 2010, that the constitutional effort had gone beyond the referendum. And so this would be a way of simply reinforcing that and broadening it to ensure that it's not just about that kind of vague concept of separation of powers, as we've talked before, what does that mean? It means different things to different people. To a lot of people, that's just separating the court out, but it still leaves a whole bunch of power vested in the council itself. And so if the idea is checks and balances, then constitutional reform rather than just separation of powers becomes a broader mandate. And I think, as George said, and I agree, it's been, and I've said it myself, it's been 6 years. You give people a chance to reinforce their commitment and maybe buy back in. 6 years ago, there was a group of people that were from between 12 and 17 years old. Now those people are 18 years old and older. The generation's changing. And so you give those people a chance to buy in and become a part of it. And so to me, that's a legitimate approach without having an outright referendum and without the council or a secretarial election and without the council feeling like they've been pushed into something, but rather that the people have expressed their concern and just as you said to the council that day, they've reinforced their commitment. And so to me, that's what you get out of it. And maybe the other thing we get out of it is that re-buy-in to the effort. And now that I voted on it, I want to be a part of it. So we were just talking, Huggy, that George had taken a look at the election rules, and we've talked a little bit about this before. But besides secretarial elections and council elections and referendum elections and recall elections, under the election ordinance there's something called opinion votes. And really that's what we did when the proposal was made to take over the museum in the 1990s. And we put that to an opinion vote, and the people voted it down, and so it didn't happen. It wasn't, at the end of the day, binding on the council, but still the council took its direction from the people, and it was voted down. So George was proposing that we maybe have an opinion vote, which still has to be, the main issue there is it still has to be put to the vote by the council. It's not something like a secretarial election or even a referendum that can be brought about by petition of the people. And so maybe that's a way of getting the council to honor its commitment, because as many of you have pointed out, the majority of the council at one point or another said they supported reform, but yet they're not active participants in reform. So maybe this is a way, and again, maybe we don't have to make a commitment to ourselves even tonight, but it's out there for discussion to say maybe we should think about doing that, and maybe shoot for March or even April to get it started. Now the other thing to me that's kind of attractive about it is that, let's be honest, even in the last effort, and you mentioned it also, that there are those people out there, and they're entitled to their opinion, that we're all entitled to our opinion, who are simply against any kind of constitutional change, period. And so one of the things you get in an opinion vote is that, and that's what, if you remember right, that's what happened on the museum. There was a fact sheet, if you will, of those who were against it, and a fact sheet from those who were in favor of it. So this would give those that are against constitutional reform of any kind an opportunity to have their own voice and make their argument and say why we shouldn't do it. Would give those of us who are in favor of it an opportunity to do it and put it out to the people as a whole. And whether you did it by a mail-out ballot that people could mail back in, or you did it by an actual, just like the chairman has even talked about a kind of a survey where you just set up a polling place in every community, one place. Polls open from 8 o'clock to 8 o'clock, you show up, you've only got one thing to vote on it, you vote on it, you're done. And you only, when it comes to counting, that ain't much to count. So, again, it's just something to think about. It's an idea we don't have to act on it or move on it right now, but it's a way of maybe regenerating interest in the effort. So, before you came back, I mentioned the documents you had given me, because when we started out, as I was just noting to the folks, that we started by talking about why we adopted this Constitution in the first place, and that you had found these minutes going back to 1934, in which at a community meeting or a couple, the council had talked about adopting the IRA Constitution, and the main issue was land, preserving our land base and stopping allotment. I didn't get a chance to, as I said, to read through it all, but in glancing through it, just the very end kind of caught my attention, because they were having this meeting, and someone said at the end, well, when are we going to do this? And the chairman at the time, Joe Brown, responded that it won't be until we all decide. It'll be a long time. Tomorrow, we're going to meet at Old Agency, and the next day at Heart Butte Station. And he goes on to say, you're all invited to come over and listen to the Windjammers. In other words, all them long-winded folks like us, I guess, who like to get up and talk. But so even then, there was a notion that's kind of been lost of involving the people, reaching out to the people for their opinion. And again, in George's idea, may be a way in this era of doing that in a shortcut fashion that sends a message to the council and to the community that this is what people want. And like I said, give people a chance to reinforce their commitment. And as I was just saying before you came in, that that was in 2008, 6 years ago. 6 years ago, there were a group of young people that were between 12 and 17 years old that today are between 18 and 24 that never got to participate. And so this is another way of maybe reaching out to the youth and getting younger people, because as we all said, again, I don't mean to be mean to us all, but let's look around ourselves and, gee, we're all of a little older generation, right? And this Constitution, if we do it, is going to outlive all of us. It's going to be their government. And that's maybe the sell we need to make to them, is it's just about their future and their government and their children. Just like it was in 1935 for those people, my great uncle Joe Brown, it was about his ancestors. I know Gertie remembers probably some of those people, but even some of us here today, I was telling Puggy, I was fortunate enough to know Leo Kennerly, Wright Haggerty, Bill Buffalo Hide, and some of those folks that were there at the time. And so, again, it's just a way of trying to reach out to people and to try to regenerate. Now, I know that even though he's not here tonight, and I want to give him credit for being a part of this effort, I know that Mr. Jarvis, we talked last time about this very thing. George wasn't here, but we talked about maybe doing surveys or something to get people's interest. And I saw that Fish had posted something about maybe a survey question we could do, a single question. It was, do you think the Blackfeet should have their own border crossing? And I believe it's the Mohawks out in New York have their own crossing. And so those are just ways of trying to get people more engaged in current day activities, rather than kind of just sitting back and doing that same old thing about, well, is this the worst or just the second worst council we ever had? And so it's just ways of getting people involved and engaged, because And I'm going to end with that, and then we'll go back to talking a little bit about what we're doing here.
I just make a comment, Joe. I just, you know, the more I think about it, just listening to you and listening to George, I really think that it could be the vehicle, you know, to get the momentum really going and to get a lot of people involved in the conversation, whether they're involved here at a meeting or not. You know, they'll be involved in a conversation at home or in their own groups, but I really think it's a good idea the more I, you know, so maybe we could put it on the agenda for the next meeting and
Talk about it.
And maybe come to a decision, because, you know, I guess just at a glance, there is a process that has to go to a council, and it looks like next you have to appoint an election board, or, you know, get our process in place, and, you know, I'm a big timeline person, get it,
You know, you're right on, you know, and the discussion, and getting the last group together, and it was very difficult. They were having a difficult time, just a few people showing up at meetings to try the community approach, and it just wasn't there. So a catalyst of that nature, you know, like this opinion, I think would be a great way to get, kind of revive that interest. So I think it's an excellent idea, George, you know, to make that happen. If we can find a way to just simply, are you for
and I think the other thing, what I've learned in the reports that I do to the people, right after I do those reports, if you look at what happens on Facebook, is it just generates a whole lot of discussion, and people get engaged. You give them a chance to get engaged by giving them information. So like, why don't we do that next time we meet? We'll talk about that and see if we can arrive at a consensus, and if we can, then we'll start working on that. And again, I don't think this February meeting would be the one to shoot for the council, but maybe March, and to try to go forward from there. So we've been talking about our own Constitution, and for those of you who have just come in the last meeting or two, we've actually gone through every article of our Constitution. We've gone through pretty much the whole plan of operations at this point, talking about why it just doesn't work. And we've been using the context of what happened over the last 2 years, starting in August of 2012 and until we had this election. Now, I want to make an observation about that in terms of what's going on, or people's involvement now. I think I said this before, but I'm going to say it again. Remember that during that process, during that time, when the group of four, as for lack of, I don't want to be derogatory to anybody, the group of four were doing business at the cabin up in the museum, and the group of 7 were down here. And the night before, they had the big standoff. Remember that? When the police showed up there and wanted to evict the group of 4 and threatened to arrest people and whatnot. The night before that, a group of people, only 2 of whom I think are in this room tonight, had a similar meeting up there to talk about constitutional reform, and they invited me up there. And one of the things I said to them is, we have to be careful. Here's what happens. We go through times like this, and then we have an election, and we elect what people think are a fairly decent group of people, and they actually start working together, and then suddenly we all go, oh gee, it's really working. We don't need to change the Constitution, and constitutional reform doesn't become a priority anymore until everything falls apart, and suddenly we go, oh yeah, we need to do that. So in my own view, in a little bit, that's kind of what's going on now. People look and think, well gee, the council is kind of working together, they're kind of doing things, and it's not a priority for them anymore, and we all move on with our own lives and get caught up in our own lives. But really, as I've said before, it only takes a little bit for the wheels to fall off again, doesn't it? And to go back to square one and have all that turmoil. It doesn't have to be that bad, but still it gets to the point where nothing gets done, or too many favoritism and all of those things take over, and fairness goes out the window. So we have talked about our whole document, pretty much our whole plan of operations. We've talked about the thing that really got us in this trouble is why we want to change our Constitution, and that is that thing called separation of powers and checks and balances. And so, to me, that's what brought us all here, that single word, power, and the use and abuse of power. Who's got the power, and what did they do with it? And did they act appropriately? And if they didn't, did we have some place we could go to hold them accountable? And we didn't have any place we could go. Both groups tried to go to the court. Both groups went to the Bureau of Indian Affairs. Nobody did anything. To me, it's been an interesting example to watch. I know the gentleman. I actually represented him during the first fight, but it's been interesting to watch what's happened at Rocky Boy. You're all aware of that, right? A gentleman by the name of Kenny Blatt, St. Mark's, has won 2 separate elections to be the chairman of the Rocky Boy tribe. And the tribal council, though, simply refuses to seat him. He's telling him, no, you're not on the council, you're not going to be the chairman, we kicked you off again, you're done. So he went to court, went to Rocky Boy court, and they ordered a new election, and he ran again, and he won again. They threw him off again, and so then he went to the BIA. And the BIA, I don't know if you read just recently, like about a month ago, the Solicitor or Interior issued an opinion saying, well, we think that Mr. St. Mark's is protected by the Whistleblower Act and provisions of Mr. Obama's law, the American Recovery Act, where he invested in America, and the people that got that money were supposed to do certain things, and if they didn't and you told on them, you were protected. And so what did the council do? They sent a memo and said, we order you to reinstate Mr. St. Mark's and pay him back pay. And what did the council do? No, we're not going to do that. We're a sovereign nation. We can do whatever we want. You can't tell us what to do. This is our Constitution. And so even in that setting where the government, like everybody was saying here, remember over these past 2 years, oh, the BIA should do this, they should side with this group, no, they should side with that group. Well, down there the BIA stepped in and took a side. And the council went, nah, that don't count. We're a sovereign nation. We can do whatever we want. They might well be right in that sense. There's a body of law that says acts of Congress only apply to us. If Congress specifically talked about Indians and said, yeah, we want that law to apply to Indians. So, for example, that law that some of you may have relatives that fall into this, called the Americans with Disabilities Act. You've all heard of that? That's what requires public buildings to have walkway ramps for wheelchair people and special bathrooms for handicapped people. There's a ruling that says that law don't apply to Indian tribes because Congress didn't specifically discuss Indians and its application to Indian tribes, and therefore it don't apply to us. So unless the American Recovery Act, and there's already been opinions saying the Whistleblower Act probably doesn't apply to us because it's a federal law. Rocky Boy Council might be right. And poor Mr. St. Mark's, even though he's had the majority vote of all of these people, might never get to take office. even though he's won 2 elections already. So at the end of the day, their constitution is much like ours. It's not exactly the same, but basically it's a one-branch form of government. And that's why they continually tell, unless it favors them, they tell the tribal court, well, you can't really do anything either. We kicked him off. We're the council. So with all the power in a single branch of government, that's why things don't work. And when people start fighting over that power, or it goes to someone's head, then that's what makes things even worse. For many years, but gee, ever since I was young, I think every generation can remember that there was always then discussion about, one of the ways to solve all of this is to hire like a tribal administrator, right? Let's hire a tribal administrator, and gee, that person will make everything right. And at one time, some people, and the reason I'm bringing it up is I don't know if you all read this week's Glacier Reporter. Does anybody see that? And maybe the guy was so out there when the fight was going on that he lost credibility and nobody reads what he writes. But there was an editorial in this past week's Glacier Reporter by Greg Paisley. And remember, Mr. Paisley wrote articles back when the other thing was going on. But the gist of his article, his editorial opinion, was that we do need change, but you didn't have to change the Constitution. You could fix tribal government just by hiring, his idea was 2 people, a business manager to run enterprises, and then like a tribal manager to run tribal government. And that's not a new idea, is it? For those of us who have been around tribal government, that's not a new idea. In fact, the first one I can remember, and there's probably ones before that, was the late Elvin Pollock, Buster Pollock, in the late 70s or early 80s.
Dan Dockstetter,
And he came after Buster.
and that lady, that barn.
Yeah, so first though was Buster. He was the tribal administrator. Elma was naming some of the people. Then after Buster was this guy named Dan Dockstetter. And then more recently, I believe in the late 90s, was this lady by the name of Patty Barnes, Patricia Barnes. And so what happens though when those people come in, they start to do things, then we have an election, right? And the new members of the council go, oh no, we got the power, not her or not him, and so here's your walking papers, we'll see you. We just took our power back. Because there's no separation of powers to stop that from happening. It's not written into the law, it's the council's law. The council takes the attitude that law is only as good as we say it is. And if we say it ain't any good anymore, then it ain't any good anymore. So to me, that's why, that's an idea that in theory would work, but in practice doesn't, because it runs headlong into that other thing called power. And who's got the power? I got the power. We got the power. And here's the other thing that happens, Let's be real honest about that. Sometimes those people start doing good things. But when you do good things in tribal government, generally you're stepping on somebody's toes who hasn't been doing their job or hasn't been doing it right or whatever. And the minute you start stepping on those long employees' long toes, they get mad about it, And they start undermining that person. They can't wait for a new council to come in. So they can go to that council and say, oh yeah, that guy Joe's no good. He's doing this, he's doing that. And pretty soon the council buys into that because it plays into that power thing. And they go, oh yeah, well, it's time to get rid of Joe. Time to get rid of the manager. Well, we can do a better job than that. And they get rid of them, and nothing changes. We go back to that more or less inefficient form of government that we have today. I think that's the one other thing most of us believe, is that government doesn't run, the council, the system doesn't run as effectively as it could run. So that to me is the issue with Greg Paisley's suggestion. The last thing would be that we had gone through all of this and we had gotten down to the point of, this is the, I don't even think I got a whole one here. The last document that we have that we haven't gone through was our corporate charter. And as we talked once before, there's the three basic what constitutional law people call organic documents, meaning documents that we run our government by. The first one was the Constitution. We've gone through that. The second one is the Plan of Operations. We've gone through that. And the last one is the Tribal Charter. And just in my own opinion, and for those of you who have been involved, the Tribal Charter is probably the least followed and least understood of the documents that we have. It's the least referenced document that we have. But nevertheless, it's a document of the tribe. And in theory, the charter is that document under which we're supposed to manage not only the enterprises of the tribe, but money generated by those enterprises. So the tribal charter, while it's adopted separately, really comes into play someplace else first. You know, it's really called into play someplace else. So Article 6 of the Tribal Constitution powers of the council says that the council have certain powers, and Article 6 Section E right there says the council has the power to manage all economic affairs and enterprises of the reservation, including all oil leases on tribal lands and the disposition of oil royalties from tribal lands, in accordance with the terms of a charter to be issued to the tribe by the Secretary of the Interior. So that's where the charter initially comes into play. But the council itself, way back in the 1936, they didn't get to adopt the charter on their own. In other words, the council didn't get to say, we're going to pass a resolution and we're going to adopt the tribal charter by that resolution. There had to be a referendum vote on the charter too. And so the people voted on the charter in the same way that they had to vote on the Constitution. And so according to the charter, the last part of the charter, it's certification. says that the charter to be effective from and after this date of its ratification on a vote of the adult members of the tribe living on the reservation, provided at least 30% of the eligible voters shall vote. Such ratification shall be formally certified by the Secretary of Interior. There's the certification. It said, pursuant to Section 17 of the Act of June 18, 1934, this charter, issued on July 18, 1936, by the Secretary of Interior to the Blackfeet tribe, was duly submitted for ratification to the adult Indians living on the reservation, and was on August 15, 1936, ratified and accepted by a vote of 737 for and 301 against. So the charter wasn't just passed by the council. It was voted on by the people, and it looks like about 1,038 people voted on the charter, and 737 of them voted in favor of it. So the charter didn't come into play just by action of the council. It came into play by action of the people by a majority vote. And as I indicated, at least in theory, the charter states that, or the Constitution states that the charter is supposed to be the vehicle through which the tribe manages all enterprises of the reservation, including oil and gas leases and income. So what is the charter? The charter, in my own view, was the effort of the government at that time to create a business entity. And just like a state corporation, that they wanted to form a state corporation or in that nature, except it became a federal corporation. And so they issued us this charter that's patterned after, but it's not the same. It's like a public corporation out there in corporate America, where in theory the people would be shareholders and whatnot, and the governing body would become the corporate board. So corporate existence, the charter says, in order to further the economic development of the tribe and the reservation by conferring upon the tribe certain corporate rights, powers, privileges, and immunity, to secure for the members of the tribe an assured economic dependence and provide for the proper exercise of the tribe of various functions heretofore performed by the Department of the Interior, the tribe is hereby issued as a body politic and corporate charter of the United States of America under the corporate name, the Blackfeet Tribe of the Blackfeet Indian Reservation. It goes on to say, like many charters in corporate America, the next thing is, how long is it going to last? It says the tribe shall have of the Blackfeet Indian Reservation shall, as a federal corporation, have perpetual succession. In other words, it'll last basically forever or until otherwise repealed, as the charter sets out. Now, George pointed out to us at one of our earlier meetings that in order to actually revoke the charter, that actually takes an act of Congress. That Congress itself has to revoke the charter. That the people can't, the council can't, that the council or the Congress has to do it. We can ask them to do it, we can submit a resolution to them to do it, but Congress actually has to revoke the charter of the tribe. It says in Article 10, I'll jump forward real quick in that regard, this charter shall not be revoked or surrendered except by act of Congress. But amendments may be proposed by resolution of the council which approved by the secretary shall be effective when ratified by a majority vote of the adult members living on the reservation at a popular referendum at which 30% of the voters vote. As we talked about before, that's two things. First, only Congress can revoke the charter. Second, we can amend it, and the standard to amend it is a little different than a secretarial vote of the Constitution. On a secretarial vote to the Constitution, everybody, even people living off the reservation, have a right to vote. But if it's on the charter, only the people living on the reservation have to vote. And so there's a change in that regard. But once again, in order to completely revoke the charter, we'd have to ask Congress to do it. In fact, George brought in, I think I still have a few of them, an example of a tribe that actually voted to do that, and then Congress passed a law revoking their charter. But if we then go back to the next section after succession, meaning how long are we going to be in business, membership. The Blackfeet tribe of the Blackfeet Indian Reservation shall be a membership corporation. Its members shall consist of all persons now or hereinafter entitled to membership in the tribe, as provided by its duly ratified and approved Constitution and bylaws. So in theory, every member of the tribe is a shareholder in the corporate entity. And again, going back to why we're talking about change, management. The Blackfeet Tribal Business Council, and established in accordance with the Constitution and bylaws, shall exercise all corporate powers hereinafter enumerated. Once again, it doesn't say the people shall exercise those powers. It doesn't say some other board shall exercise those powers. It says the council shall exercise those powers. It goes on to say corporate powers. And this is one of the things we'll look at real quick here, something that comes up all the time. And the council has, over the years, simply ignored it. And that's one of the reasons to talk about change. The tribe, subject to any restrictions contained in the powers, Constitution, and laws of the United States or in the Constitution and bylaws of the tribe, shall have the following corporate powers in addition to all powers already conferred or guaranteed in the Constitution and bylaws. To adopt and use a corporate seal, not a big thing, just all corporations have a little stamp that they use that signifies who they are. Number 1 or 5B, to purchase, take by gift, bequest, that means through inheritance, or otherwise own, hold, manage, operate, and dispose of property of every description, real and personal, real property meaning land, subject to the following limitations. In other words, the corporate entity has the power to own land, to own property, and to acquire that property in any way or dispose of it in any legal way, subject to the limitations contained in the Charter. Here's the first one. Everyone has always talked about this. I've brought it up to councils in the past. It says no sale or mortgage made by the tribe of any land or interest in land, including water power sites, water rights, oil, gas, or other mineral rights, now or hereinafter held by the tribe within the boundaries of the reservation. No sale of any other capital asset of the tribe exceeding in value the sum of $10,000 may be made unless approved by a majority vote at a referendum called by the Tribal Council as provided in Article 9 of the Constitution of the tribe. Now let's take that second clause, and I've used this example to you all before. If you look on the internet or even in the newspaper, the Great Falls Tribune, or any place else, You buy a new truck today. The tribe goes out and buys a new vehicle for, just for the sake of example, for fish and game. Chances are they're going to pay $35,000 to $40,000 for that new truck in today's prices. You use it for, let's say, 3 years, that truck does what we call depreciates, meaning it loses some value and gets run down. So you say, well, Fish and Game needs a new truck. Let's go trade their truck in and get them a new truck. Well, if you looked under Kelly Blue Book and looked up a 2011 Ford F-150 Super Cab 3/4 ton 4-wheel drive truck, chances are its Kelly Blue Book value is going to be more than $10,000. So according to that, though, we can't dispose of that truck without a referendum vote. But everybody here knows that that happens routinely. The tribe does business in that way. I'll give you another example that to me is affecting our community right now. Now, there are those, including the lawyers, that would disagree with me, but this is my interpretation. In the late 80s, middle 80s, we, the tribe, put up about $800,000. We bought the old bank building and we started our own bank. We were the first tribe in America to start our own bank, the Blackfeet National Bank. In 2002, the council voted, and so the bank, in order to have a bank, you have to get a federal charter. And it's that charter, a banking charter, that allows you to do business as a bank. So that charter in itself has a value. Now that sentence says capital asset. In accounting terms, a capital asset, generally speaking, is an asset that has a value of more than $5,000. That's a capital asset. And so the council in 2002 voted and they sold the bank. They sold the building. I'm willing to bet that building was worth more than $10,000. And they sold the charter, which in my the tribe, but there was no referendum vote on that sale, was there? And then what happened was that over the years, the Native American Bank Corporation, which is headquartered in Denver, Colorado, moved the business to Denver. So if you go down to the bank today and apply for even a car loan, something that way back in the day, even before we had the bank, when the late Stu Miller was in the banking business, you go down there and talk to Stu, fill out an application for a loan, give him your financial information, your work history, etc. Stu could give you an answer by the end of the day if they would give you a car loan or not. They approved it right here. Same with those of you who are in the ag business. You went down and took out a loan for ag efforts, and they might take it before their board depending on how big the loan was, but you got your answer right here. Today that all has to go to Denver to be reviewed and approved. You go in to make your payment and say, I want a balance on my loan. They say, wait now, we got to call up Denver to give you that balance. So we've lost the notion of community banking. And to me, a bank, and especially in our community, is an important function to help build an economic base in the community. So again, that's in the charter. And does the council always follow that? Probably not. So that's why we're talking about change, the need to change, to put some checks and balances in, to create a separation of powers where you have some place to go if the council is not doing right or you don't believe they are. to at least bring that in front of somebody, the tribal court, to do that. And if you have a complete separation of powers between legislation and administration, then maybe you don't even get to that. And as we talked before, maybe the rest of that change is we need to think about how valid this charter is, and if it's going to be of creating a separate board from the council to give there some balance there, and that a board that's geared toward nothing but business instead of business and politics. Because when you mix politics with business, generally commercially producing quantities. In other words, so long as enough oil is coming out of that ground to be commercially productive to the operator, the lease can go on. And so that might be 5 more years, it might be 10 years, it might be 25 years. Now the other thing is that commercial leases, like for example, if someone else, not us, but someone came in and said, we want to build something here, we want to build it on tribal land, but it's going to be our thing, but we'll pay you a really good lease for your land. Now, if they were going to build a big structure, then that falls under the heading of substantial improvements. So in theory, that lease can be given for a longer period of time. An example of that in a different way might be these rights of these utility rights of way that go through the reservation. For example, AT&T, that telephone and communications company, they just approached the tribe last summer, and their right-of-way was up for renewal. In the 1990s, they came in and they wanted a right-of-way, and they wanted it for 50 years. And the council told them, no, we'll give you a 20-year right-of-way. And so that 20 years ended this year. And they came in and met with the council, and the executive committee gave them a 6-month extension. But they're actually asking for a 50-year right-of-way, saying that, oh gee, we put this big expensive cable in the ground, and that's what gives us the right, or the authority, gives you the authority to give us a right-of-way for longer than just 10 years. So that's yet to be resolved, but those are the kinds of things that speaks to. The next limitation on the council's power under the tribal charter was that no action shall be taken by or on behalf of the tribe which is in conflict with regulations authorized under Section 6 of the Act of June 18, 1934, or in any way operates to destroy or injure tribal grazing lands, timber, or other natural resources of the Blackfeet Indian Reservation. So in other words, the council can't do anything. I believe Section 6 is that section which stops the sale of tribal land or the loss of land. So it goes on to say that the council in theory can't do anything that operates as to destroy or injure tribal grazing land, timber, or other natural resources of the Blackfeet Indian Reservation. Let me give an example that everybody probably has a different opinion on or answer to. Everybody's heard of this thing called fracking, right? We talked about it in our last meeting. Someone asked about the pending oil and gas deal. For those of you who don't know, fracking, and what fracking is today is it's all water. It used to be a concept called sand fracking, that they didn't do it for as long a distance, but they shot sand down into the ground in the hopes that it would break up the shale underneath the ground, and if it had oil in it, that oil would then come up. Well, they stopped doing sand fracking a long time ago. Today, the only kind of fracking they do is water fracking. So what they do is they believe, for example, that way down under, let's say 7,000 feet below the surface of the earth, that there's a layer of shale there, and that shale has oil trapped in it. And it's not like the big pools of oil like that we used to have down on the east end, where all they had to do was drill a hole in the ground and hit that pool, and the oil would basically come out. The theory of this is that oil is trapped in that shale. And so they drill a hole down into the layer, and then they turn it and they drill sideways through that layer of granite or shale. And then they pump water down that hole, high-pressured water. And it's not just water, but they mix chemicals with that water. I don't know if any of you watch those TV shows or even news shows where people turn on their faucet, stick a lighter under it, and it lights up. And they say that's the result of fracking. That gas that's under there gets loose also, and it seeps into the water table and comes up through their wells. So when they frack a well, I asked this question to the company. I was told that they pump about 600,000 gallons of water down that hole in an effort to break that shale up. And they mix chemicals with that water to help dissolve that shale and get the oil to come out. Now, what we don't, and once they do that, of that 600,000 gallons, 80% or 480,000 gallons of that water stay in the ground. Only 20% or 120,000 gallons come out. Now that water that comes out, we can say with some certainty that they can't treat it and make it usable again. What they do is they put it in waste pits, and they supposedly seal them so it can't seep back in the ground. And in theory, through the sun, like you've all seen these ponds like on the reservation that dry up in really hot years. In theory, the sun would evaporate that water off, and the toxic chemicals stay trapped in that area. However, that doesn't account for the 480,000 gallons of water that go under the ground and don't come back out. They don't know what happens to that. There's no scientific proof that it doesn't seep back into the water table and eventually end up in somebody's drinking water or somebody's stock water, or even doesn't come back up in terms of the plant life and growth. So I don't know, does that practice destroy or injure tribal grazing, timber, or other natural resources? I don't know. According to the current Secretary of Interior, Sally Jewell, there's not enough science today to say one way or another. Now here in America, we don't even make the companies disclose what chemicals they're putting in that water. At least up in Canada, they make the companies up there post a list of the chemicals that they're using in that water. And so the people when they're drilling their own water well or whatever, want to test that water and it has those chemicals in it, they can say this came from fracking. So here we don't even make them do that. Now they still allow them to frack in Canada, but at least they make them disclose what chemicals they're using. So we don't even make them do that here in America. The charter goes on to say that the council has the power to issue interests in corporate property in exchange for restricted Indian lands. In other words, they can trade corporate property for individual Indian land or whatever. Many of you may have heard of land trades. You might even been a part of a land trade where people try to block their individual little pieces that we all have up into a single block that they can actually use. Goes on to say, now this is where, when we talked, remember before we started tonight about those carrots, why they wanted us to adopt the Indian Reorganization Act. And one of them was this notion of credit, of a credit program. So we have the power to borrow money from the Indian Credit Fund in accordance with the terms of Section 10 of the Act of June 18, 1934. Now if we stop right there, I believe, Kenny, we've pretty much ended tribal credit in that terms of borrowing from that fund, isn't that right? Yeah, the government abolished that particular fund about 6 or 8 years ago, or more recently.
I think it was longer than that.
Oh, maybe 2000 or so. So even that part of this law is not there. But for those of you old enough to remember, that's when you could go to tribal credit and borrow for agricultural loans. They had the old revolving loan fund. We'd borrow from the government, we'd lend it to people, we'd pay the government back, and then we could re-borrow it again. So they abolished that fund. We don't have a revolving credit fund anymore. It goes on to say that the council could borrow from any other governmental agency, from any member of the association or members of the tribe, and to use such funds directly for productive tribal enterprises, or to loan money thus borrowed to individual members or associations or of members of the tribe. In other words, we could still go borrow money. The main source of borrowing today is the self-insurance program. Anybody that got a Christmas loan, for example, that money came from the self-insurance program. Now I have to give credit for that. It's better than the council, and that credit at least pays back that money. The tribal council doesn't. It just borrows it, and there's no note to repay it, no repayment plan. So in addition, that goes on to say, provided that the amount of indebtedness to which the tribe shall subject itself shall not exceed $100,000 except with the express approval of the Secretary of Interior. So even today, if the tribe takes out a major loan from an outside source, it has to get approval from the Bureau of Indian Affairs to do that. That still holds today. Says the tribe has the power to engage in any business that will further the economic well-being of the members of the tribe, or undertake any activity of any nature whatever, not inconsistent with law or any provisions of this charter. In other words, the tribe had the authority to start the store, to start the hotel. The casino is a little bit different, and I'm going to end the night talking about that here just in a second. So that basically says the tribe can engage in business for profit. The council has the power to make and perform contracts and agreements of every description, not inconsistent with law or with any provision of this charter, with any person or association or corporation, with any municipality or any county, or with the United States or the state of Montana, including agreements with the state for rendition of public services, provided that any contract involving payment of money by the corporation in excess of $10,000 in any fiscal year shall be subject to the approval of the Secretary of Interior or his duly authorized representative. So that just says the council can do business with the government and can do business with the state of an economic nature, but if it has to do with paying anybody more than $10,000, again, we have to have the approval of the Secretary of Interior. So as the council, for the purpose of obtaining any loan, to pledge or assign any chattel, that just means something you can carry or move, like a vehicle or something like that, purchased with the proceeds of such loan, or any income arising from activities of the tribe financed by the proceeds of such loan, or any income due or to become due on any notes, leases, or contracts taken as security for the re-loan by the tribe of the proceeds of such loan, whether or not such notes, leases, or contracts are in existence at the time, but no pledge or assignment shall be made to any person or agency other than the Secretary of Interior without the approval of the Secretary of Interior. All that really means is, like, we've all gone, or if you've ever gone and bought a car, and you buy it on credit, the bank or the finance company takes a security interest in your car. And if you don't repay, one of the things they come do is repossess your car. All that really means is that the tribe can enter those kinds of loans. And in theory, however, if it's not with the government, then it has to have the approval of the Secretary of Interior. And once again, today, in today's modern world, in terms of the government's role, it doesn't check every loan the tribe makes for a vehicle or a copy machine or whatever it is. They don't require approval of those kinds of loans. It says the council has the power to deposit corporate funds from whatever source derived in any state national bank to the extent that such funds are insured by the Federal Deposit Insurance Corporation or secured by a surety bond or other security approved by the Secretary of Interior, or deposit such funds in Postal Savings Bank or with a bonded dispersing officer of the United States to the credit of the tribe. And that's just really saying that the tribe can put its money in a bank or somewhere as long as it's protected. It has some basis that if that entity goes broke, the tribe can still get its money and still going to be protected from losing all of its money. Number I, that the council is the corporate board, has the power to sue and be sued in courts of competent jurisdiction within the United States. But the grant or exercise of such power to sue and be sued shall be not deemed a consent by the tribe or by the United States to levy of judgment, lien, or attachment upon the property of the tribe other than income or chattel expressly pledged or assigned. In other words, going back to that simple car loan, we borrow money for a car, something happens and we maybe lose our job or something and we can't pay, and we've just started the loan, and the bank comes in and they repossess your car and they sell it in what we call the secondary market, and let's say you still owe $10,000 on it, and they sell it and they only get $5,000, and they come back and they sue you and say, oh well, we foreclosed and we repossessed your car and we sold it, but you still owe us $5,000, so now we're going to sue you for that $5,000. Well, what this says is they basically can't do that to the tribe. Once they take that piece of property back, that's it. That's all they get. They can't sue you for what we call a deficiency judgment. Finally, it says the council has the power to exercise such further incidental powers not inconsistent with law as may be necessary to conduct corporate business. That's a standard provision in corporate America or corporate entities. It just says you have the power to sign documents, more or less, and whatnot, to make that loan valid or enforceable. So we're at about our 8 o'clock deadline, so I'm going to go back now and talk about something different, or talk about one of our entities. Now, under Article 6, Section 1G of the Constitution, which we looked at, and we'll look at again just real quickly, it said that right there, the council has the power to manage all economic affairs and enterprises of the reservation, including oil and gas, etc., in accordance with the terms of a charter to be issued by the Secretary of Interior. Now, as I pointed out, we had to vote on that charter to make it legal. And we did vote on it. And in 1936, the people back then adopted the charter. Now, the charter itself, which we just looked at, says that it's the vehicle through which the council is supposed to do all economic business of the tribe. So I know some of the folks here in the room have a little more knowledge about this, but a question that always comes up that I tried to answer a little bit in a couple of weeks ago for everybody was, well, what about the casino? And what about SAI? SAI is a separate entity that the council authorized to apply for and received a federal corporate charter. And it's through SAI that the casino was then built. And even though the tribe signs off and guarantees the loans are essentially given initially through the pledge of the assets of the casino. And so the SAI operates outside of this charter, has its own charter, and in theory operates under the rules of that charter, which the government issued to us. So the question always kind of becomes, well, what is SAI? And the best answer I can give people is it's still an entity of the tribe. It's just authorized by a separate charter than the one we have, which presents to me, and I have never argued it to anybody, but presents to me an interesting question. If the people had to vote to ratify and adopt this charter, why was there never a requirement to ratify and adopt the charter for SAI? Why was the council allowed to simply apply for and get a separate charter for SAI? I don't know the answer to that. What I would say once again is just that that's why we need to go forward and talk about change and talk about rules for doing those things from this point forward, to ensure that if that's going to happen, the people have a voice and have a right to at least be informed and participate and to have knowledge. What I learned by putting out the information that I did a couple of weeks ago is that, and I think most people here would agree, everybody that said anything to me about that has said, we'd never received any information before about the casino and how it's doing. But the people should have a right to know that. Now, we didn't get there, but we'll talk about next time. I've mentioned it several times before, that one of the important provisions of the charter is Section 9. It's under Section 9 of the charter that we, the people, are supposed to have a right to inspect the books of the tribe at any reasonable time. And over the years, I exercised that right, but it always depended on who the council was and whether someone on the council was willing to support that right to do that. And so if we have the right to do that for our other corporations, shouldn't have we had the right to do that for SAI? And even if it doesn't say that, shouldn't the council be willing to put that out? So that's why I put it out a couple of weeks ago, because I believe the people had a right to know that. So we're going to end there for tonight. George?
I'll say real quickly, the process the tribe used in regards to the creation
Said was in the Indian Reorganization Act, which allows a tribal government to create a federally for-profit charter. And so the tribe followed that process by the simple resolution, but the BIA said, here is the framework of how this can be created, so it's for profit. Now, the idea behind Said was to be an incubator to create businesses, not to manage them. The idea was to create one, move on, and explore, but not get bogged down, which I believe they are, and administrate. So you lost your mission of what the federally for-profit corporation was for, was to be an incubator, a vessel to create productive businesses and then move on. But somewhere, I don't know where lost in translation, that's where the tribe is the majority owner of the shares, is that they didn't move on, they got bogged down in the administration of some businesses, and then what happens to the potential of future businesses where they should have moved on. I just wanted to, so I've kind of was part of the process of helping approve that charter, but the whole theme back then was that it was going to be an incubator to create businesses and not to manage. And that's kind of been my little stuck in my craw, if you will, is that you've lost the overall mission of the Said Corporation is to be out there creating productive business for the tribe and not to manage it. Somewhere along the line, they proceeded to manage them, and they haven't created any more. Basically got stuck in the trenches, you know. So the direction
Was changed by the councils of what George is right. That's what Said was created for, was for profit and incubator, and to move on to other projects and allow businesses to start functioning in that manner. But the direction was changed by the councils. They asked the Said Corporation to take over the old bingo, what was losing $250,000 a year. And that's how they got into the casino business. And then they had a cable company that was going broke. And they asked Said Corporation to take over this company and try to make it survive. And that's where that direction sort of changed. One other comment, Joe. When we're looking at the charter, when the councils in the past, and even today, are violating the charter. You know, so it's really a document that, although it's there, just like anything, right? We have our Constitution, our bylaws, our policies that we have in place, the charter. Mortgaging property, we're supposed to have a vote on that. If they expend this for whatever. So we have no voice as people, as members of this tribe, to prevent any of this right now. But if we change our Constitution, it can be different. We can change it so that they don't have that all power to do everything.
And that's why I started by saying that, in my opinion, the charter is the least understood and the most ignored document of the three documents that we have. And it's the least relied on, the least talked about, and hardly anybody ever, in terms of the system, brings it up. Start with you, Lila.
Well, I didn't even know it existed, for starters, but as we're going through and trying to change the government part of this, couldn't part of us be working on trying to change the charter part so that when it went to the vote of the people, couldn't the people then vote on both?
And that's what we've been saying all along, is that as we do this, when people talk constitutional change, but we leave out this document, and if we're going to change the system, we need to talk about this. And maybe going back to George's example, maybe we need to start by repealing it all together and starting with a new corporate forum of some kind. But again, that's an issue that we can all talk about and we can have input on and take community input about and have a dialogue about. Like I said about the things I put out last time, that generated the most discussion because it was about businesses and that people didn't have that information before, that of anything I'd seen so far. Harold, did you have a final comment?
I was just wondering, like, Since this is my first meeting and I missed what you had previously talked about and oil, the oil business now, and like what you showed me up there, like every time we amend something, are we following from what has already been in place and not practiced? And so when we amend it, we go by that, like the SAI. All they really did was re-amended the charter that had been set in place for us, so it failed us. So, like, to redo this, I guess my question is that do we have the capability to really amend the Constitution so that it will benefit us? Or who is it going to really benefit when it comes down to saying, we don't want the tribe to have any decision on this. Where's the next power we go to? Who's going to be about the tribal power? And is this documentation that we're going to work on to best? Now, I understand that, you know, the United States Constitution's been in act for 350 years and it's still not perfect. And they have some of the so-called the best lawyers in the countries working on them. Where do we start then? I mean, where is it that are we gonna, I'm kind of wondering if...
Well, without having that whole discussion again, Harold, because we've had it just about every other meeting that we've had, the bottom line is we start with the people.
Okay.
And to me, we start by understanding why these documents don't quite work for us. And that we, again, going back real quickly, because like I said, I don't want to, we had that discussion last week for an hour and a half, and that we have always said...
I'm just trying to catch up.
We've always set a time frame for ourselves so we don't get bogged down. But what's going on like right now, down in Helena, just as a comparison, right?
Yeah.
The state, is meeting?
Okay.
State legislature. The state legislature is one branch of state government. So as opposed to, and then after the legislature meets, passes whatever laws, and in particular the budget, the governor, which is the executive branch, is going to become responsible for carrying out the laws and carrying out the budget. And if he don't do what he's supposed to do, or if any citizen decides that some law isn't authorized by the state constitution, they can go over here to this other branch called the judicial branch and actually bring a case and go all the way to the Supreme Court, and if they're right, the Supreme Court will strike that down, and the other two branches are bound by that. Here, we have but one branch, and that's what everybody's just been saying here, and both of these two gentlemen said in a different way. Because the one branch is the council and it's got all the power, it basically does whatever the hell it wants to do. And understanding that to me and to us is the first step in getting people to understand the need for change. So I guess going back to what George said, he said that he believed that under Section 5E of the Charter, that the Council had the power to engage in any business that would further the economic well-being of the tribe or undertake any activity of any nature not inconsistent with the law or this Charter, that was the basis that they thought they could go ahead with SAI and getting a separate charter for SAI. But they then said that SAI was supposed to have a limited purpose. And after it got started, it took on a life of its own and went far beyond that purpose. But the bottom line is that, as we talked last time, let's go back to, for those of who didn't come in, we don't have many copies, but you're welcome to them. One of the things that one of the people brought in tonight was a discussion that took place in 1934 on adopting our original Constitution. And the minutes of that discussion are here if you want to pick up a copy. But what's important about, the most important thing about that to me is that it took the people to do it, right? We had a council at that time. I identified them. But the council itself didn't get to just say, oh yeah, that's great, we're just going to do it. We did it, now that's what we're doing. They had to go to the people, and the people had to buy into it. And so that's the same process that we need to do if we want to address these issues that everybody has talked about, including the conflict that we've gone through. And how do you resolve that conflict? Where can you go to get justice at the end of the day? Where can you go if the council goes off the track on economic development? How do you call them to task? How do you hold them accountable? As we've talked many times, and I'm sure you did too in your sessions, you go to the council, and the council just kind of does what it wants to do, and not just this council, but every council at the end of the day did what it wanted to do. They said, we're the power. So, Wendy, you had a comment there.
Where do you think this is going to be before the terms are up? Do you think we're going to get this going? If people start getting on it?
Well,
Because, you know, like, I read your article about the store and the casino. And I don't even shop at, they say, our store. The prices are too high. I have to shop over here at Tipo's now. This guy's raising his prices.
I'll leave a few of these for these folks.
But I really hope, and you mentioned this earlier, we don't want this to hang for our next generation. You know, the council might say, yeah, we're all for it. As far as I'm concerned, I heard somebody say this before, is that that's all they're worried about, their checks and travel, and pass it on to the next council.
Well, to answer that kind of, Paul, we have kind of made a decision that hopefully by the end of this 4-year term we'll get to a vote on it. But we've tried not to set a deadline, because we want to try to give everybody a chance to have input and be involved. And if you start setting deadlines, then you put roadblocks up for yourself too, and you don't get to the point where you've reached out to the people. And like I said last week, hopefully we get to the point where the people are not, right now we're trying to pull people in. Hopefully we get to a point where the people are not just not being pulled, they're pushing. And then we get it done. But in my own view, and that's what I expressed, you were here earlier when we had the discussion based on George's suggestion about trying to find ways to get the people on the council to become committed. And that is by going out with another opinion vote, not a referendum, not a secretarial election, just an opinion vote. In your opinion, should the Constitution be reformed? Yes or no? And by doing that, you try to get the people more involved. And what I am doing, what we're doing here, is trying to get people educated in a way that they haven't been before by simply giving them information that they've never had before and allowing people to make their own decision, to make their own judgment. So I'm going to call it a night. It's 8:30. Thank you all for coming. We're going to be back here again next Tuesday night. The only thing that'll kind of Constitution and talked about the efforts and why they don't work. And at the end of the day, and I don't have it up here, and we've gone through this so many times, just about every meeting he new comes, says about the same thing. And we stop and tell them, well, you're right. The people, 2,322 people voted for separation of powers. And what happened was that the referendum language says the referendum is binding on the council. Did they carry it out? They didn't. They said, no, we're the council, you're dead. Constitutional reform is over. Our chairman at that time, I was just reading it again last night, put out a proclamation. The constitutional reform effort's done. They never met their deadline. It's dead. So that's why we're here, Jay, because it don't work. It don't work. We're here because we aren't waiting for the council to jump on board. This is the people's movement. You're welcome to be a part of it. This is the people's movement. You just sit and listen to us talk about how to get the people more involved, how to get to that point. So somebody was here 2 weeks ago, he's not here tonight, he said, well, the council don't approve it, it won't happen. I told him, read the rest of the clause on secretarial elections and amendments. It says if 30% of the people call for it, we don't need to go through the council. You can go right to the BIA and they'll call for it. So that's what we're doing, Jay. That's why all of us are here tonight, because we've all said, we've all agreed, we've all made that commitment that it don't work. One of the things we haven't done yet is haven't gotten to the point of saying this is what it's going to look like. That's not our call. That's the people's call. What's it going to look like? You have your view, other people have their view. They may say, no, I want it to look like this. My late cousin, Vicky Santana, just to challenge me, used to sometimes tell me, well, why do you keep talking about a constitution and 3 branches of government? Why can't it be a parliamentary government like they have in Canada? I said, gee, Vicky, I don't know. Let me think about that. And so we haven't even gotten to saying, what does it look like? A lot of work was done on a possible constitution. I've been asked about that, and I tell people, we haven't even got there yet. When we get there, we'll bring that document forward, we'll look at that, the people that advocate for it can present it, other ideas will be heard, and we'll talk them all over. But right now, what we're doing is we're talking amongst ourselves to educate ourselves as to why this document, the ones you just talked about, why they don't work. There's not a person in this room, in my opinion, that thinks they work, or they wouldn't be here. That's why we're all here, because it don't work. The other thing we've said to ourselves is that it would be nice, it would be really nice. I serve with them. A lot of them they're good people. If the council, the rest of them were here and showed up, I challenged them to do that in a meeting in October? Yeah, October, when Kerry came in and Darrell came in and talked about constitutional reform. And some of them said, oh, well, we think you should wait. And we told them, we're not waiting. And rather than just saying, well, we'll wait till you see what we bring us, show up and tell us what your ideas are. Be a part of the process. But we aren't going to wait for them to be a part of the process. Because in our view, the people have already spoken many times over. And it's time to do that. As I've said, the reason we're doing this, my own opinion, is that one of the mistakes of the last group was there was a deadline. Now, they extended that deadline, but we didn't reach enough people. Because if we'd have reached enough people when that council in July or August of 2010 voted and rescinded the resolution appointing the committee and said to the committee, you're dead, you're done, you got no authority, the people would have rose up and said, no, they're still there, we want them to be there. But there was no great outcry from the people because we didn't reach the people enough. That's what we've been talking about. How do you reach the people? How do you re-engage the people? Not just you or your group, not just this group here, every group out there, everybody. And so, kind of use that old saying, you're preaching to the choir. We've been preaching to ourselves already for more than 6 weeks because we met as a planning group before that to say, how do we do this? How do we get this going again? So that's what we're doing. You're welcome to be a part of it, and if not, as we just talked, as George said in his presentation, there may be some people that don't want anything to do with this. That's their right. That's everybody's right. We all have a right to either participate or not participate. We've talked about that. There are a lot of people who, they're not like us. They're not the kind to show up and take part. They sit at home and they read and they listen and they educate themselves But when the time comes, they'll vote to do the right thing in their mind. And those are the other kinds of people we want to reach. So that's why we're here tonight. That's why we've all been here for 6 weeks. This is there's 5 DVDs here. This is our 6th official week. We've actually met a couple times when there was just a few of us, so we didn't tape anything, we didn't go forward. We met before that as planning group. So that's what we're doing. That's why we're doing this, because we recognize the need to do it. And me, I've been here 3 different times. This is my 3rd time. Every one of those times I said this don't work. The first time I served, from 84 to 86, I presented amendments on the Constitution. We actually had a secretarial election. We lost. I learned then that one of the problems is you have to educate the people, because there's so much mistrust out there. I mean, there are people, let's be really blunt, there are people, I don't care who you are, they just don't agree with anything. We could walk outside and say, gee, it's a beautiful night, the stars are shining, the wind's gone down, it's about 40 degrees, and they'd say, oh no, look, there's still snow on the ground, and it's partly cloudy, and it's glum outside. And so that's just the nature of life. So if you want to be a part of us, you're more than welcome. We need everybody's voice. We need everybody to participate. Nobody is excluded. We've had different groups come. We had a whole group come last week, came together and took part together. We've had other people come and come and go. We had one couple that came to our first 4 sessions, They would be one of the first ones here. Now, they haven't been back for a couple of weeks, but they're both traditional people and Christian people. So we've had people from all walks of our life on the reservation. And my opinion is that's even represented here tonight. But that's why we're here, because the system don't work. You're not the first one to say it. You won't be the last one to say it. We all have been saying it. We all say it in different ways. But that's the bottom line. And the reason we're doing it this way is this is not Joe's thing. This is not Puggy's thing or Fish's thing or George's thing. This is all of our thing. And the reason we're doing it this way is just what we said about the council. You're right. If we waited for the council to endorse this, we might be dead. We might be waiting until we're all gone. Because that's one of the other problems, that the real problem with these documents that you didn't talk about is power. We got a one-branch system of government. The minute you get to sit in one of those seats up there, you got all the power of our nation. And once they do that, people are reluctant to give it up, no matter how much they say they might be. And so we can't wait for that. And we hope that one day they'll come forward. That's why we talked about having to go to the council to get a resolution to get the BIA money. Going to the council to get a resolution to approve just an opinion, reinforce to the people that we're going to do this. That's a way to get the council to buy back in, to show their support and their commitment. Do I wish that all 8 of them were here tonight? Absolutely I do. But as I said a couple of weeks ago, after one of our meetings, when another person came in and said, why are you doing this? It's going to die. It's just nothing's going to happen. The council's going to kill it. I ain't waiting for the council. I ain't waiting for them to endorse it. I ain't waiting for them to show up. I'm not waiting. We don't have forever. How old are you?
Me?
Yeah.
52.
We don't have forever, do we? We've been talking about this for me. I can go back to 74 when Charlie Connolly tried it the first time. Gee, that's been 40 years, and we still haven't got there. So I can't afford to wait. We're not waiting. Everybody in this room, look around at each other. We've had some young people. That's been really good. We've occasionally had young people show up. But look around you at who's in here. Harold told me just last week, he said, geez, ever since I've been a kid, they've been telling me, your generation's the next leaders, your generation's the next leaders. And here I am, and my children are in high school or getting there, and they're telling them, your generation's the next leaders. Of what? Of the same document. It's funny you should mention Mr. Oldperson, my friend. He's been sick, but I was visiting him today, and we were talking. And he brought it up, not me. He said, you know, he said, I remember growing up, I think he's thinking about the past. He said, I remember growing up, 1944. He said, we were up at camped in Greasewood, me and my dad and our family. He said, I don't remember what we were doing. But he said that one morning my dad got up. He said, I got to go to town. And he said, what for? He said, they're having that big meeting on Wheeler Howard. And he said, at the time I didn't understand how important it was that he was going in to take part in the Constitutional Convention that occurred in 1944. He said, for 4 days they met. And he said, I didn't understand that they were talking about whether to stay under this document or to change it or to just keep going the way it was. And I understand now how important that was. So everybody comes to that realization. And even our ancient elders, our old elders, our grandfathers and great-grandfathers understood the importance of that document. And as you said, correctly so, and I absolutely agree, I've said it myself. Back then, when there were only 4,000 or 5,000 of us, or 6,000, and life wasn't so complicated, and they had integrity, they made the system work. Not because it was the best vehicle in the world, but because they were committed to it. They made it work. But today, there's so many of us that it's no longer, doesn't fit us anymore. We just talked last week about part of the charter, where that section of the charter that even I have used against councils, that says that you can't, that no sale of any capital asset of the tribe exceeding $10,000 can be made without a referendum vote. Well, today that means you couldn't even trade in a vehicle. And we buy those big trucks for like forestry or fish and game or even law and order. Those are $30,000, $40,000 vehicles. You trade it in, it's still got a trade-off value of more than $10,000. Supposedly we'd have to have a referendum vote on every one of those things. And so you're right. One of the things we've talked about is right now, today, right now, and because I watched that myself, I'm a political junkie. The state legislature is meeting, and I emphasize that word, legislature, because it's their government. It's a three-branch form of government. All the power is not in one body. They don't get to sit there and make the law and hand out money to the Antelope Society and take a trip on their own and then call the police up and say, you go arrest Joe, or call a judge up and say, you better not rule against my cousin or you're fired. They don't get to do any of that stuff. So the state legislature is going to meet for 90 days, Georgia. They get a small daily per diem and a small daily pay. At the end of 90 days, they're done. The costs are over. They go home. The governor takes over, the executive branch. He carries out those laws. He carries out the budget that's been made. He's got those professional people that we're talking about. And so you don't have 9 heads trying to make one decision about who to hire today. He makes that on his own. 2 more years from now, we're going to hold him accountable for how good a job he did. He's going to want to get reelected. And we, the people, are going to be able to say, well, Steve Bullock, either you did a good job and we'll support you, or you didn't. It's time to give somebody else a chance. If they get into a fight over whether some law is legal or not, or somebody's violating the law, they go to some place called the Supreme Court, who are elected by the people, who have the independent right to declare what the law is. And then they all listen to them. They follow that law. The example I gave a couple of weeks ago was Rocky Boy. My friend Kenny Marks St. Blatt, or Kenny Blatt St. Marks, won 2 different elections to be the chairman of their tribe down there. Their people want him. He's won a couple of court cases, but he goes to the council, and the council says, nah, you ain't even sitting in your chair. You ain't taking office. We're the council. We got all the power. We don't care what the court said. Kenny still has yet to take office, even though he's won 2 different elections to be the chairman of that tribe. The other entity that we brought up and talked about is the BIA. This last 2 years that was the worst in the history of our tribe, where we melted down. Both sides at one point or the other ran to the BIA and said, come and save us. Come and straighten that other group out. No, you straighten them out. They're the ones that are wrong. The BIA said, no, that's an internal matter. You go fight it out for yourselves. We talked about how in our Constitution there are specific places that say the BIA is supposed to review this, or the BIA is actually supposed to approve this, but they don't do it no more. And we also talked about this is the 21st century. Are we really so such children that we have to have our father come and spank us and tell us what to do? Or shouldn't we be growing up enough to solve those ourselves? Again, going back to Rocky Boy. So Kenny finally went to the BIA. Secretary of Interior, the solicitors, issued an opinion about a month ago. It was in the newspaper, saying, yeah, we believe that the council violated the American Recovery Act. That's Obama's first law that he put in about rebuilding America, where he put out all these funds, because that pipeline, that water line's funded under the American Recovery Act. Then they said, and we believe that you violated the Whistleblowers Act, because Kenny was really turning some guys in for doing wrong, and you punished him for it. And they said to the council, so you reinstate him and give him your back pay, give him his back pay. What did the council say to him? Nah, go away, we're a sovereign nation, we'll do whatever we want to do. That's in our Constitution. So no, Jay, our system, it don't work. That's why we're all here, because we're committed to that notion that it don't work. And we have to have a better one.
And my statement is, to my so I understand, because everything that you say here and everything you do is I support everything here. I mean, when we had the ground building out there, and we had a meeting out there, we went over the same thing, the car charter and everything, we were trying to explain it to it, and it was like, these guys weren't comprehending it, what we were trying to read to them. And even some of them that gave it a handout, the ones that were educated understood it really thoroughly, and then they were throwing inputs out there. So I was kind of trying to go, are we taking a big step back? Or are we taking a little step back and then continue on? That's why basically I'm trying to, where we're at. I'm trying to find out, where we're taking a little step and going on? Are we taking this big giant step back and starting all over again? The same thing is when I was over in Missoula, we did this, we were told to stay away from it for a while, it's going to get worse. I had no notion this was going to happen, this last one. This is going to happen, and is this going to get worse? We were told spiritually, and sweats and stuff like that, this is going to happen, it's going to get worse. Well, I happened to go over, and Lana Burns was on there. Went in there, and Lana, I showed Lana this format. Lana says, you got it all right here. Okay, it's the power there. So by having that, showing her there, I'm sitting at my house, car pulls up, comes really sharp, pulling up and running around. He says, hey, I wanted to talk to you. He said, before I got into council, you were out in Star School, we had a talk on this tribal government structure. You have that format? And I said, yeah, come on in. Sat down, gave him coffee, we were sitting there, and he said, can I make it out in the hotel room? He went back to the hotel room, read it, came back into my house, we sat back down. He went over and he says, you know what you should get this patent. And I was like, ready to take my hat off. What do you mean get this patent? You know how much it costs to get this patent? You just need to implicate this right now. You got a Constitution committee going right now. You guys need to push this format into place. Lana Burns, I just showed it to her, and it was just like, to me, it was like, geez. And by watching what was on the website, because everybody's was reading on the website, everybody's following it. People all the way to Missoula that were Native Americans over there, people that were in Seattle that were following that format, they were looking back on what's happening now, what's going on now, what's going on, are they going to go into the change of this? I'm 100% behind you, because I'll stand behind those people that are standing up. I mean, evidently you're leading the charge here, and my whole thing is, I can get that building out there and start educating those people in Heartbeat that are willing to come.
Well, we're about ready to come out there. That's we are educating ourselves so that when we go out there, it's not just a Joe show. everybody will be able to do something and take part. So I'm glad you used that word charge. Are we taking a step back, Jay? No, we're not stepping back at all. I was in the Army, and an old guy, old colonel used to tell me there's no such thing as retreating. We're just charging in a different direction. So we're just charging in a different direction. We're not taking a step back from anything. And if we're taking the attitude that we're stepping up and going to step forward. We just don't need the sanction of this group anymore. That's our position. And one day, so that the guy asked, well, what happens if they don't? That's like I said. So we'll hope that by then we've reached enough people so that we then, if the council says, if we get to the point where we got a document that we think people will accept, and the people have indicated they would accept it, we bring it in here, and whoever's sitting in them chairs say, no, we don't like it, go change this or go change that. What we'll do is go out to the people and get 30% of the signatures of the eligible voters and head down to the BIA and say, here, we want to vote, and we won't even come back here. Their choice will be to take part or get pushed aside. The person then says, well, what if you do that? The council won't accept that. And I laughed and told him, well, then I guess there'll be 9 people with their own little government with nothing to govern and no authority, because the people will have formed their own government and we'll move on without them. So that's the other issue, Jay, is that's why the other reason we're doing this is that we don't want to get to the point where I'm sure Puggy feels like he could just sit down with that other document, finish some things and put it out, but then people would say, oh, that's Puggy's Constitution. I could sit down and write a document and people would say, oh, that's Joe's Constitution. That's Jay's Constitution. It's not our Constitution. And at the end of the day, that's what we want, is the people's Constitution, and not our Constitution, the people's Constitution. Because what's really important about that to me, and that's what I've said about this document, we've amended our Constitution 11 times since 1935. 9 of those amendments have been on nothing but the election process, the number of council people. Nothing substantive, nothing. We amended it to include the plan of operations, and we amended it to change the voting age. We've done nothing to change the power of the council, how the council governs the people, separation of powers, checks and balances, none of those things. And so my own view, part of my own personal opinion, is that the reason councils think at the end that they don't have to follow this document is it's not our document. That's how they justify it. We didn't write it. And it's true. As I explained from the beginning, this document, the basic document adopted in 1935, was one of 4 boilerplate constitutions circulated in Indian country, written by 4 bright young lawyers that worked for John Collier. And that's where Indian constitutions originally came from. And we just picked one of them, made a few changes, and went forward. We had the big convention. They thought about, should we revoke it? But they chose to continue to follow it. And that's why we had to live under it for another 60, 70 years since 1944. But that's what we agree. It's time to move on. It's time to change. And if we leave it to the council to do that, my own view is it will never get there. We, the people, have to take the lead to do that. So as I've said, almost every time we're here, it comes up from somebody new. I'm not here as Joe, the council member. I'm here as Joe, citizen of the Blackfeet Nation, and wanting something better for my people. As someone just said here a few minutes ago, gee, George, my grandchildren are 4 years old now, and pretty soon, it ain't going to be long. Time flies fast. Gee, I remember, it wasn't that long ago, I was a young man, had long hair, and a lot more than I got right now. Time flies fast. Those kids will be adults, and they'll still be living under the same document, saying these same things to each other, unless we step up and bite the bullet and take the lead and go do it. So we aren't even to the point, in my view, of saying, this is what it's going to look like. Some of us have some ideas, some maybe don't. But we aren't there yet, because what we're trying to do first is reinforce that notion with people so that instead of just saying, let's be real honest, of those 2,322 people who voted for change, if we could honestly poll every one of them and they told us the truth, I would be willing to bet that less than 20% of them had ever actually read this document and knew why it didn't work. So what we're trying to do is educate people about why it doesn't work, in the hopes that as we move forward, like I like to try to say about things, we've given ourselves the best possible chance at succeeding. When people finally really understand why this don't work, then in my own view, they'll be more willing to say, yeah, I want change. And I may not understand that completely, but it looks a heck of a lot better than the one we got now, so I'll take a chance. Let's do it. And at least we give them that chance to be educated and then to have input into what it looks like. And as we get down that road, and we've all talked, it's very important to hold public meetings, to even have a door-to-door effort, where maybe we try to develop a sheet, a handout, where people could kind of fill in the blanks. Do you want to see something like this? Do you want to see something like this? So we can get people's feedback and make them feel like they had some input, that maybe something they checked will show up in the Constitution, and they can go, yeah, gee, I did that one. I checked that one. I supported that one. So that again, we've laid a foundation, huh? That's what this is all about. Right now, our foundation is like a house of cards. Every time we change one of those cards, the house changes, and it gets more rickety. So what we're trying to do is lay a solid foundation for making a final change. And yeah, I guess the only time frame we have, and it's my personal time frame, is right now I got 3.5 years left in my term. I'd like to see us be able to come to some vote in the 3.5 years. That's the only time frame. So that's the other thing we're trying to do in a sense that, I say jokingly to white folks sometimes when they tell me something about being somewhere or something's going to start, I tell them, is that real time or IT time? And they say, what do you mean? And I said, well, real time is, are we going to start at 6 o'clock or are we going to start on Indian time? And my cousin friend Ray says, yeah, Indian time is whenever we get ready to do it. And so hopefully we're going to be ready to do this within 3.5 years. That's our goal, is to bring it to a vote. And we've heard us talk about the efforts we're going to make. Now, this is not just our effort, and we're trying to reach out to educate people. I would love nothing better than to see this room so full that there was standing room only, and that we had to kind of like even draw cards to talk because not everybody could talk and whatnot. I hope one day we'll get there, but until we do, then we're the people that have made a commitment. There's been other people that have come, and I'm sure that will come back and take part, but this is where we're at. We're ready to do it. We're not going to stop. That's why until you heard me announce that we got some money from the BIA, until we get that money, everything you see here, that food, these discs, Roland and that video recorder, those spots you hear on the radio, that's all come out of our own pockets. Nobody's paid for that. Tribe doesn't pay for that. We pay for that because that's our commitment to do this. And nobody in this room is what I would call rich. They're just committed. And so they're willing to pull a few extra dollars out of their pocket and help buy these CDs or help pay for it. Now we've already paid for, and we just got to kind of make sure in our CDs that we haven't said anything bad about anybody, and we're not going to get the TV station sued. But we've already paid to have these run on the TV station.
Yeah,
and so...
Talking to you about
Pardon?
I said, I went down and I talked to David, because we had these videos out there, because right now what I have is an amateur video production company. What I do is I edit and put everything together. I can put all this together with the voice on counter that.
That's, everybody needs to help. We're anybody that can help.
One thing I wanted to comment, what you were talking about, was that reserve powers and executive powers. And I wanted to comment on that, executive powers. And we went over the Constitution and Charter and everything. We looked at the executive powers, and we showed that down the road, the executive powers are going to be shown, and you've seen what the executive powers, how much they gained this last council. The reserve powers, I looked at the reserve powers looked at the people. And I don't know, Joe, if you ever read the Kickapoo tribe, what happened to the Kickapoo tribe. In the Kickapoo tribe, they went in there, and this is what I'm talking about, the reserve powers. The Kickapoo tribe went in, and they had a disagreement with their tribal council. The tribal council was basically trying to run everything their way. They were telling them, no, this is the way we're going to run it. The Kickapoo tribe, and that's why I said this is the worst enemy is us right now, because they were able to get 80% of their members stand behind. And they went to the tribal office one morning, early morning. You can pull this up. They went one morning, the Kickapoo tribe went there. 80% of the people are standing in front of the tribal office. They were all standing out front. Here come the tribal council members. They come rolling in. Like, oh, so what's going on here? The people are all here early. They're all standing here already going. They come to the deal, and they had a spokesperson standing there. The person goes, what's going on? They said, by the way, you guys are all fired. Bullshit, we were elected. We were put in this position. You guys elected us. You all put us, well, we just fired you all. No, you guys elected us. We're the council. We have the say. You can't do that. We have the tribal police. Well, the tribal police, one of the elders went there and said, remember, you work for the people. So they had the tribal police sitting on this side in front of the people. And then on the other side here, the tribe, the tribal council, when they called Bureau of Indian Affairs, the Bureau of Indian Affairs came back and they stood on the side of the tribal council. And the BIA tactical teams, they had a standoff there. BIA and tribal police are there to protect the people. When it all got into negotiation, the BIA had to back the people because that was their final word, is that this is what the people wanted. So the Bureau says, I can't back the tribal council, you 9 members, we have to go with what the people wanted. So it's already shown existence that we have the power. We can gain the power of the people to stand behind what we're doing here. For every one of us that we walk out of here, if we can grab 10 people and 10 people behind them grab 10 people, this is going to grow bigger and bigger.
So,
but if we don't keep grabbing people, because that was our downfall in the past. We didn't grab people, we were trying to grab people. Right? What we got was a lot of criticism, because over here, we come to tribal offices, you guys can't speak. If you speak up, you're going to be fired from your job. I went up to Bureau of Indian Affairs and I spoke with some of those people. How come you guys don't stand up? Well, the tribe don't leave nothing for us anyways. They got bureau jobs. I said, geez. Start going around and I started doing my own little survey of people out here. How come you guys don't get involved? How come you guys don't come and get involved? Just asking people that were workers, people that were educators, and there's just a variety of different things out there that people were saying why they don't get involved. They all had a reason why they didn't get involved, but their whole complaint was, the system don't work. These guys don't work for us. You know, they're all bitches, but nobody wanted to do anything. So like I said, Joe, I can offer my services, what we can do in our production, we can get this cut down and we can get explanations to everything and get these videos out there.
well, we welcome everybody's contribution. 2 final comments about your comments. We have, Jay, we've covered, as I said, every section of the Constitution. We've talked about the reserve powers and that those lie in the people. But one of the other things we've also talked about is if you read the Constitution, the Charter, and the Plan of Operations, there's no such thing as executive action. It doesn't exist. That's something that the council's made up on their own as part of this grab for power. It doesn't exist. There's no such phrase in the Constitution, Charter, or Plan of Operation as an executive action. That's something that council has just made up to have the power, because they wanted to shut this person out or shut that person out, or they didn't want to have to listen to somebody criticize them. No, let's just do it by executive action. There's no such phrase in our documents, none whatsoever. And again, that's why we have to change them. So, but I want you to know that For those of us that have been coming all the time, one of the commitments we made to ourselves is, because everybody has a life, is that we would start at 6 and try to end about 8 o'clock, just to give everybody a chance to go home and be with their families and get their other things done. So with that in mind, it's already 7:30. We, in the last 6 weeks, have gone through the entire Constitution, the entire plan of operations, and we started through the Charter. And where we're at was on Section 6 of the Blackfeet Charter. And one of the things I pointed out, that again most of everybody knows, is this Charter is probably the least relied upon, least understood of our 3 organic documents. You sit with the council, you won't hardly ever hear anybody say, well, wait now, we better check the Charter and see if it allows us to do that. Or we better check the Charter and see what the terms of the Charter says. So we've gone through the first 5 sections of the Charter. And where we're at is a section on termination of supervisory powers. And what that's talking about is, just like in the Constitution, where there's articles in the Constitution, for example, the ability to levy taxes, or whatever we would call them, regulate and license business activities and levy assessments, it says subject to the approval of the Secretary of Interior. That's supervisory powers. Similarly, the Charter has language like that says the Council could only do things subject to the approval of the Secretary of Interior. So this section of the Charter talks about how to terminate that authority, how to kind of take another step towards self-government, if you will, instead of having to run back and say, oh, Father, check me out, make sure we're doing all right, and if we're not, stop us. This is another way of moving forward. It says, upon the request of the Tribal Council for termination of any supervisory power mentioned in sections 5B, 2, 5F, 5G, 5.8, and Section 8 of the Charter, the Secretary, if he deems it wise and expedient to do so, in other words, if Father thinks it's okay, shall approve such termination and submit it to a ratification vote by the tribe. So in other words, there's 3 steps. First, the council will have to say, we want you to end your supervision. The secretary has to say, okay, all right, I'll let you do that. I think that's a good idea. And then he would have to put it to a vote by the people. Shall be effective upon ratification by a majority vote at an election at least 30% of the adult members residing on the reservation shall vote. George and Fish have both pointed out over time that that's different than the language that they follow on an amendment or referendum, or rather a secretarial election, where they basically let every tribal member, even those living off the reservation, get to vote in a secretarial election. In this kind of an election, only if you live on the reservation can you vote. It says, if at any time after 10 years from the effective date of this charter, such request shall be made, and the secretary shall disapprove such termination, or failure to approve or disapprove it within 90 days, it may be then submitted by the secretary or by the tribal council to popular referendum vote to the adult members actually living on the reservation. And if 2/3 of the eligible voters vote approved by 2/3 of the eligible voters, it shall be effective. So let's look at how that changed. The first one says if the tribal council requests it, and this was within 10 years of its passage, and the secretary allows it, then only 30% of the members need to vote, and only half need to approve it. After 10 years, which is we're long after 10 years, in order to approve the termination of secretarial review, 2/3 or 66 2/3% of the people have to vote in favor of that termination. Again, to me, that was another way of maintaining that big brother notion that you're not going to be far enough along. We still have to have final judgment. You know, it's like us not letting our kids grow up, huh? The 25-year-old comes in and says, I want to get married. And I'm going to say, well, you better bring your husband or your future wife to me. I need to approve it first or you can't get married. So this is kind of that mentality. Next one was
So,
corporate.
like right there, that seems to be like a trust issue, because the people aren't going to trust the council anyway.
Well, and that's the way it's turned out, isn't it? It's a trust issue.
Yeah.
But really it was more of a paternalism issue. In other words, the Constitution, those documents were rooted in that policy of paternalism by the federal government. We have to take care of you poor Indians. And it's like that sign, you see that sign that we just put up out there about coming into Browning? Gertie probably knows this better than I do, but Browning was called Itun Yupi. And people said, well, that means Browning. Well, no, it doesn't. It means where our father lives, because that's what they called the agent, our father. And that's that paternalistic notion that the government's got to take care of us. We got to look to the government to tell us what's good and bad and steer us in the right direction, instead of recognizing it. Like a bunch of the people in this room got college degrees, work in educational institutions. Many of the rest of you have worked at jobs for a long time in the real world. Do we really need someone else telling us what's right and wrong? Isn't the essence of self-government that we make those rules and tell ourselves and then hold ourselves accountable? But you're right, it's come down to trust. And that whole, another reason why we're doing this is because if we were to take I was just watching an interview yesterday on 60 Minutes where they interviewed the Republican leader in the House and the Republican leader of the Senate. And the interviewer said, well, they were criticizing the president, and he said, well, gee, the president's rating is about, I think, 48%. That's pretty high. It's not the best, but it's pretty high. And they continued to run him down, and then finally the interviewer said, well, let's be honest, the approval rating of Congress is only 15%. And so if we took a poll right now today, if our poll question was not reform, but do you trust the tribal council, I'm willing to bet that we'd get similar results. Huh? We wouldn't get a very overwhelming vote in favor of just the council notion. And it's not, in my own view, it's not really at that point, it wouldn't be about do I trust Joe or whoever's sitting there. It'd be the notion of of how this system works, and people would say, no, I don't trust that system. So that's what I think that was about. So corporate property. Now remember we talked about the charter was the government's attempt to create kind of these semi-corporate entities through which tribes were supposed to do all of their business activity. And like corporations of the time, they were supposed to have shares and shareholders and whatnot. So this is corporate property. No rights of the tribe heretofore constituted shall be in any way impaired by anything contained in this charter, and the tribal ownership of unallotted lands, whether or not assigned to use of any particular individuals, is hereby expressly recognized. In other words, the tribe's ownership of its own property remains intact. The individually owned property of members of the tribe shall not be subject to any corporate debts or liabilities without the owner's consent. Tribe can't pledge your property for a loan or whatever. Any existing lawful debts of the tribe shall continue in force except as such debts may be satisfied or canceled pursuant to the law. That just meant whatever debts the tribe owes then, they continue to owe unless they pay them off. Corporate dividends. The tribe may issue to each of its members a non-transferable certificate of membership evidencing an equal share of each member in the assets of the tribe, and may distribute per capita among the recognized members of the tribe the net income of corporate activities, including proceeds of leases of tribal assets, including oil royalties, over and above sums necessary to defray corporate obligations to members of the tribe or any other person, and over and above all sums which may be devoted to the establishment of a reserve fund and other expenses incurred by the tribe for corporate purposes. Let me kind of go backwards on that. The late Charlie Conley, who was, in my view, a real good manager in terms of money and looking out for interests of the tribe, used to say that the council, based on that, second to the last clause, sentence there, devoted to the establishment of a reserve fund. He used to say the council had an obligation to establish a reserve fund, an excess, that rainy day fund in case something happened. We haven't had a reserve fund for a long time. We spent every dime that comes in and more so, and that's why we're in trouble financially today. Otherwise, this is that section that basically says the tribal council can use its money, the tribe's money, to pay a per capita payment. And notice that the main thing mentioned there was oil royalties. That was when oil first was being developed on the reservation. We've never made it rich, but if you read in history back to that time, one of the things they used to tell the councils was, you guys are going to be the Osages of the North. You're going to be oil rich. The Osage Oklahoma people who they first hit the big oil strikes on, and they did become wealthy. We never did get there, but that's what the belief was. I can remember, and I bet a lot of the folks in this room, when I was a little guy, right before 4th of July, we'd get what was known as an oil check. Remember that, huh, Gertie? We'd get an oil check. Gee, all the kids would get lined up and taken down to Fox. Got a pair of boots and a pair of Wranglers and a new cowboy shirt if you were a guy. I don't know what the girls got, but that was our oil check. And so that was even what they called it. We got your oil check. Come on, it's time, oil money. It's time to go shopping. So that's the provision that allows for the distribution of tribal money per capita. Now, let's just for a second, just think about it. We could have a debate probably that go for a couple of days on whether that's right or wrong. But if you're trying to build a reserve fund and you're trying to put aside money to maybe create employment through other businesses, is it always a good idea to pay all that money out per capita? That's the philosophical issue which divides people. Some people say, no, you should pay it out, we deserve it. Other people would say, no, well, how can you ever create jobs, or how can you ever do new businesses if you don't put some of that money aside? And so that's a philosophical debate that our people need to face going forward. We just got our 2012 audit. I was reviewing it. Remember that one of the things that happened in 2012 was that we got our share of the Cabell money. I helped start that lawsuit for the tribe, where we sued over mismanagement of the tribe's income. $19 million. Just stop and think. What could we have done in terms of creating business or buying back land or whatever with $19 million? You know, in business, there's kind of a general rule. If you went to a bank and wanted to borrow money, if you could come up with a third of the amount of that loan, let's say you wanted to borrow $21 million. If you could come up with $7 million, you have a good chance of getting that loan, a third of the equity. If you had $19 million, you take that 3 times, that's $57 million we might have been able to leverage that into and put it into business and activities. What we did was pay out $14.5 million in per capita payments. What do we have to show for that? How long did it last for individual people? I'll be honest, I've been there for some, I've sat with those people, I help them every day. For some people, the $800 that represented individually, that might be more money than they got in a couple of months, huh?
Yeah.
So that's the trade-off. It's a philosophical trade-off. Do you take that money and try to create jobs and give that person an income for life, or do you give them $800 that's gone in a few months?
So they've never showed the people like a plan of what they're going to do with that money, so that's why they're so reluctant to.
I agree, and that's why I put that stuff out that I do, so that people can make those judgments. Sherry?
Well, and that is, a trust issue, because they think, the council's just gonna spend it anyway.
Yeah.
So, and if you didn't hear her, and for the people watching, what Sherry said is that's a trust issue. People figure, well, if we let the council hold it, they're just going to waste it anyway, and we ain't going to get nothing out of it, so they might as well pay it out to us.
Yeah, that's really what the
So that's a philosophical issue that we have to deal with going forward, and where that comes out is for every person to decide.
You will probably be facing that again, providing if the water compact ever goes through. There's a pot of money there that in the compact that's going to have exclusive ownership of what to do with it by the council. It doesn't say by the people there, and the water compact, when they got it there, one of the questions we asked them, why? Well, because, they're the ruling body, so they must know best. So there's about 24 million or something like that.
About that. It's not the whole amount, yeah. But that's a whole nother discussion. I don't want to get into that. We could debate that one for a couple of days, too.
But that's what I mean, though, is that they have control of all.
Let's do Puggy, and then we'll go Jay.
And we should note up there that it says net income.
Yes.
And when we get it per capita sometimes, they borrow, and put us further in debt. So it's
Well,
not income.
that's true. So let's be honest about that. Up until the distribution money, the Cabell money, every per capita payment for about 5 years before that was paid by borrowing money. So that council that paid it out, they really weren't paying it themselves. The burden was coming on the next council who had to pay back that loan. Then it just went on and on and on, and that's how we got per capita payments, is that the council borrowed that money. So net income for real simple business purposes, that's income you got left after you paid all your expenses, paid your debts, all of those things. That's what I got left at the end. That's my net income. So we really aren't even distributing net income at that point. We're distributing more like a pile of the gross income, the income that you get before you paid for any of the costs. Go ahead, Jay.
Well, it's a comment on that pre-capital payment being a council political coin, because that was when they came out, they said, well, that last council only gave us $50, this council gave us $100.
That's a good point, because let's be really honest. This is something Earl Operson says. No council has ever got reelected by paying per capita payments. Never got anybody reelected for the reasons she mentioned. Ultimately, it comes down to trust, and the people judge you on how good a job you did, not how much money you paid out. So that's the issue there. Let's keep going. Any distribution in any 1 year amounting to a cash payment of $100 or more, or amounting to a distribution of 1/2 of the accrued surplus, shall not be made without the approval of the Secretary of Interior. Now that's one of those places where the government just kind of goes, we don't even care anymore. The only thing they get involved in is if we have to draw down that money from our so-called trust money, our TAMS, Trust Asset Management account. That's the only thing, the reason they approve it. But in terms of the amount, they didn't try to veto anything. That's one of the places where, again, some people might be saying, well, gee, the government should have stepped in and approved that, but they don't do that. So the government picks and chooses where it wants to play a role. It doesn't play a consistent role. Corporate accounts. This is, to me, one of the most important parts of all of our governing documents. But again, because it's in that charter, It's one of those we pay the least attention to because it's one of the only ones that gives us, the people, ability to hold the council accountable. That so-called checks and balances. Corporate accounts. The officers of the tribe shall maintain accurate and complete public accounts of the financial affairs of the tribe, which shall clearly show all credits, debts, pledges, and assignments, and shall furnish an annual balance sheet and report of the financial affairs of the tribe to the Commissioner of Indian Affairs. The tribal council shall elect from within or without their number a treasurer of the tribe, who under their control and direction shall be the custodian of all monies which come under the jurisdiction and control of the council. He shall pay out money in accordance with the orders and resolutions of the council, and no disbursement shall be made without the signature or approval of the treasurer. So just stopping right there, kind of the treasurer in a way is given some authority, some kind of veto power to say, you know, just like over your checkbook when you're trying to write a bad check and your spouse steps in and says, wait now, we don't have that money, we didn't have that money, or we can't commit that money. So the treasurer in theory has that authority, subject to the risk of losing their job. They say no to the council might say, well, you're done, we'll go get Joe to be our treasurer, he'll sign anything we want. It goes on to say the treasurer shall keep accounts of all receipts and disbursements, and shall make regular written reports of the same to the tribal council at each regular and special meeting. He shall be bonded in such amount as the council shall approve by resolution, shall provide such bond to be approved by the Commissioner of Indian Affairs. Here's the most important part to me. The books of the treasurer shall be audited at the direction of the council or the Commissioner of Indian Affairs, and shall be open to inspection by members of the tribe or duly authorized representatives of the government at all reasonable times. In other words, any one of us, in theory, tomorrow, can get up and show up over here in the treasurer's office and say, I want to see, for example, how much travel the council spent. I want to see this, or I want to see that. And in theory, they have a duty to show that to us. But that hasn't worked in practice, has it? You know, I always give him credit for it. We've had our share of disagreements over the years, but one time when I was concerned about a particular way the council spent money, I went to the council and said, I want to see how much you spent on that deal. And most of the council said, no, you can't. Leland Grounds was the treasurer. He was on the council. I went to Leland and I said, Leland, let's be honest. You're one of the ones that always talks about these documents. Here's what it says. I'd like to see that. And he looked at me and he said, you're right, Joe. You're right. He said, but here's what I'm going to do. Rather than have you just going over there and rummaging around, you submit a request for what you want. I'll make sure they pull that request, and you can go in there and look at it and copy it and do whatever you want with it. And he did. He honored that commitment. So I was able to go in there and find out that the council spent $750,000 on a particular supposed deal that never did work out. They eventually went to the government, and the government went after the guy. They scammed him out of it and got part of our money back. But in theory, that's how we are able to hold our council accountable. Now, councils from time to time, some have been better than others in just putting out that financial information. But still, depends on who you are. If you go over there and say, I want to see this, chances the first time you're going to go do it, they're going to tell you, no, you can't see that. It's private, or it's confidential. Or here's the best one. It's covered by HIPAA. It's private. HIPAA only applies to health records, not the financial records. Oh, it's covered by HIPAA.
Why they put the language about the bond? Requirements of bonding, and the bonding is like the insurance, so.
Yeah. So as George was just alluding to, he asked about the bonding section there. Now, back then, when it was more prevalent, making someone get a bond was a way of protecting the tribe. In other words, if the treasurer then tried to steal money by writing hot checks to themselves or their family, and they got caught, that bond would cover the amount that they had misused. Bonding today is really something that has kind of gone out of practice. What's been substituted today for bonding is what we call directors and officers liability insurance. It's a substitution for bonding. This covers the same thing. If the treasurer steals money and violates their duty, then they're covered under that directors and officers liability insurance, and the tribe can recover from that insurance rather than having a bond. More importantly, and as a practical matter, because the tribe's finances have been so messed up in the last 10 years even, nobody would actually issue a bond, because the bond at an event is not to the person but covers the tribe as a tribe. No one would issue a bond to the tribe. I mean, there's a difference again between what we call performance bonds on like construction contracts and this kind of a bond. Tribe could get if we contracted a construction job from the BIA or from the IHS, we could get a performance bond, but we couldn't get one of these kinds of bonds. So that's why we buy directors and officers liability insurance. So, and just so you know, that is in place right now today and covers the tribe, covers the treasurer and whatnot. The tribe's not hanging out on a limb if something goes wrong. So that was the purpose for that. And again, remember, this is written in 1934. So we're talking about corporate America of 1934, before insurance grew as such a major part of corporate and business activity. So insurance generally has covered that gap. So let's see if we can finish up on the charter tonight, because after that we can start talking about getting out and where a bigger plan. Amendments. This is the one George did a presentation on to us a few weeks back. The charter shall not be revoked or surrendered except by act of Congress. In other words, we can't get rid of it altogether unless we have a bill in front of Congress and Congress approves it. But amendments may be proposed by resolution of the Council, which if approved by the Secretary, to be effective, shall be ratified by a majority of vote of the adult members living on the reservation at a popular referendum in which at least 30% of the people vote. So if we want to just amend the charter, the Council can propose that. Notice it doesn't include a provision for the people to propose amendments, just the Council. And if the Council does and the Secretary approves it, we'd have a referendum vote. To be valid, 30% of the people would have to actually vote, and then half of those that voted would have to be in favor of that amendment. But if we just said, look, the charter don't work, which we might do, we might get there, and we just want to revoke it and start over, then we're going to have to do what the Miami tribe of Oklahoma did, and we'd have to write a bill, get our congressman to sponsor it, saying we hereby revoke the charter issued to the Blackfeet tribe of the Blackfeet Indian Reservation. That charter is revoked in order for it to be legal. So again, these are, to me, part of that paternalistic attitude, mentality of the 1930s, that we're still little children who have to be managed and have to be told what's right or wrong, and grandfather has to be there in case we make mistakes to catch us and pick us up and make sure we get back on the right road. So, but, you know, it may well be that we might decide as a group, as a people, that the charter, while it has good intention, just doesn't work for us today, and that we need to revoke it and make our own business thing, separate business out from government, and have a different way of running business. And just like Jay and others before him have alluded to have professional business people running business. So that was something we talked about a little bit last week. 2 weeks ago, there was an article in the paper. The gentleman said, well, we don't really need to change anything in the Constitution. We just need to do two things. We need to hire 2 people, a tribal manager to kind of like run the government, and a tribal business manager to run our businesses. Well, if it were that simple, we'd have done that a long time ago. You mentioned Tom Thompson. I was just reading some literature of his from 1994 where he proposed that. What happens? Well, that person's, and we've tried that. Then Elma was naming some of the people over the years: Elvin Pollock, Dan Dockstetter, Patty Barnes. And what happens is either they start doing things and the people they're affecting get mad about it. They run to the council privately. Oh, we don't like that Joe. He don't know what he's doing. He's doing this and he's doing that. And oh, by the way, I voted for you. And if you want to get back in next time, then gee, get rid of him. So pretty soon Joe's down the road. Or the next council just comes in and goes, well, what's your job? Well, I'm the tribal manager. Well, no, you're not. We're the council. We'll manage the tribe. Here's your walk-in papers. We'll see you. You're gone. So until we change these documents to put those in place in a legal way that they can't, to have a president, to have a governor, have like, up north they call them chief, but they're really the elected leader. They serve a political term, just like a governor or just like the president. But they're elected separately by the people. They're not the chairman of the Tribal Business Council. They're the chairman or the governor, the president of the tribe, because that's what they run for. And so that's why, again, we need to change these things, why we need to do something different.
Ask a question on that.
So
Now, those people that you just mentioned, were they appointed, when they were managers and that, by resolution and amended? Did the Constitution was ever done that way, or were they just appointed?
they were just appointed.
They were never amended or read by
No. Constitution was never changed. Councils just kind of went, we have authority to manage the affairs in a business-like manner. We think that'd be a good idea. Let's hire Buster to be our manager. And they hired Buster. And someone else come along and said, well, gee, Buster, no, we don't. We'll do it ourselves. Here, you're going. Actually, I think Dan Dockstetter was after Buster, wasn't he? They had a white guy named Dan Dockstetter. And he used to go around. He was a business guy. He meant business. But when you're doing business in an entity like ours, you step on people's toes, don't you? And so Dan didn't last really long before the people decided, the employees decided, well, Dan needs to go. And then the last one we had was a woman by the name of Patty Barnes. And the council that hired her decided that she just wasn't working, and they let her go. But no, there was no amendment that said this is the way it's going to be. So the last part there is just how we ratified the charter and just said it will be effective, and we know we've already done that. Charter was ratified, issued on July 18, 1936. The vote to approve it was held on August 15th. 737 people voted for, 301 voted against, and so the charter was adopted back in 1936. Now that document, while we've amended our Constitution 11 times, we've never amended this document. So again, it's an aged document that no longer meets the purposes of our time.
So that's it, we didn't change that
No.
And the reason the land tribe went through the whole process to do that is because of their businesses that they were getting into. The document was old and it was preventing them from doing the economic development that they wanted to, because they had some of the same was just no longer feasible people to use that as a economic tool, huh? And so you had your membership, so they just did away with it, and they're proceeding on because their business part is part of their government there. It's no longer their charter, so that's what they did. They petitioned it, and it was more, it just was not conducive to where they were going economically.
So what George is talking about is that last week we had a discussion about SAI, which is a separately, it's organized under Section 17 of the Indian Reorganization Act as a separate chartered entity. Well, I was posing the question to the group of, well, where did that authority come from? And there's a provision in the charter that says that the tribe can engage in any business that will further the economic well-being of the members or undertake any activity of any nature whatsoever not inconsistent with the law or provisions of this charter. And that the council's kind of relied on that and said, well, so let's create SAI, a separate chartered entity. And then a couple of the people that were there at the time spoke to that and said, well, the truth is, maybe in their opinion, SAI has kind of drifted away from its original purposes of just being a business starter and has become a business manager. And so, again, that's just all the reasons. Those are the reasons why our documents don't work. We're not living in 1935. We loved our elders. I've many times have pointed to the men on these walls and women and said they did their best to lead us in their time. This is our time, and it's our obligation to do our best for our children and our grandchildren, and to recognize that these documents don't work for us anymore. Not in a bad way. We don't have to be mean about it or criticize them. Times have changed. The U.S. Constitution has been amended a number of times because we outgrew it. Times changed, issues changed, needs changed, and that's where we're at today. And so the next time we come together next week, we'll start talking about more about strategy. For those of you who come for the first time, who haven't seen everything, pick up one of these. Anybody else who knows anybody who you want to see some of this, take one or two of these copies with you and hand them out. That's one of the ways that we get things distributed. And as we talked, we'll be posting these on the TV station and whatnot. So, I know my boss back there kind of told me one day, you got to really be committed to taking part, because it's kind of dry material. So I'm glad, I appreciate all of you who have sat through all 6 sessions of my dry presentation of our Constitution and Charter, and I thank you, 7, and I thank you for it. And now it's time to go out and start passing on what we've covered to those in the community and teaching them. Jay?
Now that 1,038 that voted for it, was that a legal vote at that time? Was there only about 1,000 people at that one time?
Well, that would have been at least, again, remember the measurement is it had to be a third of the people eligible to vote had to vote. So that was at least a third of the people eligible to vote. Yeah.
There may have been like 3,000 people.
And not all of them may have been of voting age.
Okay.
So, again, thank you all for coming and being patient and listening and learning.
Talking about strategy.